to second and third generation Chagosians, despite some of them migrating to the UK with their British parents as very young children, is nothing short of a scandal. And I hope honourable members on both sides of the House will support new clause 2. Turning now to the bill itself, whereas the honourable member for Crawley is seeking to rectify an injustice, the Nationality and Borders Bill does the opposite and seeks to create chaos and injustice, and I'll focus my comments in this debate to part 1 of the bill. Clause 9 of the Nationality and Borders Bill provides the government with dangerous and unprecedented powers to deprive UK nationals of citizenship without warning, and we're wholeheartedly opposed to this clause. Though through Clause 9, the government seeks to amend the long-standing position under British Nationality Act 1981 that an individual must be notified if they are to be deprived of their nationality. It exempts the government from giving notice of a decision to deprive a person of citizenship if authorities do not have the subject's contact details or if it's not reasonably practical to do so. The government's proposal also allows such secret deprivations to take place solely on the basis that the Home Office deems it in the public interest or because it would damage foreign relations. Effectively, this means that the Home Secretary can strip someone's citizenship without informing them because it would be internationally embarrassing for her to do so. This abhorrent proposal therefore enables the government to remove basic fairness on top of an already dangerous power. As like many measures in this bill, there is no practical reason for this change. Present rules already allow for citizenship deprivation letters to be delivered to an individual's last known address. And the real purpose of this rule appears to be introducing measures that remove the right to appeal. These measures make a lawful, previously unlawful citizenship stripping. They ask Parliament to pretend an unlawful decision was lawful all along. It's shameful and Orwellian in equal measure. And Clause 9 means that... I'll give way.
Thank you very much indeed for that. I wonder if the honourable gentleman could just cast his mind back to 2003, the Nationality, Immigration and Asylum Act 2002. And for the first time, people who had acquired British citizenship through birth were made subject to deprivation of citizenship powers. So what we are talking about today, what he's just commented on, brought in by a Labour government, voted through by a Labour government. So I just wonder if he could address that.
As I've mentioned previously, any reasons to strip people of citizenship are done on notice. And this actually deprives people of the rights to... I do not agree with the principle of it. It should be done on notice. Clause 9 means that individuals will not be able to challenge their deprivation of nationality as they will not be aware or told that they are no longer British citizens. And the time limit for appeal may run out before the individual becomes aware that their rights have been stripped. As Reprieve have pointed out, under these proposals, a person accused of speeding will be afforded more rights than someone at risk of being deprived of their British nationality. I'll give way.
I'm very grateful to him for giving way, and I very much agree with the point that he's making. Is he aware of the very widespread alarm that Clause 9 of the bill is creating up and down the country?
My honourable friend is exactly right in what he's saying. In recent years, the government has unlawfully failed to satisfy the simplest of obligations in relation to citizenship deprivation, providing notice to people seeking to deprive of their rights. And having found them to have unlawfully stripped people of citizenship without telling them, the Home Secretary now seeks to undo these unlawful actions. I'll give way.
Can I just ask him very simply, does he agree with the principle of citizenship revocation? Forget the issue of duty of notice. Do you agree with the principle of it?
I'm sorry, but that's exactly what speaker.
Thank you, Madam Deputy Speaker. Madam Deputy Speaker, the British Nationality Act has been in law for the last 40 years, and that provides the power to strip people of citizenship. What we're talking about here is about doing it without notice.
Would my honourable friend agree?
I'll give way.
Thank you. Would my honourable friend agree with me that to deprive a person of their citizenship without warning or explanation would be a flagrant breach of natural justice, and that to do so as an alternative to submitting that person to due process under the law risks undermining our national security rather than enhancing it.
My honourable friend makes an excellent point. She's exactly right. How can it be right that somebody is able to be stripped of their citizenship without knowing about it? That's clearly a breach of natural justice.
My honourable friend
Give way.
very grateful to my honourable friend giving way. He's made a very important point about people not knowing that they've been deprived of their citizenship and how that might affect their ability to appeal, because in the clause the government's inserted, it says that someone subject to these new rules may appeal against the decision to the first tier tribunal. But as I understand it, Rule 8 of the Special Immigration Appeals Commission gives individuals 28 days to appeal deprivation of citizenship if they're outside the United Kingdom. Doesn't he agree with me that the Minister in responding today has got to give absolute clarity that that 28 days will be extended?
My honourable friend is absolutely right. How can you know when the 28 days are going to run if you've not received notice of the decision to strip you of your citizenship? It's absolutely basic.
Honourable friend, give way on that point.
Give way.
I thank my honourable friend, and would he agree with me that at the heart of this is the complete stripping away of the due process, where a person now does not have to be given notice, does not have to be given a reason why their nationality is being stripped, and it also has a disproportionate impact on our BAME communities.
My honourable friend makes a very good point. It will clearly affect people that have other citizenships acts available to them because it's currently unlawful to deprive somebody of citizenship and leave them stateless. People's citizenship, their identity and ultimately their rights are what this clause is about, because without citizenship, people do not have rights, leaving them without an identity and a sense of belonging. I'll give way this one last time, but I do need to make progress, otherwise there'll be very little time for anyone else to speak in this debate.
I'm grateful to him, and the honourable member is a reasonable man, so I'm sure he would agree with me. It is incredibly important on sensitive issues like the very small number of people whose nationality may be revoked by the Home Secretary, as it has been over the last 100 years, should not be subject to rather embarrassing scaremongering such as that has been by the honourable member for Bradford East. And would he like to confirm at the dispatch box that his clear understanding is that where someone has a single nationality only, they cannot have this revocation of nationality and be sent abroad, as the honourable gentleman has been passed?
There are many people that have dual nationality in the UK, and those are the people who are currently in fear of this measure being introduced and the status being. I will make progress. I will make progress. Not only do the provisions in this clause represent a total disregard for justice and the rule of law, but it also to certain British citizens that despite being born and raised in the UK, their rights would always be precarious and subject to change, because in the words of the Home Office, British citizenship is a privilege, not a right. The consequences of this are drastic. It is a threat to all, but particularly those from an ethnic minority background. According to analysis from the New Statesman, nearly 6 million people in England and Wales could be affected, with 2 in 5 people from an ethnic minority background eligible to be deprived of their citizenship without being told under this proposal. Madam Deputy Speaker, has the government learnt nothing from the Windrush scandal? It is repeating the same mistakes again and again. How can we trust the government and the Home Office? How can we trust them with the measures proposed in Clause 9? Simply, we can't. And I therefore commend the Right Honourable Member for Houghton, Price and Howden from bringing forward Amendment 12 to remove Clause 9 from the bill. We support this amendment in the name of fairness and in order to uphold the rule of law. Another aspect of Part 1 we're concerned about is statelessness, in particular Clause 10, which is intended to disentitle stateless children here in the UK from their existing statutory right to British citizenship. And I thank my honourable friend, and Right Honourable Member for Camberwell and Peckham, for tabling Amendment 111, which would in effect give effect to the recommendations made by the Joint Committee on Human Rights, which published an excellent report into the bill earlier this month. And I also wish to put on record my thanks, and I'm sure the whole House's thanks, for the enormous contribution that she has made as a parliamentarian, preserving rights and demanding equality. She'll be sorely missed when she steps down at the next election. Clause 10 proposes to amend and restrict a vital safeguard in British nationality law that prevents and reduces childhood statelessness. Under our international obligations, existing safeguards mean that a child who was born in the UK and has always been stateless can acquire British citizenship after 5 years of residing here. By restricting and amending this obligation, the government's proposals are an affront on children. They will impose the most profound exclusions upon children, denial of any citizenship, and particularly citizenship of the place where they were born and live and the only place they know. The exclusion and alienation will be inflicted on a child through their formative years and will be highly damaging to their personal development and to their feelings of security and belonging. The government has also failed to consider during second reading a committee stage, has consistently failed during committee stage and second reading to explain what assessment has been made of the impact this proposal will have on statelessness, and this is unacceptable. On this side of the House, we therefore welcome Amendment 111 and support its intention, which is to ensure that the government acts in compliance with Article 1 of the 1961 UN Statelessness Convention by amending Clause 10 so that British citizenship is only withheld from a stateless child born in the UK when nationality of a parent is available to the child immediately without any legal or administrative hurdles. This is a necessary amendment as the government has failed to protect existing safeguards in line with international law in this bill. In contrast, it has introduced cruel and unworkable proposals that would only exacerbate challenges for children and young people in the UK. Following on from the issue of child statelessness is the new clause from my honourable friend, the member for Streatham. We'll be supporting this new clause, which concerns the fee of £1,012 in cases of a child for people to exercise their right to be registered as a British citizen. Like honourable and right honourable members from across the House, I've raised many cases on behalf of my constituents navigating this inefficient, ineffective and expensive system. The fees imposed by the Home Office deny people their rights, and application fees are one barrier and Home Office delays and inefficiencies are another. And if we look at the figures, the unfairness becomes extremely stark. Even to the former Home Secretary and right honourable member for Bromsgrove, who described the registration fees for children quite rightly as a huge amount of money to ask children to pay.
Would my honourable friend give just on that particular point?
I'll give them.
Could you enlighten the House? Because I've heard that as this was being prepared, the Children's Commissioner wasn't consulted at all about the implications of this bill for the status of children and this bill. Could that possibly be right?
My honourable friend makes a very good point. I'm not aware that the Children's Commissioner was consulted on this, but I'm sure the Minister will clarify in his remarks whether that was the case or not. I agree that the fee for a child to register as a British citizen currently stands. The fee for a child to register as a British citizen currently stands at £1,012, and the Home Office confirms that the cost of registration to be only £372. The remaining £640 is therefore money made above the delivery of the service. Registration fees do not therefore reflect the costs of registration as things stand for the Home Office. Therefore, under the government's watch, people are being prevented from accessing the immigration system, leading to exclusion and isolation for children and young people who are denied citizenship due to the barriers in their way. Citizenship is not about cost, it should be about contribution to our communities and inclusivity. And as a system currently functions, however, it is about cost. By design, it is about the cost of astronomical application fees. And rather than fixing these problems through this piece of legislation, which despite its draconian measures, provide a unique opportunity to right this wrong, the government concerns itself with outlandish and unworkable policies. I strongly urge members from all sides to carefully consider my honourable friend's new Clause 8, which will deliver fairness where the government has failed to. It has our full support. Finally, I also wish to speak about another issue which I know has brought cross-party support and represents a further important and unique opportunity to right wrongs. New Clause 5, in the name of the Right Honourable Member for Ashford and others, which is related to the British National Overseas Visa Scheme, the BNO visa scheme. As we know, the BNO scheme has, in theory, been designed to offer a path to citizenship for Hong Kongers, but in practice, the scheme is not working as well as it could. Indeed, there are worrying and significant loopholes in the scheme that mean individuals and groups of individuals are being left in limbo. This is particularly true for young Hong Kongers who have fled the country over fear of repercussions. As those born after 1997 do not hold BNO passports and are therefore unable to settle in the UK via the BNO route, the result of this loophole is that the BNO scheme is that young people who have fled police brutality now find themselves fighting for their rights within the sclerotic and inefficient UK asylum system due to being arbitrarily excluded from the scheme because of their age. Those born after 1997 do not hold a BNO passport, and these documents were issued to citizens following the handover of Hong Kong from the UK to China in 1997. Therefore, to date, those under 24 cannot benefit from the BNO scheme. Home Office figures show that there have been 124 asylum claims from Hong Kong nationals in the year to June 2021, compared with 21 the year before and just 9 in June 2019. It is a growing problem and it cannot be swept under the rug. Indeed, for those stuck in the system today, there is an agonising wait, in the words of Hong Kong Watch. And it is an agonising wait that shouldn't exist and could be fixed in the BNO scheme. Again, this is something that we introduced as the opposition in committee and naturally with support New Clause 5 fully. There are deep and historic ties between the UK and Hong Kong. The government must not waver in its commitment to people whose way of life has been put at risk, and by accepting New Clause 5, the government can take a significant step forwards, doing that immediately with the support of members on these benches. We believe that the government's decision to offer the Hong Kong BNO scheme is a welcome expression of the UK's historic relationship with the citizens of Hong Kong, and we believe that individuals and families arriving from Hong Kong will enrich the cultural life of the UK and contribute to our economy. But without amendment, this scheme is in danger of just being more warm words. And as with other amendments and new clauses I've mentioned, despite our deep concerns about this bill and its draconian dog whistle politics towards refugees and asylum seekers, it does nonetheless provide an opportunity to right wrongs in our system. Thank you, Madam Deputy Speaker. I'll leave my comments there, as I know that many honourable members wish to speak today.
Perhaps I'll just give a little bit of guidance. There are 2 groups of amendments this afternoon. Sorry, you can sit there. There are 2 groups of amendments this afternoon. If colleagues wish to speak in the second group of amendments, they should wait until we get to that group. And obviously, a lot of colleagues will want to speak at various parts, so it might be wise to prioritise which particular sections colleagues wish to speak in. And I shall be prioritising those who have amendments down in this first section. David Davis.
Thank you, Madam Deputy. If I may just ask a question with respect to what you've just ruled, I take it I will be able to speak in the second group to my second group of amendments. I don't have to address them now. Is that correct?
I'm sure very careful consideration will be given to the amendments that down, but there may be some people who don't get in on both sections because if there are votes, it does eat into the second section. David Davis.
I wasn't looking for a promise, so thank you for that anyway. Let me start, before I talk to my amendment, literally, for which I have a 1-minute speech, by addressing two of the points raised by my honourable friends on these benches to the opposition spokesman. The first question that was put to him was, do you agree with the idea of being able to withdraw citizenship full stop? And my answer to that is that I think the current 1981 Act gives too much power to the Home Secretary, and that and I will answer if he doesn't interrupt me. And it gives too much power without sufficient early judicial intervention. It allows the right of appeal, but it doesn't require the right of application to court first, which for something as serious as citizenship, it should do. We should not give the state the power to effectively take every right whatsoever away from erstwhile citizens of the country. Now, that's not just my view. It also happens to be the view of our biggest ally. The only time in my time in this House that I have had a visit, as it were, from the State Department of the United States is on this policy. is on the fact that we are leaving, as it were, in some people's view, our human detritus out in the conflict zones of the Middle East. And most of our allies, having started with that policy, have withdrawn from it and are now taking back their own people to put them on trial in their own country. So from a security point of view, this policy doesn't exactly stand up in the views of our allies.
Will you give way?
Of course I'll give way.
He's making an incredibly strong point. Does he also think that it's quite inappropriate for one of the leading nations, which has the privilege of the veto at the United Nations, not to accept its international responsibilities in this way, responsibilities that all the other members of the Permanent Five are accepting?
Yes, I do think that, but I was focusing on this point on the security element of this, and I do not think the security argument stands up. Now, the amendment in my name, Amendment 12, would remove Clause 9 from this bill. It doesn't take away the Home Secretary's right of rejecting citizenship. It just takes away her right to do it without notification. Now, of course, that matters, going back to the point I made about judicial rights. Because if you don't know you've had the right withdrawal, if you've had your citizenship withdrawn, then you are unable to appeal the matter for as long as you don't know about it. And that might be a long time, because if you look at Clause 9, you'll see the reasons that subsection 5, this is the requirement to notify, does not apply if it appears to the Secretary of State that, and a series of conditions, one of which is it's in the interest of the relationship between the United Kingdom and another country. I cannot think of a weaker reason to withhold the rights of one of our citizens in favour of our diplomatic relations with another country. I really do not think we're on the same page in this respect. Now, the right of citizenship in this country, I mean, in 1850, I think A.J.P. Taylor said it was the greatest speech in Parliament was Palmerston's speech on the Don Pacifico affair, when he talked about the Civis Romanus Sum speech about the rights of a British citizen. And of course, in those days, that meant rights to be protected around the world, rather than what American citizens are now. It doesn't mean that anymore. But what it does mean are rights under our democracy, rights to access to a member of Parliament so they can stand up, rights to freedom under the law, rights to the judiciary, to the courts. I know they're unfashionable now, but rights to the operation of British justice, something which is one of the most valued things in the world, and it's what we are defending in these contests in the Middle East and elsewhere. And it seems to me entirely inappropriate that we should make one of our strategies that of being able to take away citizenship from people who very often have lived here since they were 1 or 2 years old. Very often, if they were sent to the other country, which they've never been to and don't speak the language anymore, they will face summary execution, at least one case that applies. Where stands our belief against the capital punishment, which most of the people in this House espouse? So this is an uncivilized, legally disputable removal of the rights of people who may not be good people, but then put them in front of our courts and punish them. That's the way British justice would work. That's the way British democracy should work, and that's what we should do today.
Yeah.
We now come to the SNP spokesperson, Anne McLaughlin, and just to remind people that being fairly brief in remarks will allow more people to get in, as admirably done by David Davis. Anne McLaughlin.
Thank you very much, Madam Deputy Speaker. Even though we have fundamental disagreements with most of this horrific bill, that is not the case for Part 1, where we're in agreement with much of it. We support the efforts to correct some historical injustices of UK nationality law and bringing British citizenship and British overseas territory citizenship law back into line. It could have and should have happened a long time ago, but it's happening now, and we support that. But we must pay tribute to the campaign groups who've continued to make the case over several years, including the Project for the Registration of Children as British Citizens and Amnesty International. However, there are a number of issues I want to raise, and I'll start with the SNP new clauses. New clause 34 wants to ensure that the government does not profit from people registering as British citizens or British overseas citizens. Members might be interested to know that in 2018, the Home Office made profits of £500 million by charging £500 million more than it cost to process the fees. The cost to the Home Office of the registration process per person is approximately £372. The cost to the person applying is a minimum of £1,100 if you're a child and £1,200 if you're an adult. Why? And more importantly, why does it matter? How does it impact on somebody's life? Madam Deputy Speaker, I'd like to share the story that I shared at committee stage of someone who's become part of my family and the devastating impact these extortionate fees had on his family life. Campbell, not his real name, came from Sudan. His village where he grew up was razed to the ground. Everybody fled, and he didn't know where the rest of his family were. He assumed that his brothers, sister, mother and father had died, but he didn't know for sure, and he kept hearing rumours over the years. He came here as an asylum seeker and then got his refugee status. He worked in security on minimum wage, 0 hours contracts, but he had a very diligent approach to his job and he built a life for himself. But always in the back of his mind was the need to know for sure what had happened to his family members. Any of us would share that need. The Red Cross got some information from him, but nothing was certain. There was a possibility some of them had survived. He knew he needed to go back and find out if that was the case. To do that, he needed the protection of a British passport and British citizenship, so he set about applying. Because he was on minimum wage, it took him years to save up the fees. And I realise there are many in here who cannot imagine that, and I make no criticism of them. I'm not being facetious for never having experienced poverty. I would like nobody to experience it, but I would urge the members opposite to trust me when I say it took him years to save up the £1,200, and he couldn't have saved any harder. Had he been charged what it actually cost the Home Office, he would have got to the Sudan a whole lot sooner. I know that nobody in this room would have wanted what happened to him, which I'm going to come on to have happened, but I want to explain the impact of these extortionate fees in the hope that the government can be persuaded to reduce them. It took Campbell a long time, but he finally got back with his British passport to Sudan to see what had become of his family, and he discovered that his mum had in fact survived the brutal attacks. She later became ill for many years. She lived longer than anybody expected, but it was because she'd clung on, hoping that she would see his face one more time. She died 2 months before he got there. As I said, I'm not for a second suggesting that anybody here or anybody drafting the legislation would not care about what happened to Campbell. But if he had been able to apply for his citizenship when he became eligible, in other words, if he'd been able to afford the cost because it was the actual cost rather than the cost plus profit, he could have been reunited with his mum before she passed away, and it would have meant so much to both of them. There are so many Campbells out there, Madam Deputy Speaker, and so many others with different stories. I want to express my party's support for new Clause 8 in the name of the Honourable Member for Streatham, and I will leave her to make what I know will be very good arguments about the even more offensive practice of making profit from children's applications. One of those arguments being, of course, that the courts have already ruled against it, but that doesn't seem to make a great deal of difference to this government these days. And finally, on new Clause 34, awareness raising, several organisations, including Amnesty, have expressed concern about the lack of it. They've asked for assurances that where an individual application is successful, the government will take positive action to ensure that other potential applicants are made aware of their equal or similar right to register at discretion. This means that where an example is identified, as the bill says, of unfairness, an act or omission by a public authority or exceptional circumstances on which it is right or necessary to exercise the discretion, there should be publicity and awareness raising. We talked about that in committee, but those organisations want to know that it will happen and that members of the public who could use the legislation to the same positive effect will have access to that information, easy access. And I would also like an assurance from the Minister that awareness raising will apply equally to British citizenship and British overseas territories citizenship. New Clause 33, EU citizens have been living in the UK without knowing that for some there is an obscure requirement to hold a form of private health insurance with free access at point of need to our unique NHS, of which we are all proud. The EU rules on the need for comprehensive sickness insurance were not really written with the UK's unusual situation in mind. So new Clause 33 is necessary because for many this requirement has only become apparent when applying for citizenship or when applying for British passports for their children born in the UK, and it's now presenting significant hurdles to obtaining citizenship. It could easily be rectified by this new clause, which would allow an applicant's right of free access to the NHS to satisfy the requirement that an individual should hold CSI. And the Minister made sympathetic noises on this at committee. So if he won't accept this new clause, will he at least tighten up the guidance so that nobody has to take the risk of shelling out over £1,200 to apply, only to lose it when the decision maker takes the view on CSI that the Minister seemed to be suggesting he would not want them to take? Madam Deputy Speaker, we support many of the amendments and new clauses, but I'll mention just a couple in particular. The Amendment 2 in the name of the Right Honourable Member for Orkney and Shetland to leave out the clause 10 on statelessness. So clause 10 requires the Secretary of State to be satisfied that a child was unable to acquire another nationality before the child is permitted to register as a British citizen. This creates an additional and unjustified hurdle to stateless children's registration as British citizens. Rather than ease the process and reform the current system to help children attain citizenship, the Government are intent on putting up more barriers and making it more difficult for children under 18 to be registered. Why? Because they have a handful of anecdotal examples of parents who appear to be using the system, as far as they're concerned, to jump the queue. In fact, I only remember one anecdote at committee stage. What I do remember is honourable members on the committee asking repeatedly for evidence, and the Minister repeatedly saying evidence would be forthcoming. I remember the honourable member for Enfield Southgate asked, I asked myself several times, the honourable member for Bermondsey and Old Southwark asked, and the honourable member for Cumbernauld South and Kirkintilloch East asked. I think I counted when I looked at the record at least 10 times that we asked for something more than anecdotes, and we were told the evidence would be forthcoming. But it's just not, it hasn't been. So maybe the Minister's going to surprise us and give us the evidence now. But the impact of the anecdotes one anecdote that I remember being given was that a child who's done absolutely nothing wrong may end up registered as British 5 years before they otherwise might be. It hardly seems grounds for introducing this restrictive clause. And the impact of statelessness on children can be dreadful. It's a terrible thing for a child to feel that they don't belong during their formative years. Coming on to Amendment 12 in the name of the Right Honourable Member for Halton Price and Howden, we're very much opposed to Clause 9 of the Bill, which grants the Home Secretary the power, as we've heard, to strip UK nationals of their citizenship in secret without advance warning. Deeply concerning, and it sends completely the wrong message. And I can say that since this has become public knowledge, I've had a number of people phoning me in an absolute panic about it. I will give way to whoever it was that asked me.
Thank you very much. Thanks very much for giving way. Does she agree with me that it's not only us and the honourable gentleman opposite that share the concerns? A petition was started on change.org by my constituent, Mr. Kashif Iqbal, has now got over 150,000 signatures calling for the removal of new Clause 9 to ensure that British citizenship cannot be stripped from our constituents in this manner.
Yeah. And I pay tribute to, I'm just coming to the end, Madam Deputy Speaker, but I pay tribute to Mr Iqbal, my honourable friend's constituent, because that's what we want, is public pressure. Because on the committee, I felt we were not being listened to at all. And of course, we didn't win any of the battles on committee. Probably not going to win any of the battles here, but we'll try. But public pressure is what will make this government change its mind. As I said, we do support many of the amendments, for example, new clause 2 on the Chagos Islanders, and I also pay tribute to the honourable member for Chorley for his tenacity in this. New clause 4 and 5 regarding Hong Kong citizens, new clause 7 on healthcare workers. Seems a bit of a cheek to be charging people for the privilege of putting themselves at risk fighting the pandemic, and those amendments and new clauses from the Joint Human Rights Committee. But as I say, we support righting the historical wrongs, but our primary concerns are stateless children, stripping away people's nationality without notice, the requirement for CSI for EEA citizens, and they need to end the practice of profiteering from people registering as British citizens. That, Madam Deputy Speaker, has to stop. Hear, hear.
Just a reminder that this debate has to finish at 4:45, and obviously the Minister will require some time at the end. So if colleagues were about 5 minutes, we might make it. Damien Green.
Speaker, I wish to move new clause 5 and to start by thanking the more than 50 colleagues who supported this new clause, representing, I think, every party in this House. And also, I wish to thank ministers for engaging positively with me on the substance of the amendment. My new clause aims to provide greater protection for the brave young people in Hong Kong who are fighting oppression. In particular, it gives them a right to settle in the UK, which is very difficult for them at the moment. Why is it needed? I would illustrate it with one case of 20-year-old Tony Chung, who's been handed a prison sentence of more than 3.5 years. His crime, which was that when he was 18 years old, on a small student Facebook group, what he said was deemed to amount to secession and being breach of Hong Kong's national security law. This illustrates how what was once Asia's freest and most vibrant city is moving towards totalitarianism. Political persecution is growing by the day. Amnesty International calls it a human rights emergency, and I agree. The Hong Kong government, at the behest of Beijing, is silencing the free press, gagging civil society, and smothering all forms of dissent in the city.
Honourable friend,
give way to my honourable friend.
As my honourable friend knows, I am signatory to his amendment. Does he share my concern that 93% of those people that have been arrested just for being pro-democracy are young people, and we have a unique obligation to protect them and provide them safe and legal passage? And when we're dealing with a Chinese Communist Party that can disappear a tennis player or even sanction members of parliament, we need to be absolute in the support that we give young Hong Kongers.
My honourable friend is absolutely right, and indeed anticipates a point I was about to make. And the key point that arises from her remarks is that the British government has sensibly and rightly introduced the British National Overseas Visa, which allows people in Hong Kong who registered for that scheme before the handover of Hong Kong in 1997, the right to settle in this country. The problem is that many of the dissenters and demonstrators in Hong Kong are under 25 and are therefore too young to have qualified under that route as it currently stands. So what I am seeking to do is to give those under 25-year-olds the route as well. I give way to my right honourable friend.
Can I first of all congratulate my honourable friend for having brought this amendment forward? It speaks of the decency of what we represent here in this House, and I want to support him in this. Does he not agree with me that right now many of those individuals he's referring to are looking to us desperately for some hope of freedom, and that we need to offer them, as this mother of all parliaments, the chance for that freedom?
He is exactly right. These young people, mostly young people, are fighting for the values that we fight for and that this Parliament represents, which is why I'm so pleased that people from across this House have supported this new clause. But in practical terms, as I say, I have thanked ministers for being positive in their engagement. I hope to hear more from the minister when he rounds up the debate. But I think although the government is absolutely moving in the direction and its heart is in the right place on this, I fear they may not at this stage move far enough. And in particular, I know the minister is very keen on using the youth mobility scheme, which exists not just for Hong Kong, obviously, but for many other countries as well, as a route for young people in Hong Kong to move towards settlement. And I would enter two quite large caveats at this stage about using that scheme. The first is straightforward practicality, which I can illustrate with the example of a 19-year-old Hong Kong young woman called Venus. That's not her real name for obvious reasons. She was involved in many protests. The university she was at reported the protests to the Hong Kong authorities. She evaded the police for a time, but she soon became aware that they were coming for anyone involved in protests under the pretext of the national security law. She fled to the UK from Hong Kong the day after. Several of her friends were arrested 2 weeks later. If she had applied through the youth mobility scheme, it would take 3 weeks at least for her to get out of Hong Kong. It would not have been enough. So there's that very practical point about using the youth mobility scheme. And the other point I would make is that, of course, it's a reciprocal scheme. It requires both sides to agree. So if the Chinese authorities, the Hong Kong authorities, decided not to participate in a reciprocal scheme, then they could close it down tomorrow. And I would want to hear from ministers what they would do in those circumstances. Give way to the honourable lady.
I thank the honourable member for giving way, and I thank him for putting forward this amendment. Would he agree with me that the under 25s that are seeking asylum and safety in our country from Hong Kong not only have to navigate a difficult asylum system, but now also have to face difficulties in terms of access to healthcare, but also safety once here as well?
I don't wish to go into wider issues with the immigration system at this point. At the moment, genuinely, I'm most concerned with giving them a route to get to this country. Apart from the asylum system, we already have a couple of hundred of them in the asylum system here. And if ministers can find another route, if we can find another route, then that would take a bit of pressure off the asylum system. And I would recommend ministers look at Canada's Young Talent Work Experience pathway to permanent residence for Hong Kong as a suitable exemplar to follow. I do want to work with ministers on this, and I believe that they have the best interests of the people in Hong Kong at heart. So I'm hoping not to have to move this to a vote this time, but I would want to give them more time simply to work out the better details of a mobility scheme suitable for young people in Hong Kong, because as we know, after this week, the bill will go to the Lords, where it will excite very detailed interest. By the time their lordships debate it, I hope and expect that ministers will have sorted out the gaps that remain in their proposals sufficiently so that there's not a similar amendment to mine needed again. If there isn't, then I expect and indeed encourage their lordships to pass a similar amendment and let us have another go. If this has to happen, those of us supporting this amendment will be less accommodating to the government than I propose to be today. But I hope it doesn't come to that. We all have a duty to the brave people fighting for democratic values, our values, in Hong Kong. And by the time this bill has passed through all its stages, I want to know that we have fulfilled that duty. So over to you, Minister, do the right thing.
Can I just clarify that everybody who wants to speak in this debate is now standing? Right. Okay. Addy.
Thank you, Madam Deputy Speaker. I wish to move new clause 8, which is very gratefully signed by a number of members of this House, on child citizenship fees. The children in question are not migrants. I repeat, they are not migrants, because every single time this issue is raised, there's some sort of suggestion that there is something behind it, there's something slightly illegal behind this. And I think it's absolutely disgraceful. On the contrary, the large majority are exactly like myself and the Prime Minister. They have every single right to British citizenship. The government and successive governments have accepted that. The issue is that they're being priced out. Now, in this country, we charge British children, up to 10 times more to claim their citizenship rights than their counterparts in Spain, France, Belgium, Denmark, and Sweden, the most expensive in Europe. If the £35 fee introduced back in 1983 had risen in line with inflation, it would only be £120 today, but instead we are charging £1,012. A fee that has doubled in the past decade, a fee which the government have the ability to increase at will, a fee which far too many can't afford, and a fee the level of which neither myself nor the Prime Minister had to pay. And why do I keep mentioning myself and the Prime Minister? Because the circumstances of our births are no different from the children in question today. In fact, there are many members across this House not born here or born to migrants. None of us face these barriers on claiming our citizenship. No one questions our rights, and our British citizenship gives us the right to sit as members of this House. So I repeatedly mention myself and the Prime Minister because I believe that neither of us should be in a position to make things difficult for the children born after us. I certainly didn't come to this House to do that. But just like the Windrush generation, these children, through no fault of their own, and often with no idea of what's to come, go on to face some real difficulties with everyday life. Things we take for granted: travelling, getting a job, renting a home, or being able to go to university without being asked to pay international fees in a country they were born in or have lived in their whole lives. Make it make sense. Now, Citizens UK, who alongside Amnesty and Amnesty International and the PRCBC, who have led on this campaign, have estimated that there are between 85,000 and 215,000 children with a legal entitlement to British citizenship who have ended up undocumented due to the extortionate registration fee. Imagine just how many children have never got the opportunity to reach their full potential because they spent the end of their childhood and the beginning of their adulthood fighting to prove that they have rights in their own country, fighting to prove that they belong in the only place they have ever called home. And exactly what happened with the Windrush generation. Now, we have to understand that the harm of being denied your citizenship rights in the only country you know can't be overstated. It's not just about the societal barriers, but the psychological impact of being constantly treated like a second-class citizen. And why do I continuously compare them to the Windrush generation? Because just like the Windrush generation, a piece of legislation or policy that was attempted to dissuade migrants and make the environment more hostile for them is impacting on a group of people that have every single right to be here. And just like the Windrush generation, this policy disproportionately affects those of Black, Asian and minority ethnic heritage. I will give way.
I'm grateful to my honourable friend. Does she agree with me that to make children bear the burden of this government's hostile environment policy must be wrong?
I thank my thank you. I thank my right honourable friend, and I absolutely agree with her, and I'm sure she will agree with me that there are clearly no lessons learned here. And now this new clause is not even asking to scrap the fee, which is my personal preference, just reduce it to cost and examine its impact on the rights of children. It does, however, ask for the fee to be scrapped for children in care. For the very obvious fact that the children in care are the responsibility of the state. As we approach Christmas and we're thinking about families and home, with all the disadvantages that children in care face, this government seems all too at ease with telling these children that they also have no country to call home unless their local authority is willing to pay for it. Now, I spoke to children that were Lambeth care leavers, and they told me horrific tales of threats of deportation to countries they have never been to because they cannot prove their link to their citizenship due to issues with their relations with their parents. And our cash-strapped local authorities can't afford to keep paying these fees. Further to this, they are not border guards or immigration specialists to have to understand exactly what is happening. Now, my honourable friend, the member for Glasgow North East, is absolutely right. There are parts of the citizenship section of this bill which we do appreciate, things that have been corrected. And I spoke to the immigration minister earlier this week, and I was very grateful for his time. I promised I would say something nice, and I did. I'd just like to say that if we are correcting all of these other things, why would we not correct this now? We know exactly what the issue is. We know that the courts have ruled it out. We know that the government has appealed against us, and the courts have ruled again that these fees are not in the best interest of children. This bill is so horrible in so many other areas. Is there not just one thing that we can all agree on? Just like the Windrush scandal, why does the government want to be dragged and screaming into submission on something which they know is absolutely right? Now, I'm glad to be standing here today because I get to keep my promise that I made just before my election to a group of students from St Gabriel's College who, along with Lambeth citizens, explained to me their plight as children who were suffering like this. And I'm glad and I'm proud to be the school governor at their school because they are what I call citizens. They are affected by this issue, and some of them have moved on, but they continue to fight for others in their place. And I promised I would try and stand in this house and show that these young people are valued by their country, because this is their country. And I hope that every other member of this house, when this hopefully goes to a vote, will walk through the lobbies with me and show these young people that they have every single right to be here, that we won't continue to price them out, and they should be able to access every single right, just like myself and the Prime Minister have been able to. Thank you.
Andrew Rosendale.
Thank you, Madam Deputy Speaker, and I rise to move new clause 4 to this bill that would secure the right of abode to the brave and loyal servicemen that served Queen and country in the British military in Hong Kong Military Service Corps and the Hong Kong Royal Naval Service Corps since 1997. These were servants of the Crown, and they should, I believe, be treated equally to all those that have served in Her Majesty's Armed Forces. Certainly.
As a co-signee of the amendment, which I congratulate the member for bringing to the House today, does he agree with me that this is a unique group of individuals because of that service, and therefore they should be considered and considered favourably by the government?
They most certainly should, and it should not have taken all this time for the government to accept the need to deal with this. This is a left-behind group of ex-servicemen, and they really do need to be given the right of abode here in the United Kingdom. And it was prior to the handover of Hong Kong to the People's Republic of China that only 159 of the 654 British Hong Kong servicemen who applied under the then 1990 to 1997 British Nationality Selection Scheme were offered full UK passports for service to the Crown. I believe that those who applied for UK passports and were denied them have been discriminated against, and it's time this was rectified. They should have been treated equally to the 159 and also given British citizenship for their armed forces Crown service. Currently, the campaign for the right of abode of former British Hong Kong servicemen have established the number of servicemen still seeking recognition from the government to be around 301, with immediate family growing the group to around 1,000 people. This is, Madam Deputy Speaker, a very low number of people when compared to the 3 million citizens affected by the changes made last year to introduce the BNO passport, which was such a welcome support for the people of Hong Kong.
My honourable friend,
I certainly will.
am I right in thinking that of these very patriotic individuals, they are seeking the right to come here if they need to under cases of future discrimination? They're not necessarily all likely to have to take up that right.
My right honourable friend makes a superb point, and he's of course completely correct. These ex-servicemen in Hong Kong are not demanding the right to come here straight away, but they want that option should there ever be a need for them to leave Hong Kong if they felt unsafe or their families were under threat. Surely in a situation like that, Her Majesty's government should support those who have served Her Majesty's armed forces. Yes, I certainly give way.
I thank the honourable member and the right honourable member for tabling this important amendment. Does he agree with me that while this amendment is welcome and it would be an improvement on the current situation, that it still means that young people born after 1997 would be relying on the BNO status of their parents, and that will disproportionately impact poorer Hong Kongers and people whose families moved after 1997?
I think that refers to a different amendment, Madam Deputy Speaker. Yes, yes, certainly.
Thank you, Madam Speaker. On this amendment, I take my mask off. Isn't it the case that for this very explicit group of people who've given loyalty and service to this country in standing for freedom and liberty and the rule of law, it will be deeply ironic and unjust if we were to leave them to the vagaries of a regime that has turned out to be entirely opposite freedom, liberty, and the rule of law, and that's why we owe them this duty of care if they choose to take it up.
And makes an excellent point. I agree wholeheartedly. This is about giving people that have loyally served the Crown and defended freedom and liberty in Hong Kong the ability, if they so choose, to have the option of living in the United Kingdom and being treated as equals. That is surely something we should now accept. This is long overdue, and I hope the Minister will respond accordingly later on. And I know that, Madam Deputy Speaker, Mr. Speaker himself shares my interest in resolving this long-standing issue. And I've worked together with Mr. Speaker prior to his elevation to the chair on this issue for over a decade. In that time, I've worked with a number of ministers, Home Secretaries, Ministers of State, including my friend James Brokenshire, the late member for Old Bexley and Sidcup. We've worked together to try to resolve this matter and right this wrong which has been done to these servicemen. But so far, with deep regret, no concrete steps have been taken by this or previous governments to resolve this matter. An appropriate solution must include a mechanism to grant every single one of these servicemen immediate settlement status in the UK if and when they decide they would like to take up that option. Furthermore, it should not create another group of left-behind servicemen by putting an arbitrary period of service required to be eligible for the right of settlement, or putting an age limit on the immediate family members that they would be able to bring to the United Kingdom. I believe that the only legislation that includes all of these measures will be sufficient to finally correct the anomaly that has led to these fine servicemen being left behind. My amendment, New Clause 4, would secure these objectives and finally give the servants of the Crown the right to be treated as fully British, which is no less than they deserve. And so, Madam Deputy Speaker, I ask the Government either to support my amendment or produce an appropriate and legally acceptable way to support these veterans and give them the status they are entitled to, dealing with this matter once and for all. It is with this in mind that I would like to thank the Minister for reaching out to me about suggesting an alternative solution which may be possible. However, let me be clear, I do require guarantees that will not be watered down. If the Minister does not feel able to support my amendment, I expect him to provide a fair and just solution that gives these brave and patriotic Hong Kongers the outcome they deserve, and ask him to use this opportunity today to provide the assurances I seek. Thank you.
Can I once again really urge colleagues to stick to the 5 minutes that we talked about, because we are going to have to impose a time limit shortly if we're going to get everybody in. Alistair Carmichael.
Thank you very much, Madam Deputy Speaker. We have a fair old mixter of different amendments, new clauses and provisions here, but as I consider them all and try and find some common theme through it, I think I find this, and it is that foreign policy decisions that we as a country take and are taken in this House always, sooner or later, have domestic policy implications, consequences that flow from them. And it doesn't matter how hard we may try to ignore them, as we have done with the rights of the Chagos Islanders over the years, and it doesn't matter how hard we resist the logic of our own decisions for whatever reason, as we have done with the Hong Kongers until recent years. Eventually, they all require to be dealt with. I want to deal briefly with first of all, the amendment number 2 standing in my name, which is effectively to remove clause 10 from the bill, and the new clause standing in the name of the Right Honourable Member for Halton, Price and Howden, which seeks to remove clause 9. Essentially, the purpose of clause 10 of the bill is to restrict the rights of children who would be born in this country but otherwise would be stateless. The point about clause 9, as was made very well by the Right Honourable Member, is that not only is the removal of citizenship obnoxious, it is the removal without notice that actually is supremely dangerous. Now, I think it's perfectly legitimate for government backbenchers to point out that the genesis of this removal was something that was to be found in the 2002 Act. I see them nodding. I would just gently counsel them that to say that you have found a way of taking a measure that was introduced by David Blunkett as Home Secretary and make it even more illiberal and more draconian is not necessarily something about which anybody should be particularly proud. It is the removal without notice that is particularly objectionable. And as the Right Honourable Member for Chingford said, one of the things that we're dealing with here is just that basic British sense of decency. And when it comes to the question of citizenship, we shouldn't be using that as some sort of tool for further punishment. There are plenty of other ways in which people who have done wrong can be punished. But you don't use fundamental concepts in domestic and international law, such as citizenship, as a tool for that. The Honourable Lady from the Scottish Nationalist Bench and the Honourable Lady from Streatham have brought forward various provisions with regard to the financial barriers that are put in place. I was happy to sign the Honourable Lady's amendment, and I very much support the ones brought by the Scottish National Party. It seems to me, from my casework as a constituency member, that we have made an immigration system which is already so complex that it is virtually impenetrable to those who are not in some way legally qualified. And as far as I can see from many who are legally qualified, that it should not therefore be administered in such a way that it is open to the government actually to make a profit from these cases. There are already sufficient financial barriers in the place of those who wish to have and need to have a citizenship, that we should not be putting a further financial barrier in their way. Madam Deputy Speaker, there are a whole range of different matters before the House this afternoon. I think it illustrates to me the fact that this bill is far from properly scrutinised. We are taking it at a canter this afternoon. There may well be reasons for that in the minds of the government business managers, but as is the case with trying to wish away the consequences of our foreign policy decisions, these are not or the considerations of government business managers are not ones that are going to carry any water when the bill gets to the other place. And I fear that even though the government will probably get their way in virtually everything today, we will not have heard the last of this bill yet.
After the next speaker, I will impose a time limit of 4 minutes. Rob Roberts.
Thank you, Madam Deputy Speaker. I rise to speak to my amendment, new clause 7, which has been kindly supported by members from 8 different parties, including immigration and NHS subject experts, for which I am exceedingly grateful. I'd like to declare an interest, Madam Deputy Speaker. My partner is an NHS clinician from overseas, and I'll state at this point that this new clause would not benefit him, as he already has his permanent residency status confirmed. In this country, Madam Deputy Speaker, we typically use the word hero far too casually. It's lavished on our celebrities and sports stars, and while I'm sure they're very deserving, I think this pandemic has shown us who this country's true heroes are in our NHS workforce. While the entire NHS has played a vital role, our thanks and gratitude should perhaps in particular go to our NHS clinical workers who've come from other countries. These are individuals who've travelled huge distances to be here, often separated from their families, putting their own lives at risk to help save our lives. Regardless of their or our citizenship, the duty and responsibility to care and contribute to the well-being of others always comes first with them. While I welcome the many steps that the government has already taken for foreign NHS workers, we do need to go further, and I'd ask the Minister to really give this some serious consideration for support this afternoon. With fees for indefinite leave to remain at almost £2,400, citizenship applications another £1,330, the total cost of naturalisation is almost £4,000, one of the highest fees of its type in the world, and that's after a minimum of 5 years, in which there will also be an initial visa cost, another high fee every 3rd anniversary to renew. The process of becoming a citizen for our NHS workers is a costly and challenging one. We'll take an example of the case of Carrie, a real-life case but using a different name here. Carrie moved to the UK in 2016, leaving behind a husband and 4-year-old child back in South Asia. It took another year for her to bring her husband and daughter to join her because of the costs involved in dependence visas. They could only get to be together as a family once more by taking a loan which she has to pay for over 3 years. 3 years after she arrived, so still one more of loan payments to go, she had to get another loan and compound her cash flow problems because she was due for visa renewal, so had a load more fees. This year, Carrie's entitled to apply for indefinite leave to remain, with loans still ongoing from previous renewals, and the ILR is more expensive again. What does she do? What options available to Carrie? Her only choice is to apply for another loan, even bigger than before, to have the right to occupy a space in the UK and call it home. She pays her taxes every month. She's done so for 5 years. Oh, by the way, she's an ICU nurse. She spends the past 5 years saving lives, especially the past 18 months. She shouldn't be in debt. We should be in her debt. I feel, Madam Deputy Speaker, it's our duty to create a new route to permanent residency for NHS workers, one that won't leave them in debt, won't leave them in poverty or constant worry about funding their next application, by abolishing the costs associated with applying for indefinite leave to remain for NHS clinical workers. I'm proud that our NHS attracts such global talent and recruits from all over the world, and frankly, we wouldn't be able to run it without them. As of last year, over 160,000 NHS staff stated that they were a non-British nationality from over 200 different countries. Residency shouldn't be about cost. It should be about inclusion. It should be about our communities and contribution. And our NHS workers have arguably given the biggest contribution of all, saving our lives and keeping us safe. Despite being such valued members of the communities in which they live and work, without ILR and citizenship, they can't be fully part of them. Without ILR, individuals face barriers to home ownership, difficulty obtaining a mortgage, challenges in the job market, challenges in higher education, so many different aspects. Scrapping the fees would not only make ILR more affordable and a viable option for foreign workers in our NHS, but would also create a more diverse and, crucially, a more integrated society. And why is that important? Well, a few weeks ago, Madam Deputy Speaker, I had a message from my partner, distressed at having met a new patient that morning and being asked, "I hope you're not from Myanmar." We have a long way still to go with integration and acceptance. People from other countries that have worked in our NHS during this pandemic and throughout their lives deserve to be able to call the UK home and actually feel like it is. It's time to abolish the fees for indefinite leave to remain for those that do clinical work in our NHS, so that those who spend time helping and treating us in our time of need can finally feel like they belong and are welcomed here with open arms.
Sina Malhotra, 4 minute time.
Thank you, Madam Deputy Speaker. I want to first acknowledge my support for new Clause 8, tabled by my honourable friend, the member for Streatham, and to congratulate her on a very powerful speech as well, to end the shame of profiteering from child citizenship fees. And I also want to support the arguments made by my honourable friend, the member for Enfield Southgate. I want to mainly make my short contribution on Amendment 12 in the name of the honourable member for Halton Price and Howden, to which I have added my name. It seeks the removal of Clause 9, tabled by the Home Secretary, seeking to deprive UK nationals of citizenship without notice. Madam Deputy Speaker, this is an extraordinary amendment that has caused shockwaves across communities, and particularly in Feltham and Heston, it has really affected the South Asian community. I'm grateful to all who have written into me and signed the petition that's had almost 150,000 signatures. I also want to thank the immigration solicitor, Mr. Harjat Bungle, for his work and awareness raising around this. I was born in Britain, in Hammersmith, in West London. I grew up in Hounslow. It appears that the law as drafted, I could theoretically, in future, be deprived of my citizenship with no notice and potentially without appeal because my parents were born in another country, even though they became British nationals and served their community with distinction. Perhaps the Minister in his closing remarks will be able to say whether or not this could ever be able to happen to anyone. Because what it appears is that this is a thin end of an appalling wedge. Members of my extended family were also amongst those who were expelled from Uganda and with mass expulsions of the Indian community. And I'm sure the Minister will understand why this has caused such concern. The Home Secretary's clause would amend the British Nationality Act 1981, which currently requires the Secretary of State to give notice, to give a person written notice of their deprivation order, the reasons for the order, and the person's right of appeal. Clause 9, subsection 2, specifies circumstances in which the Secretary of State would be able to deprive a person of their citizenship without notice, briefly including that the Secretary of State doesn't have the information to give notice, or it would not be reasonably practical to give notice for any other reason, or for giving notice, if giving notice would not be in the interest of national security, relations with another country, or otherwise in the public interest. Now tell me what relations with another country means. If, in theory, a foreign government with whom the government is negotiating a trade deal says that they want British citizenship revoked from a group of people that they would like to see returned back to their country of origin as a condition, possibly for political reasons, the Home Secretary could, in theory, do it, and without saying why. It is not what is likely that this is about, it is what becomes possible. And there is no practical reason for this change. The present rules governing notice allow for citizenship deprivation letters to be delivered to the individual's last known address. I cannot support this new clause from the Home Secretary, which has breathed a huge distrust and insecurity into the lives of millions living peacefully and law-abidingly in this country, that the state could have this power and without needing to give explanation that may not just affect them, but also their children and grandchildren. And I would urge all to support Amendment 12 today.
Richard Graham.
Mr. Deputy Speaker, today's debate covers many different aspects. I certainly hope that new clause 4 is considered carefully by the government. But I want to focus my comments on new clause 9 and the impact of the change in notification about revocation of nationality and the impact that that has had. And I want to say straight away really to the member for Streatham, who is not in her place at the moment, when she described this bill as hostile and horrible, that she should consider, as we all should, very carefully, the impact on the lives of so many people from those killed by terrorists, whether in Manchester, on London Bridge, or anywhere else. Because the important thing about these ghastly incidents is that they affect those from every background, of every faith, of every race, of every colour. And clause 9 is not. Of course I'll give way.
He says, I don't know if I heard you properly. We're talking today about people dying because of this government's policies, because they are so desperate that they're fleeing war-torn countries, and you're wanting us to think about terrorists. I think that that's quite appalling. I'd really like you to withdraw that comment.
With the greatest of respect, what I'm talking about is a specific aspect to the revocation of nationality for appalling behaviour against the interests of the country to which all of us belong and are national. And it's a very specific point. So I'm not going to follow the honourable member down that debate, I'm afraid. But the point is,
Go on, yeah, go on.
please,
go on.
it would...
To clarify, Mr. Deputy Speaker, in reference to the speech given very eloquently by the member for Streatham, he drew an allegiance between terrorism and children fees for the fees for children seeking to get nationality here. That's what just happened. I think that she should revoke those comments.
I'm grateful for her comments. I specifically quoted the member for Streatham on the use of two words about this horrible bill, this hostile bill, in relation to this particular clause, which has been used, she will recognise, by members of the opposition, notably the member for Bradford East, in order to stir up concerns, and bluntly speaking, which I regard as scaremongering, and I'll come on to that, amongst members of different ethnic communities in our country. This is, to my way of thinking, deeply inappropriate, because what we are talking about is the notification of a revocation of British nationality to a tiny number of people who have chosen to behave in a way that is totally against the interests of our country and allied themselves with the enemies of this country. And all this particular clause does is to allow for the absence of the notification physically where those individuals are either unreachable or in a war zone. Now, so far, so good. Of course, I'll give way to the right honourable member.
I'm very grateful to him for giving way, and I'm listening carefully to the point that he's making. But will he take it from me that the alarm about this clause is not because of any stirring from this side of the House? It's the reality of the content of that clause and the government's track record.
I have agreed over the last 10 or 11 years, many times, with the right honourable gentleman on many issues, particularly to do with work and pensions. On this particular point, I'm sorry, but I think he's being a little bit disingenuous about how some of his colleagues are using this to stir up concerns where actually we need to be together as a nation. But where I agree with him is that I do think there is real work for the government to do, as the Minister knows, because he kindly gave me time on this point yesterday, in order to communicate much more effectively with Britons across this country about the facts of this legislation, which draw on a right that has been there for government for 100 years, since the First World War, which most people, most of our constituents have no idea about. And therefore the questions, well, I've given away quite a lot. Can I make some progress?
She's spoken.
I'm just conscious there are a lot of people who want to speak.
She's already spoken.
So if she will forgive me, let me make some progress and let's see where we are. But the point that is really important about this are the following ones. How many people have actually had their UK nationality revoked in a context like this? And to which crimes does this 100-year clause actually impact? Is there a right of appeal to a legal tribunal? There is. And will anyone have their single nationality revoked, completely oblivious of where their parents or grandparents might have come from originally? And the answer to that, in my strong understanding, is that almost certainly no, in 99.999% of the cases. But in the remaining time, can I urge my honourable friend, when he comes to speak about this clause, to clarify, not just for members in this House, but to the nation at large, to reassure them about the nature of the atrocities that need to be committed for this clause to be applied, and the fact that it absolutely does not target anyone of any origin whatsoever. Indeed, if it did do so, my wife, who was Kenyan when I married her, would certainly be affected. There are millions of people who potentially might be affected, and that is where the reassurance is required to make it clear that this is purely about a very simple business of notification when that person is unreachable or in a war zone. And on that note, I will give way to the honourable member.
Thank you. Very glad that the honourable member gave way. I wasn't here in my place when he referenced my speech, but I'd like to ask him if he really understands what the issues are here. The government, as you rightfully said, already have the ability to remove people's citizenship. So why do they want to make it even easier? And why do they want to remove all checks and balance on it? This is where the concern comes about. After what has happened to the Windrush generation, after what's happened to young people who...
Order, I'm afraid we've run out of time on the allotted time. That includes 2 interventions, so I'm afraid that's it. Tulip Siddiq.
Thank you, Mr. Deputy Speaker. I'm grateful for the opportunity to speak in this debate. I come off the back of welcoming Little Amal to Parliament Square. Little Amal is the 3.5-metre puppet which has travelled 8,000 kilometres across the world in order to raise the plight of refugees and in support of refugees. But today I don't rise to speak on refugees. I want to speak about Clause 9, which has been referenced several times during the debate. I know that these powers to strip people of their citizenship are not new powers. I don't need a lecture about what's happened in the past and which government brought it in. But my worry is that the new legislation that's being brought in is actually making the powers more draconian. And that's what I want to talk about. In 2019, we even saw the government justify deprivation of citizenship of people who do not possess dual nationality. They were born in this country and have not even set foot in the country that they were being sent back to. The Secretary of State just said that there was reasonable grounds to believe that the individual would be eligible for citizenship in this country, not even confirmed about citizenship. Yes.
That my honourable friend is describing exactly the situation that would happen to me when I was born. If this bill had been law in the early 1970s, then it's quite likely that I would have been stripped of my citizenship as a young child, and that is what we are talking about.
agree absolutely with my honourable friends. And may I just say that being a middle child, I'm not intimidated by the brave from the opposite side, so I will continue to make my arguments. The other thing that the clause states is that the government does not need to notify someone if they're being stripped of citizenship. And I want to ask the government properly, is there a genuine blockage? Is there data from the Home Office that states that the government cannot enact this law because they've had such problems getting to the person to notify them that the citizenship has been stripped? If that is the case, then could I ask, could they provide the data that shows how difficult it has been made? But also, could I say, is it genuinely a blockage, or is this being done because it gives the powers more power to and more severity? And is it because it means, no, I'm not going to give way, and also because it means that the appeal process has less scrutiny and the decisions have less scrutiny? Is that the reason why? And the government needs to think long and hard. I'm also concerned about how much the government is starting to increase the frequency of this policy. Between 2016 and 2018, 175 people lost their citizenship on national security grounds, but 104 of those occurred in just 1 year, in 2017. It's a worrying trend if the government feel they have to use the powers more and more. Of course, criminals should be locked up and served a sentence, but if a criminal has been born here, raised here, got radicalized in this country, why do we think it is the responsibility of another country to try them? This cannot be right, Mr. Deputy Speaker, and I know this will evoke some reaction from the opposite benches, but the truth is that almost always it's non-white people who are having their citizenship revoked. And before there's any more braying, could I read out the statistic that the new statement's analysis of data from the Office for National Statistics found that 2 in every 5 people from non-white ethnic minorities in the UK are likely to be eligible for deprivation of citizenship. This compares to 1 in 20 characterized as white. We cannot argue about the statistics that are there. In 2016, in the most awful moment of my career, my friend Joe Cox was murdered by a far-right extremist and terrorist. He was tried in this country and locked up in this country. If his skin color had been any different, he should not be sent to another country. The following year, in 2017, Darren Osborne drove a van into a group of Muslim worshippers in Finsbury Park. Rightfully, he was tried in this country and given a sentence in this country. It was not proposed that these convicted terrorists or criminals should have their citizenship revoked. Why is that? Is it because of the color of their skin? And I say this because I genuinely feel, yes, I give that way to John Ottoman, who made a wonderful speech.
I'm grateful. I'm grateful to. She's making some interesting points, but I do think it is really important for us all to understand this is not some sort of act of racism.
No.
Anna Chapman was a Russian spy with dual nationality. She had her nationality revoked, and so I just urge the honourable lady to do the right thing by her old friend Joe Cox. Do the things that bring us together. This is about the good of the nation. It has nothing to do with colour or race. Thanks.
I thank the honourable member for his intervention. And what I would say to everyone is that I am not trying here to flame tensions or play politics. I'm genuinely saying that ethnic minorities in this country are in fear of this clause, and this has created widespread fear in communities. If we start treating non-white criminals and terrorists like they're the responsibility of another country and not our responsibility, we are sending a signal to law-abiding non-white British citizens that somehow they are less British in this country. And I genuinely ask the government to consider this. I'm conscious of time, so I won't give way, but I would say, okay, I shall give way.
To what the Honourable Lady said, I'm very confused. Could the Honourable Lady tell me where exactly in the bill it refers to people's skin colour or ethnicity? Because otherwise it's pure scaremongering and tries to provide division. It does not reference skin colour, it doesn't reference ethnicity. A terrorist is a terrorist, and I don't want them in this country regardless of their skin colour.
I don't feel I could even respond to this honourable member's comment, but I will say, yes, I agree. Terrorists are terrorists, which is why, regardless of what their skin colour is, they should be tried in this country, because they are British terrorists who were born here, radicalised here, and committed their crimes because of growing up here. And I really think maybe the honourable member should go on unconscious bias training, because I'm not sure what else to say to him. But finally, I would say to the minister that they also have to think about whether the powers that they're bringing in are actually compatible with their international obligations as a country.
Yeah. I thank the honourable member for giving way. And would she agree with me that this is perhaps not the best look to say, trust this government with our citizenship, when they are shouting down members that are of an ethnic minority, raising concerns, raising genuine, and shouting down another one, raising genuine concerns on behalf of their constituents and their families.
I thank the honourable member for her intervention. I don't even need to mention, I was born in this country and I was raised here. I don't even need to mention the colour of my skin. I'm here representing people who are genuinely worried about what the powers are contained in this bill and how they feel their lives will be impacted as we move forward. And I would just say, without taking up too much time, that people in this House should consider that the powers that we have in this House will have a severe impact on people who are non-white, are law-abiding British citizens, make up the fabric of our community and do everything right, and now feel that they're being penalised.
And I know emotions are running high on both sides, but if we can take the heat on both sides out of this, because I've heard shouting on both sides, and it's really not helping for the debate. Paul Bristow.
Thank you, Mr. Deputy Speaker, and I rise to speak to Amendment 12 of Clause 9 of the bill. Now, Peterborough is a city of an estimated 20,000 Muslims, and a city full of people who can trace their ancestry to scores of different countries around the world, and many are dual nationals. They are my friends, my colleagues, my supporters, and I speak as the chair of the all-party parliamentary group on British Muslims, something I do with pride. And last week I held a surgery at the Khadija Mosque, and I also met my local branch of the Conservative Muslim Forum. A common experience within British Muslim households and families are stories from first-generation migrants, grandparents and great-grandparents that involve telling younger family members that there may come a time when you'll be asked to leave. Now, despite our shared values, this insecurity is understandable and genuinely felt, because the UK was a very different country in the 1970s. Racism and far-right marches were common. Idi Amin had just thrown the Asians out of Uganda, and even today, incidents of Islamophobia and racism are all too common. Some 93% of Muslims say they feel strongly that they belong to Britain. This does not just apply to Muslims, it also applies to other communities too. But there is nothing in this bill that should make families more insecure. And those that push this perception on social media and in this House spread fear and anxiety, and they should understand the consequences of their actions. For over a century, Home Secretaries have had the ability to remove British citizenship in exceptional circumstances, provided this would not leave a person stateless. There must be significant risk of harm to the public, like terrorism, and there is a right to appeal. This bill makes no changes to these existing powers. Now, there is a legitimate debate to be had about whether it's right that the Home Secretary should have this power, about whether the Home Secretary should have the ability to strip, albeit in limited circumstances, dual nationals of their citizenship. And this was made by my right honourable friend, the member for Houghton, Prowse and Howden. But, Mr. Deputy Speaker, this is not what this bill is about. Clause 9 alters the requirement for the Home Secretary to serve notice on a person in cases where this would be impracticable. For example, if they're in hiding or they're in the middle of a war zone. But to present this as a threat to people living in my city is to scaremonger, and it's shameful. Nothing in Peterborough, nobody in Peterborough is altered by this minor change in this law, and no constituent should feel concerned about their citizenship. Let me just tell you, Mr. Deputy Speaker, what Labour activists and Labour councillors are saying in my constituency. Councillor Amjad Iqbal, a legal practitioner, not a lawyer, a legal practitioner, emails and messages constituents saying, as your councillor, I'm very concerned at some of the policies this government is sharing behind closed doors. As an ethnic minority individual, I wish to share this with you. Please sign and send to Paul Bristow, the MP, whose government is responsible for this fiasco. Behind closed doors, we're debating it in the House of Commons, Mr. Deputy Speaker. Another, Councillor Kayam, says that she has been told that she is ward residents that have been told their nationality cannot be revoked by an MP who has written to them on official letter-headed paper. This is untrue. I can't revoke anyone's citizenship, Mr. Deputy Speaker, and to be sending that message out to people in my constituency is shameful. This misinformation has consequences for some of the most vulnerable people in my city. And one of the kindest, most loving families in my constituency, someone who I helped with a schooling issue, comes to me and they were told by an activist that I wanted to see them deported and deprive them of their citizenship. This is despicable. I know, Mr. Deputy Speaker, why members opposite do this and why the Labour Party do this, because they've got nothing left to say.
Hussein.
Thank you, Mr. Deputy Speaker, and I also rise to speak in support of Amendment 12. Mr. Deputy Speaker, citizenship is a fundamental right that speaks to our very sense of belonging and identity as a person, which is why it is enshrined not just in law, but in the UN Charter, in the Universal Declaration of Human Rights, and in the 1954 Convention of Stateless Persons. Mr. Deputy Speaker, under this Home Secretary, the government have failed to treat citizenship with the reverence and respect which it deserves. In removing the requirement to give notice, the Home Secretary has done away with due process and has expanded her already draconian powers which allow her to deprive anyone of British citizenship, provided that she believes it is in the interest of the public good. Powers, as reference has been made to powers that, according to analysis of the ONS, could potentially impact on 6 million people. Many of those from a Pakistani background, Indian background, Bangladeshi background, Jamaican background, Nigerian background. So let me be absolutely clear, Mr. Deputy Speaker, that this is the group of people that this will disproportionately impact, and that's why this House must vote this down today. Over the last fortnight, Mr. Deputy Speaker, in which I originally raised this, I have had people telling me, like some of the arguments we've heard from the opposite benches, that as long as you don't break the law, then you have nothing to fear from this Home Office. Mr. Deputy Speaker, I absolutely disagree. Working class people from a black, from an Asian, or from any ethnic minority background have everything to fear from this Home Office, because let us not forget that it is this Tory Home Office presided over the mass deportation in the Windrush scandal. It is this Home Office that continues to prosecute a hostile environment against migrants, refugees and asylum seekers. And it is this Home Office that uses Orwell's 1984 not as a warning, but as a guidebook. I therefore have no confidence, and neither do my constituents, that based on their record, the Home Office will not further expand the scope of their powers to deprive someone of British citizenship on more spurious grounds. The powers that the Home Secretary has even now to deprive someone of British citizenship already creates two tiers in society based on foreign ancestry. But removing the requirement to provide notice takes it even further. An individual stripped of citizenship will not be told, will not be given reasons, and will therefore have no right of real appeal. And all of this can happen even as they are being deported. Frankly, Mr. Deputy Speaker, such a move should send shivers down the spine of anyone interested in upholding liberty and due process. And, for those that want to accuse me of sensationalizing the situation, I simply ask them, Mr. Deputy Speaker, to come walk for a day, for a year, for a lifetime in the shoes of someone that the Home Office has decreed as a second-class citizen, and then tell me that you honestly believe that those are not real fears of those from ethnic minority backgrounds in our country today.
Sally Ann Hart.
Thank you, Mr. Deputy Speaker, and I'd like to focus my comments today on Government Clause 9 with reference to new Clause 12, which would amend the deprivation of citizenship powers in the British Nationality Act 1981, currently Section 40, subsection 5 of the 1981 Act requires the Secretary of State to give a person written notice, which has been highlighted by members today, of their deprivation order, the reasons for the order and the person's right of appeal. The power to deprive an individual of their citizenship has been possible for over a century, since the 1914 British Nationality and Status of Aliens Act. It is currently also contained with that British Nationality Act 1981, and Home Office powers to strip British nationals of their citizenship were introduced after the 2005 London bombings and were broadened in 2014. There has been, as we have heard, some criticism of the clause in this House. There has been criticism outside the House. The Runnymede Trust, for example, states that citizenship is not a privilege and that the Nationality and Borders Bill is a threat to ethnic minority Britons. I wholly disagree with this. Citizenship of any country is a privilege, not a right. We are all privileged to be British citizens. It is a privilege which also comes with responsibility. Deprivation of citizenship on conducive grounds is rightly reserved for those who pose a threat to the UK or whose conduct involves very high harm. It is integral to the national security of this country that if an affected person cannot be contacted or because knowledge of their whereabouts derives from sensitive intelligence sources, we can act for this country and our citizens' best interests. Removing someone's British citizenship is a last resort against the most dangerous people who pose a risk to society or those whose conduct involves very high harm. It is rare and always comes with a right to appeal. Deprivation of citizenship on fraud grounds is for those who obtained their citizenship fraudulently and so were never entitled to it in the first place. The Nationality and Borders Bill does not change any existing rights or circumstances in which a person could be deprived of their citizenship, and decisions are made following careful consideration of advice from officials and lawyers and always in accordance with international law. Each case is assessed individually, and when seeking to deprive an individual of their British citizenship on the basis that it is conducive to public good, the law requires that this action only proceeds if the individual would not be left stateless. I will give way.
She's describing a very textbook example of how the Home Office is supposed to work, but in the experience of many of my constituents, their decisions are riddled with errors, with mistakes, with misjudgments all the way through top to bottom, time and time again. The Minister knows that. And the Minister knows this well. Does she agree with me that the Home Office needs to be a lot more careful with the people it's dealing with because they make so many mistakes?
So I would agree with my honourable friend that I also have constituents who've been waiting for 5 years for asylum status to be decided, and I'm sure that the Minister agrees that the Home Office officials that deal with people do need to have proper processes, efficient processes in place. I would agree with that. More generally, Mr. Deputy Speaker, whilst human migration has been going on for millennia, we face increasing global challenges caused by a range of complex climate, economic, social and political factors. We have seen uncontrolled mass migration cause a swing to nationalism in some European countries, and we must not let that happen here. A country which has always welcomed immigrants, we have lived together in a tolerant society that welcomes immigrants. The developed world, including our allies in Europe, need not only to take better measures to control migration, but also better help people thrive in their homelands than face the indignity
and the lack of worth in Europe that they face, where people are exploited or detained in facilities. No man, no woman, no government, nor any faith should be upholding this new form of slavery.
Abdul Khan.
Thank you, Mr. Deputy Speaker. I rise today in support of the Amendment 12, tabled by honourable friend, the member for Holborn Price and Howden. Before I speak about the amendment, I first want to put on record my complete and absolute opposition to this bill in its entirety. This bill is a sham. This Home Secretary is intent on extending her predecessor's hostile environment policies to ensure migrants and asylum seekers feel unwelcome and unwanted in the UK. Not only is the legislation atrocious, but it is poorly written, demonstrated by the fact that government tabled 80 amendments to its own bill after it had already undergone line-by-line scrutiny in committee. Moving now to the issue of Clause 9 in Part 1 of the bill, which Amendment 12 seeks to remove, the inclusion of this clause to allow the Home Secretary to deprive persons of their British citizenship without any warning deeply worrying. More than 60 of my constituents have contacted me concerned about this specific clause of the bill in the last couple of weeks. The government declared that citizenship is a privilege, not a right. They have got it backwards. Citizenship is a right, not a privilege, and this clause represents a fundamental breach of the rule of law. I secured my British citizenship in the 80s after nearly 2 decades in this country. It is people like me and those with migrant heritage who have the most to fear from this clause and this government. Black, Asian, and minority ethnic people, whether they are migrants or not, are frightened of what this government could do to them, particularly in the wake of the Windrush scandal. To deprive someone of their citizenship is a serious undertaking and should be subject to appropriate safeguards. That must include giving individuals a notice. For this reason, I'm supporting Amendment 12, which would remove the clause from the bill. And I want to finish, Mr. Deputy Speaker, with the words of one of my constituents. And she said, as an aunt to 5 children of mixed heritage, as someone with a sister-in-law who is Moroccan, as someone with friends who were not born in Britain, and as a human being who exists in this world, I believe this bill is inhumane, unconscionable, and evil in its intent. Thank you.
I'm going to reduce the time limit just to the 3 minutes now, because I want to try and get as many in as I possibly can. And then I'm going to ask the Minister to respond to the debate at no later than 4:30. Alexander Stafford.
Thank you, Mr. Deputy Speaker, and it's a pleasure to speak on this debate, which I can say that the residents of Rother Valley warmly welcome this bill. But I have been very disappointed with the tone of this debate, especially from the members of the House, especially in regards to the poor victims of the Windrush scandal, which has been an absolute tragedy for this country, and somehow equating this bill with Windrush. This bill, this clause I want to speak on, against new clause 12 in favour of clause 9, is designed to strip the citizenship of dual citizens who are a threat to this country, terrorists, hardened criminals, those people we do not want in this country and should not be part of this country. So to equate those sort of reprobates with Windrush, I think, is deeply insulting and deeply troubling to hear from the opposition bench. It is no more than scaremongering trying to wind people up. Because the bill is not about taking your citizenship without notice, unless it's not reasonably practical to do so. So I want to hear from the opposition benches how you can go, let's say, to an ISIS fighter in Syria and hand them a notice saying, you've been taken away, you're deprived of citizenship. Or maybe to some terrorist in Chechnya and say, excuse me, Mr. Terrorist, please stop shooting people. I'm going to serve you here from the government to give you a notice. It is ludicrous and puts UK government officials in danger. Now, the question this House has got to say is, whose side are we on? Are we on the side of the rule of law and British citizens and British officials, or do we want to send those British officials into harm's way, into the suicide bombs of Iraq and Syria to ISIS to give them a piece of paper? I, Mr. Deputy Speaker, say no. And I hate chanting the central position. I'm very happy to take interventions if they so wish to challenge this. But none are forthcoming because they know that this is the truth. They know this bill very happily.
Thank you very much. The honourable member was describing how people couldn't go somewhere and inform people about their citizenship. How did they notify Shamima Begum, I might ask, that she no longer had her British citizenship? There are clearly ways to do it. And the objection we have on this side of the House is there are already mechanisms that exist in law that allow the government to deprive people of their citizenship. Why do they want to make it easier? With everything that's happened with immigration over the past number of years, that's why people from Black, Asian and minority ethnic communities are afraid, because every time you change legislation, it is worse for people from those communities.
I thank the honourable lady for the point, although I'm a bit confused about it. Shamima Begum was divided on citizenship. First of all, she was found because she was in a refugee camp, and secondly, well, she was a terrorist, and I say good. Good that her citizenship was taken away, and long may we continue taking citizens away from terrorists. But frankly, if you have nothing wrong, and you are not a terrorist, and you are not a threat to this country, you have nothing to fear. And that is the message that's out there. It's such a small minority of cases. Some would argue that we should do this for more terrorists and more of these reprobates. I would definitely support that. Because it's not about targeting minorities. This bill is not about minorities. It's about bad people. And the question which I'm very confused about in this House, once again, is whose side are Labour on? Are they on the side of British people, upstanding, law-abiding people? Or are they on the side of people who want to do harm to the country, to blow people up and cause damage and try and go out of harm's way for us? I'm very confused by the point of view. Of course I'll give way.
I thank the honourable member for Rotherham for giving way. Thousands of constituents in Ilford South are certainly not terrorists. What happens if they decided, for example, to go on a protest about their rights, or a protest against something this government was probably doing to them? Would they then be deemed at what point? Because remember, some of the laws that you're also looking to bring forward over the next couple of weeks are about extending the things that you can be accused of being terrorists for. You know, you could be a climate activist. Are they now terrorists? To someone who's campaigning because their family are Bangladeshis, drowning in Bangladesh because of this government's inaction on climate change, then we said, oh, actually, you're a terrorist, so you're going to have your citizenship removed. The problem is people in Ilford South do not trust this government to take care of minority communities because their track record is so dreadful.
Order. We can't have interventions that last longer than the speech the person's giving. Alexander Stafford.
Thank you, Mr. And I thank the honourable member because it seems to me this is the argument of Labour. They're creating the Windrush of victims, activists as terrorists. They're not actually on the side of British people. They're not actually on the side of the actual victims. They're not on the side of activists. They would rather put up these strawmen and say, but what happens this? What happens if the evil hand of government does this or that? It's complete rubbish. This bill is designed to take control of our borders, take control of who actually lives in this country. Because the people of Rother Valley fundamentally want good people in this country and people who actually know what's going on. This law, and the fact that there's an appeals process after they establish a tribunal, so it's not just arbitrarily taking away. It's actually help people and is looking after our country. So I think Labour are trying a desperate bid to stir up, dare I say, racial tension, because it is racial tension, because it's trying to differentiate. And as the grandson and son of an immigrant myself, I find this deeply upsetting and trying to encourage division in our country when we need to come together to defeat the terrorists, defeat the bad people. This is giving the government no more power than they had before, except for when it comes to notification. And I'd say that protects British officials from going to those war zones and doing it. We're not talking about depriving citizenship for people we can trace, people in the United Kingdom with a postcode, people we can actually go and speak to and deal with. We're talking about those people we cannot have access to. So I don't see why Labour are supporting those people who want to do harm to this country. And I think it's very telling that in order to try and, frankly, scam votes out of people, they're trying to pay to the lowest base. I've given away twice, I won't give more minutes, so I won't give away on this point. But briefly, I want to do another clause. I want to speak to the clause, new clause 4, which the Honourable Member for Romford spoke for, which is a superb clause. I do hope the government has listened to that. Those people, those Hong Kongers who've given service, military service and police service, should be at the front of the queue when it comes to this. And I think the government should look to the Honourable Member for Romford's clause and support it. Because after all, this is exactly what this bill is about. It's about looking after the good people, protecting those that actually have done good things, service for our country, and keeping out the bad ones. And that's why I support it.
Yeah. Ramajit Singh, Desi.
Thank you very much, Mr. Deputy Speaker. And I was proud to add my name to new clause 8, led by my honourable friend, the member from Streatham, regarding the abolition of excessive fees being charged to children. And I hope that the government accepts it. But overall, Mr. Deputy Speaker, this Nationality and Borders Bill is a deeply flawed bill, driven by ideology and destined to have lasting and catastrophic consequences. If it is intended to make our system of citizenship and asylum fairer and more humane. It does the opposite if it's intended to smash the evil gangs who trade in human lives. It does the opposite if it is intended to end the heart-rending tragedy of people dying in the icy waters of the English Channel. It does the opposite if it's intended to make our borders secure and make us safer. It does the exact opposite. Yet the government ploughs on with their hostile environment without thought for the devastating impact that it may have. Ministers have been warned by experts and academics that the bill undermines the UK's commitment to the 1951 Geneva Refugee Convention and much more besides. Given the weight of evidence against the government's approach, one might wonder why they persist. Why indeed? Mr. Deputy Speaker, the removal of ethnic minorities from these islands has been a long-standing fascist demand. On the streets where I grew up, it was translated into something more straightforward and visceral, chalked up on walls or shouted through letterboxes. Send them back. Now, this government is hanging the sword of Damocles over our heads. If you go and do something wrong here, or something perceived to be wrong by the nation of your ancestral heritage, you could be stripped of your citizenship and ordered to go back home. Now, this right-wing rhetoric returns in the Nationality and Borders Bill in front of the House this afternoon. And let's be blunt, Mr. Deputy Speaker. It won't affect your good self because of the colour of your skin, but it will impact people like me because of the colour of our skin, of our ancestral heritage. And what's even more galling, Mr. Deputy Speaker, is that the Prime Minister is getting someone with brown skin colour to do his dirty work with a bill that could have disastrous consequences for black and brown people. No wonder there are accusations of tokenism from within the Asian, African and Caribbean British communities. What's the point of having black and brown people as cabinet ministers sitting on those Conservative front benches if they are going to directly act against the interests of black and brown people just so that they may hold ministerial office? When the military government of Myanmar disempowered ethnic groups by removing their citizenship, many of us shuddered with horror. But people are now frightened, Mr. Deputy Speaker, that this Home Secretary can remove their citizenship at a stroke, can do so retrospectively and without any notice.
Well said, very good.
Thank you very much indeed, Mr. Deputy Speaker. I think it's better to move on from such an appalling speech.
Yeah.
The debate today regarding my honourable friend from Halton, Price and Howden's new clause 12 to replace clause 9 of the bill is quite a straightforward legal matter in this sense, in that on occasion when I've listened to the debate here today, I think honourable members may have been debating a clause that doesn't exist or is not in front of us today. As I referenced in my intervention to the honourable gentleman who sits on the front bench, the Labour government in the Nationality, Immigration and Asylum Act in 2002 and through further legislation in 2016 actually were the people who codified and ensured that a Home Secretary of whatever political party had the power to exclude or to take away somebody's citizenship in certain circumstances. What I don't understand, and that anybody in this House had the opportunity to put forward this amendment today, if there was an objection to that principle, then the amendment should have been laid. But the only amendment that was laid in respect to this was concerning the notice period, and that was it. And therefore, let us have a debate on the notice period, because the one thing that is absolutely certain, if the Labour Party opposed in principle what they did, or what the previous Labour government did in 2002 and 2016, I am absolutely certain an amendment would be put forward, and certainly put forward by the front bench. So if we get to the notice period, what is it that we are arguing about? And some important issues have been raised in respect to that. I thought the member for Leeds Central made a point that I hope the Minister will take into account, that if a order is made without notice, does the appeal process start from the point when the order is made, or does it start from the point when the notice or the order is received, as per is the norm and the law at this moment in time? And I hope he will address that. I think I don't want to go down into some of the things. I could read out, like my honourable friend from Peterborough, a magnificent speech about some of the scaremongering and utterly appalling things that have been said in respect of this. And I find it very surprising, because if it is the case that this government or any other government wanted to do some of the things they are being accused of doing, they could do it now. What does it matter whether they have no notice or no notice? If people, I mean, we had the unbelievable suggestion, genuinely unbelievable suggestion, that this act could be used to address climate change activists. And we know you are genuinely scraping the barrel when it is coming down to that level. I am here to tell my constituents, it has been scaremongering. This is a requirement that is there in very exceptional circumstances to protect them, and no one has anything to fear from this clause at all.
Mohammed Yazin. Thank you very much, Mr. Deputy Speaker. I'm deeply concerned and opposed to the great majority of what has been proposed by this inherently authoritarian bill. Much of this bill appears to be written to satisfy front-page tabloid headlines rather than fixing the broken asylum system. It amounts to a fundamental rejection of this country's international obligations under the 1951 UN Convention relating to the status of refugees, but does nothing to resolve these complex issues at all. Even the government's own impact assessment suggests that measures in the bill could actually lead to an increase in unsafe journeys across the channel rather than a reduction. This bill originally not only tried to criminalize asylum seekers, but also those who try to help and rescue them. I cannot recall a more immoral and wicked piece of UK legislation. I'm disturbed by clauses 9 and 10, which would enable the Home Secretary to deprive UK nationals of citizenship without notice and restrict access to British citizens for stateless children. As a British citizen with the dual nationality, I personally feel the ice-cold chill of those proposals. And I can tell you, it looks and feels like a ramping up of the hostile environment. I will not support a set of laws which create hierarchy of British citizenship. They are trying to reframe citizenship as a privilege, not the right that it is. The message it sends is that certain citizens, despite being born and brought up in the UK and having no other home, remain migrants, so that their citizenship and therefore all their rights are permanently insecure. The law clearly disproportionately targets those of Indian, Pakistani, Bangladeshi, or other racialized groups, regardless of their country of birth. Mr. Deputy Speaker, the racialized nature of this tiered system is obvious. The citizenship of those like myself, many of my constituents, and millions of others of minorities and migrants' heritage is less secure and less important than those who belong to majority ethnic groups in the United Kingdom. It is a shameful piece of legislation, and that should be concerned of this. Much of the bill appears to be written to satisfy a front page tabloid. As I said, it's not in the favor of the communities, and all those communities who like our parents who came here for years and years ago, worked hard to rebuild this country. They are facing this because of this Tory government.
Bergen.
Thank you, Mr. Deputy Speaker. And there's been some powerful speeches. I want to, in particular, pay tribute to the speech by my honourable friend for Bradford East, which the members opposite would have done better to listen to rather than shout at. I want to address the government's clause 9, which proposes removing people's citizenship without notice and, in effect, removing their right of appeal. When people from black and minority ethnic backgrounds raise concerns about this, deep concerns, the response from the government opposite is trust us. Trust us, the people who deported black citizens in Windrush. Trust us, the people who sent go-home vans around working class estates. Trust us, the people who authored the hostile environment. Trust us, the people who are talking in this legislation about offshore detention centres. Trust us, the people who've created an atmosphere where people are trying to demonise people going into the waters of our country, trying to save lives and prevent death. Trust us. It's no wonder that people at the sharp end of this government's hostile environment and the sharp end of this racist legislation don't trust this government. Yeah. It's absolutely appalling. People being made to feel as if they don't belong in their own country. People being made to feel as if they are somehow second-class citizens. Well, let me contrast that. No, it's not because of members of parliament raising these concerns. It's because of the legislation, the racist, divisive, scapegoating legislation that this government is bringing in. I'm not going to give away, you talked enough rubbish before. I want to contrast this with the community event that I attended in the most ethnically diverse ward in my constituency, Gipton Harehills in Leeds on Friday. Young people were there reading poems about their experiences. One poem was read by local residents about how the community has welcomed asylum seekers, welcomed refugees. I think that this government, rather than using the issue of migration as a weapon of mass distraction in order to distract people from the responsibility that the Tory government and its policies has for the misery in their lives, would do better to listen to the message of hope and unity from diverse communities and stop peddling this legislation of division, racism, scapegoating and hate. And I make no apologies for this speech.
Lee Corbyn. Thank you, Mr. Deputy Speaker. I just want to put on record 4 things. First of all, this bill is an appalling piece of legislation. It's designed to appease the most backward elements in our society, and it's designed to chase headlines in the popular media. The attacks on refugees, the attacks on people who support refugees is nothing but appalling and disgusting. And the idea that this country is always in a welcoming place for refugees is simply not true. Often it's been very, very hostile towards refugees. If we were that welcoming, we wouldn't have so many people who've legitimately sought asylum in Britain who are living in desperate poverty because the Home Office can't be bothered to process their applications, and they're living in penury as a result of that. And it would not be criminalising people who are trying to save lives on our shores rather than prosecuting people in the RNLI or anything else. And I think we should all be very proud of those that demonstrated in memory of those that died in Calais, including the 250 who attended a demonstration at the Stade in Hastings a couple of weeks ago. There are 3 parts of this bill I want to make reference to. New Clause 2 being put forward by the member for Crawley, I absolutely support. I've been a member and chair in the past of the Chagos Islanders group for many, many years and worked with Olivier Bancourt and many other Chagos Islanders. We did wrong to the Chagos Islanders in the 1970s and 80s when they'd driven off their land. We've done wrong by them many times since then. And the reason that British nationality was ever offered was because the late Tammy Leal and myself moved an amendment here to previous legislation to try to get recognition of the rights of Chagos Islanders. Unfortunately, the Foreign Office and the Home Office collectively got it wrong, and what the amendment does is actually corrects a mistake that was made, or maybe let's be generous and call it a mistake that was made many years ago, and will grant security to Chagos Islanders living in this country. I also strongly support New Clause 8, put forward by my friend, the member for Streatham. Nationality fees should be based solely on the cost of processing, not as a way of the Home Office making a vast amount of money out of them. And her clause would help to right what is an intrinsic wrong there. And in the remaining 39 seconds I've got, I want to strongly support the amendment put forward by the member from Halton Price, Amendment 12, over the removal of British nationality. Many of us in this House, probably everybody, has been at some point to a citizenship ceremony at our town hall. And they're very nice. They're a moving occasion. All that could be for naught. The Home Secretary could simply remove the right of citizenship to somebody who's gained it in this country or gained it through their heritage. And it requires to remove it the agreement of another country. They're not going to get that. And so we will end up with stateless people as a result.
Thank you, Mr. Deputy Speaker. I want first to support new clause 8, moved by my honourable friend. The Barriers to Britishness report was published a year ago this month, and in his foreword, the Conservative member for South Leicestershire pointed out that the cost of citizenship in the UK is the highest in the Western world, and that, and I quote, "The combined cost of applying to become a citizen in Australia, Canada, the USA and France still does not add up to the cost of a single application in Britain. The fee is almost 4 times the cost to the Home Office of processing an application." This is a hostile environment for hard-working, law-abiding migrant families, and that is the reason that Clause 9 in this bill provokes such anxiety. I know many families on the so-called 10-year route to indefinite leave. 2.5 years leave to remain at a time to be obtained 4 times before they can apply for indefinite leave. They pay extortionate fees every time. Sometimes people lose their jobs because they don't have leave to remain between 2.5 year period ending and the Home Office getting round to granting the next. No recourse to public funds applies throughout that 10-year period, subject to a different amendment we'll debate later on. I told the Prime Minister about a family I know at the Liaison Committee last year. Both parents work, mother a teaching assistant, father in a big international company. The mother's job continued after lockdown. The father was laid off. Lockdown happened in one of the gaps between 2.5 year periods. His employer didn't know whether it was allowed to furlough him under the new scheme, so did not. That family had no recourse to public funds. All they could do was turn to a food bank to survive. The Prime Minister said at the Liaison Committee, hard-working, law-abiding families in that position should have help of one kind or another. I very much agree with him. Unfortunately, they don't. And every 2.5 years, they have these extortionate visa fees. And how people cope with massive fees. And one family I know, that they talk about £14,000 every 2.5 years in order to stay in the UK. For 10 years, no child benefit, even if the children are British citizens, no universal credit if somebody loses a job, no free school meals if the family hits hard times prior to the pandemic. That is the hostile environment for law-abiding, hard-working migrant families, which is why families are so worried about what's in this bill.
Minister. Well, thank you, Mr. Deputy Speaker. It's certainly been an interesting debate, and I would also welcome my shadow, who's, I think, moving on to a new pastures new after this debate. Also welcome my new shadow to his position on the front bench. But this bill did start with at least one positive point from the opposition benches when the SNP spokesperson referred to some of the changes we're looking to correct historical anomalies which have existed for far too long. And the reforms we make in this bill to British nationality law will finally address these anomalies, which will have a positive impact for a significant number of people. It also includes measures for the Home Secretary to grant British citizenship to people who would have become British citizens if not for unfairness and exceptional circumstances beyond their control. So let me turn to some of the amendments. Now, Mr. Deputy Speaker, the government amendments 17 and 18 in relation to deprivation of citizenship are minor and technical and correct a drafting error in clause 9 of the bill. So therefore, it would be an appropriate opportunity to come on and address Amendment 12, tabled by the Right Honourable Member for Halton Price and Howden. Now, we've heard some quite strong comments from opposite about this particular amendment, but let's really go into what Clause 9 does. It amends Section 40 of the British Nationality Act 1981 to allow the requirement to give notice of a decision to deprive a person of their citizenship to be disapplied in certain limited circumstances, such as where there is no way of communicating with the person, or as was quite well pointed out from our friends on this bench, on these benches, For example, if someone is in a war zone, it's rather impractical to suggest that we should ask them to stop shooting so that we can pop up and serve them a notice. And it's absolutely extraordinary to hear some of the comments from opposite implying that we can just simply pop a letter in the post and it'll almost certainly get to them. Clause 9, to be clear, does not change the circumstances under which a person can be deprived of British citizenship. Nor does it remove the right of appeal against a decision to deprive a person of their citizenship. Rather, it preserves the right of appeal in cases where specified circumstances mean it is not reasonable to serve a person with a notice of a decision to deprive. These minor amendments to Clause 9 clarify the statutory right of appeal in deprivation cases is against the deprivation decision itself and not the deprivation order. And as touched on, Mr. Deputy Speaker, deprivation of citizenship is hardly a new concept and has been in operational practice for many years, including under governments of the party opposite. The 1981 Act provides a statutory right of appeal against a decision to deprive. Clause 9 preserves this right of appeal in cases where the notice of a decision to deprive has not been served. Once a person makes contact with the Home Office, they are given a copy of the deprivation decision notice. They can then seek to exercise their statutory right to appeal against the decision. Now, Amendment 12 would remove Clause 9 in its entirety, undermining the integrity of the immigration system and this government's efforts to keep dangerous people out of this country. So again, to reiterate, Mr. Deputy Speaker, no change in scope of who potentially could be deprived, no change in the criteria, and appeal rights still there. And with that, I will happily give way.
Thank you. Can I thank the Minister for giving way? It is important that we are completely accurate on what we're saying. It is true that actually this bill does extend the role of the Home Secretary with regard to notices, because it now places in the power of the Home Secretary the decision that they need not give notice. And let's be clear, if it's not in the interest of the relationship between the United Kingdom and another country, or breathtakingly, otherwise in the public interest. That confers a huge amount of discretion upon the Home Secretary. So this legislation does take our concerns about due process to another plane.
Well, I'm pleased he didn't throw a book at the dispatch box this time. But in terms of what we've just said, no one extra in scope, no change in criteria, and judicial oversight still there in terms of an appeal. This is very clear, let's be clear. We cannot simply allow someone who could be a high harm to this country or who has gained citizenship via fraud to be able to avoid this simply by hiding away or heading to somewhere, for example, perhaps one of the repressive regimes some members opposite seem far too supportive of, to hide away where we cannot reasonably issue a notice. So again, let's be clear what this is about. So we cannot be in a position where we could never deprive someone of citizenship just because it's not practical to pop a letter in the post to them. So I'll now turn on to new clause number 2. This amendment, I'm afraid, would undermine quite a long-standing principle in British nationality law dating back to 1915, where nationality or entitlements to nationality are not passed on to the second and subsequent generations born and settled outside the UK and its territories, creating quite a major precedent. Yet I do hear the very strong points made by the honourable member for Crawley, and to be fair, the member for Islington North. And we'll continue to consider what further we could do, given particularly the low uptake of the £40 million FCDO fund, which was designed to assist this diaspora community. And that's certainly something we'd be keen to look at, including potentially how that could allow them to settle here in the UK. Turning then on to new clause number 4, again powerfully moved by the honourable member for Romford. The government remains extremely grateful to former British Hong Kong service personnel. Now, I know the member for Romford will be aware, under the British Nationality Selection Scheme, a limited number of personnel who were settled in Hong Kong could apply to register as British citizens. And additionally, because innately they were all adults at the time, All such veterans would have been eligible to acquire BNO status between 1986 and 1987. Therefore, we believe most should hold BNO status and be eligible for the BNO route. We do believe granting right of abode would set quite a precedent. However, I am pleased to confirm the Home Secretary has identified an option which will enable our government to treat this group of personnel in a similar way to other non-UK service personnel who at one before handover were based in Hong Kong. And this would be, to be clear, on top of the existing pathways they are already eligible for, including the BNO visa route and any other route they may qualify for. There is some considerable work to be done to fully scope the ramification impacts of this policy and its practical nature to deliver, and I will aim to provide further details to the House as soon as I am able, with a view to a solution being provided before the end of the next calendar year. And I hope that's a reassurance to the honourable member for Romford, because I know his regular chance is not just about having an idea, it's also about having a timeline to deliver it. Moving on then to new clause number 5, which the member for Ashford, another member, spoke very powerfully about, which raises issues around the eligibility for the BNO route, in particular around those who were too young to obtain BNO status before the handover to China, and whose BNO parents or grandparents, who they are former household with, do not wish to apply for the route, effectively do not wish to move from Hong Kong. I would say there are issues with the clause as it is drafted, given it doesn't contain an age limit, and its scope could even extend to those who have actually never set foot in Hong Kong. However, we hear the very strong points that are made, and we very much recognise the importance of our close ties to the people of Hong Kong. I would emphasise that those who are not eligible for the BNO route have a number of other UK immigration routes available to them, not least the very expanded skilled worker route. And individuals from Hong Kong can apply to come, for example, as a student. There is also, as he referred to, the existing Youth Mobility Scheme, which is open to those aged between 18 and 30 and offers a 2-year grant of leave in the UK with a scope to switch into other routes once here, which lead to permanent settlement. There are 1,000 places currently available each year, and it is substantially undersubscribed. We believe these existing measures allow a lot of people to come, but he asked me 2 specific points. I must say we expect 1 or 2 of our new routes being created next year to also open up a pathway to this age group in Hong Kong, alongside others. First, if it was unilaterally, if the other side unilaterally acts their provision, that would not automatically change the immigration rules here in the United Kingdom. That would be something we would have to do to close the route in terms of applications by Hong Kong nationals. I would be clear that if unilateral action happened, which further damaged the rights and abilities of people in Hong Kong, then of course the government would look very closely at whether it maintained the scheme, whether something else be put in its place, or whether we could continue to just, let's say, allow this to go forward. And I would make the point that we have a number of very successful YMS schemes. And in terms of the timeline for application, I would say that whatever route we put in place, I wouldn't want to be used on general, there would be a period of time between between applying and getting a decision. But certainly we're happy to look again in the context of our simplification process and the fact that we've moved to create, in some cases, wholly digital pathways to apply to the BNO route for Hong Kong citizens. Certainly happy to look again at whether some of those principles could be applied to the YMS in Hong Kong. I noted the comments from the honourable member for Delyn. I would say we very much welcome and value the contribution of overseas workers in the NHS, and that's why we introduced the health and care visa. I would say, though, that making changes in one area would require potential changes in others, including to routes some other NHS staff are on. I'd also point out that the amendment itself would see the applicant, if they left within employment within 3 years, having to pay the fee. I can understand why he thought to put that in. However, this would be quite a novel approach and would be very difficult for the Home Office to actually operationalise and inevitably require enforcement with it. So that is why we don't think this is the right step that's approached. In terms of children registered as British citizens, I'm grateful again for the opportunity to debate this under new clause number 8, but I would be clear that we are still waiting for the Supreme Court to give its judgment on this issue, and we will then look to respond to that. In terms of new clause 33, we don't believe we can accept this amendment And we believe all applicants for UK nationality should be treated the same in terms of the test they apply. But we are considering how this issue overall could be picked up as part of our work on simplification, and not just applying it to those who hold settled status under the EU, potentially wider ILR holders. So, although we won't accept today, I hope the honourable member will be pleased to hear we are very much closely looking at this work. And I would again emphasise, as I've said many times before, no one has been refused of British citizenship purely on the basis of the CSI requirement that sat in free movement regulations. Turning to Amendment 2 from the Right Honourable Member for Orkney and Shetland to remove Clause 10, unfortunately, we are seeing an increasing trend of application for children whose parents did not take the step of registering their child's birth with their embassy or High Commission, leaving their child without a nationality. Concerns about the use of this route were confirmed by Home Office sampling, given the request for data. Of over 200 cases sampled, 96% of parents were Indian or Sri Lankan. Crucially, where a child born in the UK to a parent from those countries can only access their citizenship if the parent registers the birth at the relevant High Commission. To register the child's birth, they would need to comply with the requirements set. Within the sample, 90% of Indian and Sri Lankan parents had chosen to contact the High Commission to obtain a letter to show their child was in fact not a citizen, and so clearly had no problem in approaching their authorities. And in many cases, the parents had, I think it's safe to say, a checkered immigration record, with only 16% of parents having permission to be in the UK at the time of the child's birth. In 67% of the cases, the parents had obtained leave to remain in the UK as a result of a child's applications. So I would again say this points to why we believe this is a clear concern. In terms of quickly dealing with Amendments 110 and 111, Amendment 110 would mean, in practical terms, parents who had chosen not to register their child's birth could argue it was not in their child's best interest to have their nationality. And this could create some obvious issues and concerns about actually creating quite an argument when in reality this isn't really something that they should be doing, certainly not for an immigration benefit. So overall, Mr. Deputy Speaker, we believe that the package of measures that are in the bill are fair and proportionate. And I would again say, as many members have reflected in their interventions, some of the scaremongering we have seen about some of the provisions in this bill are nothing less than shocking. People who would never be in the scope of the tight criteria for deprivation of citizenship, those who committed the worst offences or are literally overseas committing war crimes, that is never going to apply in the way honourable members opposite have suggested. And therefore, I'd urge the House to reject some of the nonsense we've heard and vote to support these measures, which will transform our migration system and make sure we have a nationality system that's fit for purpose.
The question is that new clause 2 be read a second time. As many of that opinion say aye. Aye. The contrary, no. No. Division, clear the lobby. Order. The question is that new clause 2 be read a second time. As many of that opinion say aye.
Aye.
Or the contrary, no.
No.
Tell us for the ayes, Andrew Rosendale and Patrick Grady. Tell us for the noes, Craig Whitaker and Scott Mann. Lock the doors. Order. Order.
The ayes to the right, 245. The noes to the left, 309.
Thank you. The ayes to the right, 245. The noes to the left, 309. So the noes have it, the noes have it. Unlock. Order, order. Under the order of the House of today, I must now put the questions necessary to bring to a conclusion proceedings on the new clauses and amendments in this group. New clause 8 has been selected for separate decision, and I call Bel Ribeiro Addy to move new clause 8 formally.
I beg to move.
The question is that new clause 8 be added to the bill. As many of that can say aye. Aye. Of the contrary, no. No. Listen, clear the lobby. Order, order. The question is that new clause 8 be added to the bill. As many as of that opinion say aye. Aye. Of the contrary, no. No. Tell us for the ayes, Mary Glindon and Tayo Owatemi. Tell us for the no, Scott Mann and Craig Whitaker. Lock the doors. Order. Order.
The ayes to the right, 237. The noes to the left, 323.
Thank you. The ayes to the right, 237. The noes to the left, 323. So the noes have it. The noes have it. Unlock. We now come to Government Amendments 17 and 18, and I call the Minister to move Government Amendments 17 and 18 formally. The question is that Amendments 17 and 18 be made. As many other friends say aye? Aye! No, I think the ayes have it. The ayes have it. We now move on to Group 2, and we begin with the Government New Clause 20, with which it will be convenient to consider the other selected new clauses and amendments as listed on the selection paper. And I call the Minister to move Government New Clause 20.
Thank you, Mr. Deputy Speaker. And if I may, conscious of the wide interest that there is in the House this evening to debate a significant number of amendments, I will keep my remarks focused predominantly on the government amendments in this first instance and deal with a number of matters in the wind-up later on in the debate. Mr. Speaker, Mr. Deputy Speaker, our asylum system must not reward those who enter the UK illegally and from manifestly safe countries where they cannot possibly still be fleeing persecution and fear. You must claim in the first safe country you come to, and making that secondary and unnecessary movement to the UK puts lives needlessly in danger while pushing aside other vulnerable people, including women and children, from the system. We must break those criminal networks that facilitate illegal immigration and exploit people. If you come to our shores illegally, you will be treated differently. And while we cannot resettle everyone across the world who needs sanctuary, those large numbers who we do resettle in the UK will be made very welcome. We will be fair but firm in how we continue to embark on this landmark reform of our asylum system. Let me address the government amendments in this grouping. Mr. Speaker, new clause 20 on justice of the peace Northern Ireland is a minor and technical amendment which will ensure that a small number of references to justice of the peace in the context of obtaining entry and search warrants in immigration legislation become instead references to lay magistrates in Northern Ireland. Simply put, this is a simple measure which tidies up the statute. I will give way to the Right Honourable Gentleman.
I'm extremely grateful to the Minister for giving way, and the point he makes about claiming asylum in the first safe country is critical, because the people traffickers rely on the idea of selling a destination, regardless of where the person starts. The measures he's described will frustrate them and do a great service both to this country and to their many victims.
Well, I'm very grateful to my right honourable friend, and not for the first time I find myself agreeing with him wholeheartedly. It is fair to say that nobody needs to get in a small boat to reach safety. France is a safe country with a fully functioning asylum system. The same applies in Belgium, the same applies in Germany and across the European Union. All that people do by getting in a small boat is hand over very, very significant sums of money to evil individuals who treat people as cargo with no regard whatsoever to human life. We have to bring this to an end, and that is precisely what we are seeking to do through this bill. And I look forward to my right honourable friend's support in the division lobbies, as we've seen from him up until this point during the passage of this bill. Government Amendments 19 to 25 to Clause 12 are also a small technical amendment. The amended clause enables the provisions within it to apply to asylum seekers or failed asylum seekers supported under existing legislation if and when uncommenced provisions come into force. Amendment 26 to Clause 15, related to reasonable period, seeks to amend the bill provisions relating to the inadmissibility of asylum claimants with a connection to a safe third country. This government is clear that people should claim asylum in the first safe country they reach, as I've set out, rather than make dangerous journeys to the UK to claim asylum here. Inadmissibility is a long-standing process designed to prevent secondary movements across Europe, and inadmissibility measures are being moved from the immigration rules into primary legislation to support this. However, we acknowledge there are circumstances where it may be appropriate to consider these cases here in the UK. We are removing the power to consider an asylum claim that has been declared inadmissible here in the UK, where it is unlikely to be possible to remove the claimant to a safe third country within a reasonable period. This will instead be set out in the immigration rules. Mr. Speaker, Mr. Deputy Speaker, I now turn to Amendments 27 to 38, 44, 45 and 91 to 93, relating to the evidence notice and priority removal notice. The Asylum and Immigration Act 2004 requires decision makers to take into account certain behaviours that may be deemed as damaging to a claimant's credibility when assessing a protection or human rights claim. This includes concealing information or obstructing or delaying the handling of a claim, providing late evidence, not acting in good faith, and behaviours that are designed or likely to mislead. It is right that all decision makers, including the tribunal, should clearly set out when and how they have taken into account the claimant's credibility when assessing a protection or human rights claim. Mr. Deputy Speaker, the remainder of this group of amendments are minor and technical and make sure that all the measures relating to the priority removal notice operate in the manner that was intended. I will give way.
Very grateful to my honourable friend for giving way, and what he's just stated there is actually not unique to my honourable friend, but actually was stated by former Labour Home Secretary Charles Clarke, who said it is simply not acceptable to destroy identity documents, use false passports, lie about your personal history, refuse to say how you reached this country, or any other device which the people smuggling gangs employ to make their money. Asylum seekers who knowingly commit such acts should lose their right to asylum in this country and be returned as soon as possible to their country of origin. He was right, wasn't he?
Well, I'm very grateful to my honourable friend for his intervention, and I think that any right-minded or fair-minded person would think that it was entirely appropriate for people to engage with the immigration system in this country in an appropriate manner that does comply with the evidential requirements that we have, and that means that people comply in the spirit of goodwill, because inevitably what we want to do is provide sanctuary to those in need of sanctuary at the quickest opportunity possible. That is entirely what our reforms are seeking to achieve, And of course, we also think that it's right and proper, and I think the British people think it's right and proper, to remove those who have no right to be here.
Will you give way?
I will give way.
Very grateful to
The Minister, what impact does he think this legislation, if carried in the way he wishes, would it have on this awful, vile trade through small boats? Would it stop it? And is there a danger the UK courts will overturn the intent?
Well, I'm very grateful to my right honourable friend. I think that the measures in this bill are significant. We have recognised, the Home Secretary has consistently recognised, and I recognise as the Minister responsible for tackling illegal immigration, that the asylum system in this country is broken at present. And it is unacceptable, the length of time that it takes to process claims, and we need to improve the situation. And of course, the government's intention is a very clearly stated one, which is to improve the way that we process claims. We expect individuals seeking to claim asylum in this country to comply with the requirements, but of course there are safety nets in place through good reasons that mean that if people can't meet those deadlines, that will be taken appropriately into account. But we do believe that processing claims more quickly, removing those with no right to be here, and progressing forward on that basis is going to make quite a significant difference. But also, and this is important too, it is also about the work that we do, not just with our nearest neighbours in France and in Belgium, for example, and that collaboration is important and is delivering results. And of course, we want to secure a returns agreement that will help to build on that. But also, the work that we do further upstream, removing those with no right to be here back to source countries. I will give way.
Yesterday, in a scathing attack on this bill, Welsh Government Cabinet Ministers issued a statement saying that this bill undermines Wales' desire to be a nation of sanctuary and will exacerbate inequality and harm. In their words, Wales is a welcoming nation and will always stand with those who need us most. Yes, Minister, we do keep a welcome in the hillsides and the valleys of Wales. So will the Minister therefore scrap this inhumane bill, end the hostile environment, put in place safe and legal routes and stop undermining the responsibilities and aspirations of the devolved nations?
Well, I think the short answer to that rather long intervention is no. And it isn't the first time that I perhaps find myself disagreeing with Labour politicians. And I'm afraid on this one with the Welsh Government, I do disagree. I think that this country has a very proud record, all parts of this United Kingdom have a very proud record of welcoming people to this country who are fleeing persecution and conflict from around the world, and that tradition will continue. And I'm sure that the Honourable Lady knows that that tradition will continue, but we also have to have a system in this country that is fair but firm, and that means that the abuses that we have seen in the system previously and to date come to an end, because actually those that are not acting within the spirit that I think all of us would like to see are actually making it more difficult for genuine asylum seekers who are seeking sanctuary. And inevitably, there is considerable resource. There are considerable resource implications associated. I will give way to the right honourable gentleman.
Ask him if he could just think for a moment what it is like to get into a small dinghy and try and cross the channel. What sense of desperation you must be in to risk your own life in order to try to get to what they believe to be a place of safety. I'm not defending people traffickers or criminal gangs. I'm just saying that we have created a situation in this country and across Europe where we leave desperate people with no alternative but to turn to ruthless people in order to try to get to a place of safety and contribute to our society. Can I ask him, has he got any humanity?
Well, I'm afraid that the intervention is a very disappointing one, in the sense that I would not for a moment suggest that he is doing anything that supports people traffickers. Of course not. But what I would say is that I think he is giving credence to their business model. And I think that that is highly unacceptable, disappointing, and I think he should reflect upon the position that he takes in relation to these matters. As I've set out, nobody needs to get into a small boat to seek to cross the channel to reach safety. The idea that anybody is in danger in France is utterly farcical. And he really should reflect upon this. The bottom line is that France is a safe country with a fully functioning asylum system. That is a fact. He needs to reflect on that, I would argue. I will give way to my honourable friend.
Thank you, Mr. Deputy Speaker. Where the former leader of the Labour Party was absolutely right, of course, is what he was trying to say, Minister, was that the French are failing in their own country to look after the people there. And in that regard, he's right, isn't he?
Well, I think it's probably fair to say that his own benches quite regularly try to reinterpret his comments. But look, in the end, it is highly unacceptable for anybody to get into a small boat. And I recognise, and I think it's fair to say, that this House speaks with one voice in saying that people should not be making those dangerous crossings. And we perhaps just disagree about how we render this route unviable. But this government has brought forward a comprehensive bill as part of the wider package of measures that we are seeking to introduce to address this issue. And it's disappointing that some others in this House seem to have quite a lot to say in complaining about our approach, but don't actually have a viable alternative to our policy. I will give way.
Having sat through hours of this debate this afternoon, I've been shocked, but I shouldn't be surprised by some of the smearing and the scaremongering that we have heard. Is it any wonder of some of the communications that we receive? Now, there's much to support in this bill, but as the Minister says, the immigration system is clearly not working. But where I'm struggling with it, and where maybe we may be able to take more people with us around resettlement, the government has rightly promised that the bill will provide new safer routes that can help address the channel crossings. But can I ask the Minister whether the Home Office now has plans and can provide more detail on that for more resettlement schemes for safe routes?
Well, I'm very grateful to my honourable friend. And of course, one of the things we've been very clear about is that we want to expand community sponsorship in particular. But there are also a number of schemes that are already being delivered that are making a considerable difference. We shouldn't forget that 15,000 people were airlifted out of Afghanistan over the summer. We shouldn't forget the fact that the BNO route in relation to Hong Kong is a valuable and important route that is helping to provide sanctuary to many individuals, and that is an ambitious offer that we have made. I will give way to the honourable lady.
Isn't the reality this, that there are people who come to France fleeing their country of origin with the desire to come to the United Kingdom? And will the Minister look at new clause 10 in the name of the Honourable Gentleman for Bermondsey and Old Southwark, which I'm a co-sponsor of, which puts forward a humanitarian visa scheme to enable people who are in France to start their application process off in France to come to the United Kingdom? Now, we spoke about this in the Joint Committee of Human Rights last week, and he said he was going to go away and verify whether that suggestion had ever been put to the French. Has he been able to verify that for me?
The honourable lady does come to this debate with ideas and suggestions about how we tackle this issue. But what I would say is that I disagree with her in terms of the suggestion that she makes in relation to this. Of course, in order to have a system like that in place, the French would have to agree to it. I think it is fair to say that there is considerable concern about the number of movements across France as things stand already. And I think it is fair to say that whilst offered in the spirit of cooperation and in the spirit of trying to be constructive, I think that that is where I'm afraid that the Honourable Lady's suggestion falls down. I'd like to make some progress, if I may, Mr Deputy Speaker, in relation to amendments 39, 40, 41, 42, 43, 46 and 47, which clarify the government's intention that appeals should remain in the expedited appeal process wherever possible. The revised text, which reflects wording in the primary legislation which sets the statutory framework for tribunal rules, specifies that judges should only remove an appeal from the accelerated or expedited process where there is no other way to secure that justice is done. Amendments 48 to 50 are minor and technical amendments to clause 34, an internal relocation. The amendments clarify the ambiguity in the current drafting that has the potential to be interpreted in an unintended way, where an individual could only be internally relocated within a country where they had previously been in that part of the country. I would now like to move on to the purpose of amendments 51 to 59, which is to increase the maximum penalty for the existing statutory offence of overstaying, which is currently 6 months imprisonment. The 6-month imprisonment maximum penalty dates back to the original Immigration Act of 1971 and is no longer considered sufficient for the present day. Given how much the world has changed over the last 50 years, the existing penalty hinders our ability to deter overstayers, and we consider that raising the penalty would encourage better compliance. Clause 39 introduces a new maximum penalty of 4 years to align with illegal entry and other similar offences which have already been amended during the passage of this bill. Mr Deputy Speaker, at committee stage, I promised to bring forward amendments to protect the RNLI, individuals rescuing persons at sea, and those in charge of vessels who find stowaways on board, and I'm pleased to say that these are now set out in Amendments 60 to 63, and I'm grateful to members from across the House who had raised concerns in relation to this, and I'm delighted to be able to put this matter beyond doubt this afternoon. I will give way.
I'm grateful to the Minister for giving way. My constituency may be landlocked, but I grew up on the Cape Coast where many of those who cross the Channel land. And I continue to donate, as do many of my constituents, to the RNLI. We all know that those who volunteer to serve do so selflessly, and they often leave their own place of work in order to go to sea or to go and support from a land perspective. So will he join me in taking this opportunity to thank those who volunteer for the RNLI from the Dungeness, Littlestone, Dover, Walmer and Ramsgate stations?
Well, I'm very grateful to my honourable friend who makes the case so eloquently for the RNLI and sets out the incredible work that those volunteers and those individuals do to protect life at sea, along with many other agencies such as Her Majesty's Coast Guard, who do work tirelessly around the clock, often in very, very difficult circumstances. And so I would certainly like to join her in placing on the record the government's thanks and appreciation for everything that they do, and to the individuals in her local area who do this tireless work day in, day out, week in, week out. We have provided a clear and unambiguous statement that persons do not commit an offence of facilitation if the act is done by, on behalf of, or coordinated by Her Majesty's Coast Guard or overseas equivalent. This provides protection not only for organisations such as the RNLI, but also individual seafarers who respond to Mayday relays. I will end by addressing Amendments 94 and 95, which represent one of a number of measures we are bringing forward within this bill to strengthen our efforts to tackle the issue of clandestine migrants seeking to enter the UK in vehicles. We will work with representatives of the transport industry in order to devise and set new regulations that detail how to secure a vehicle, conduct checks on vehicle security, report attempts of unauthorised access, and keep evidence confirming that steps have been taken to prevent unauthorised access to the vehicle. These changes are necessary as a high proportion of drivers and hauliers continue to fail to properly secure their vehicle, often running the risk of being targeted by migrants or relying upon going undetected. There is a human cost to this traffic. Criminal gangs are preying on vulnerable people and shipping them across the UK border like human cargo. We must all take responsibility for preventing this. And with that, I draw my remarks to a close, and very happy to pick up on the various other aspects that will no doubt be raised in this debate during the wind-up.
References to justices of the peace in relation to Northern Ireland.
The question is that new clause 20 be read a second time. Vamos, Sharalambo.
Thank you, Madam Deputy Speaker. Madam Deputy Speaker, this bill is a sham. It does nothing to create safe routes for resettlement. It does nothing to garner international support for breaking people smuggling gangs, and it does nothing to support victims of modern-day slavery. Instead, the Nationality and Borders Bill creates unworkable policies, lets down victims who've been trafficked, and breaks out international obligations. This bill is a smoke and mirrors trick designed to deflect attention from the government's failings and incompetence in the area of asylum and refugee protection. Madam Deputy Speaker, it's shameful that since the abandonment of the Dubs Amendment, the UK has turned its back on unaccompanied child refugees and young people in need of protection. And looking at the young people that are having to turn to people smuggling gangs, we need to make sure that this model is broken. People have died during the dangerous crossings, and it's important that we tackle the criminal people smuggling gangs. To do this, we need international cooperation and greater security. And that is why we on this side have tabled new clause 50 to make the advertising of people smuggling routes by social media an offence. And if the government is serious about tackling the gangs, we cannot see why they will not have any problem supporting this new clause. Smugglers and trafficking gangs are putting people's lives at risk, and we know that they use social media to promote, encourage and advertise and organise these dangerous crossings. But when the NCA ask Facebook and TikTok and others to take down dangerous material, too often they refuse. We have to strike at the heart of this illegal and dangerous operation, and this is why we are proposing a new and additional criminal offence. It does not replace existing offences, but creates a new offence to make clear beyond doubt that this is illegal, as well as dangerous, and as well as prosecuting those responsible, we also expect social media companies to take the dangerous material down. It's well known that dangerous routes are promoted by people smugglers on social media platforms, including Facebook and TikTok, and often with promises of easy journeys at an extremely high cost. If those interested are told to send private direct messages to smugglers because they know that private conversations are encrypted, that is much more difficult for police intelligence agencies to access. And if the government is serious about tackling the criminal gangs that are profiting from people's desperation, it must therefore take urgent action to tackle the problem online. At the moment, the government are talking tough on the issue, but the policing and intelligence response is failing to keep up. The government should therefore back Labour's new clause 50 today, and those who are seeking to profit from people's desperation online must be made to feel the full force of the law. As everyone in this chamber knows, the Dubs Amendment, which was passed in May 2016 by David Cameron's government in the wake of the increase in refugees arriving from Europe, required ministers to relocate and support asylum-seeking children from the continent. The Dubs scheme was initially envisaged to offer settlement to 3,000 children, but it was capped at 480 places. In May 2020, it emerged that this smaller quota had been filled and the scheme was then abandoned. Ever since, members of this House and from across the political spectrum have warned that this bad decision would mean hundreds of vulnerable children being forced to turn to people smuggling gangs to assist them with travelling to Britain, placing them at greater risk of trafficking. The government's inaction on this matter has been deeply depressing. Ministers have shown a callous disregard for the plight of children. In the past, when debating these issues, the ministers have made shameful claims about so-called pull factors for refugees being made as one of the reasons not to help unaccompanied children to safety. I'll let the honourable member give way.
The opportunity to intervene. Does the honourable member recognise that since 2015, the numbers of unaccompanied children arriving into the UK and going into the care of local authorities have doubled from an average annual run rate of just over 2,000 to significantly over 4,000, and that the Syrian resettlement scheme included an element of specifically identifying vulnerable children and bringing them to the UK as a place of safety? So does he accept that it is simply not true to say that the government has turned its back on refugees?
Yeah. At the moment, there are no safe routes for children to come to the UK, and there are no routes that allow that to happen. And that is why we've seen an increase in the crossings, and we're seeing more unaccompanied children crossing. I will give way.
Because I've heard a lot about attacking what the government is trying to do. I've heard a lot about social media, and now we're hearing something about children. And I have some sympathy with the Dubs scheme, and indeed the Shadow Home Secretary and I have tabled amendments in the past in support of that. What I've not heard in any of the amendments being tabled, in any of the debates, is a single practical measure that his party would take, which would deter adults actually from taking to those boats and taking on those serious and dangerous journeys and paying the people traffickers to do it. What exactly is Labour's plan for real solutions for a very serious problem? Because I've heard not a single solution yet.
Well, if the honourable member will allow me to continue, you may be interested in clause 49, which does address this point that he's making. I'll try and make some progress because I was told off previously for taking too long in taking interventions in the last debate. In relation to the Dubs Amendment, we believe it is time for the government to show global leadership on this instead of shirking for its commitments as enshrined within the Refugee Convention. So we would very much urge the government to support our amendment, which proposes the reintroduction of dubs. Madam Deputy Speaker, this leads us on to our new clause 49. In this new clause, we're asking the government to produce a negotiating mandate setting out proposed reciprocal arrangements with the EU for safe returns and safe legal routes. These reciprocal arrangements were previously covered by Dublin III agreement, which has now ended. It is actually ridiculous that the government is now resorting to dangerous tactics such as pushbacks in the Channel when we used to have civilised reciprocal agreements with our geographical neighbours. These agreements... I'll give way.
Thank you. I'd first of all like to thank the Shadow Minister because the Minister would not. The whole point of this bill by the government seems to be that they think that this will end small boats crossing the Channel. But actually, as the Shadow Minister's just said, the ending of Dublin III is what's increased the number of small boats crossing the Channel. Doesn't he think that in 3 years we're going to be back here with even more small boats, with even more children and adults dying in the Channel because of this bill?
My honourable friend makes an excellent point. It is deeply worrying that without reciprocal arrangements, that this very bill will actually fail, because without those, it will just encourage more dangerous crossings. On that point, but then I must make progress.
He's making his speech in a very quiet and reasonable way, but don't you think the problem is the fact that the French are refusing to allow the return? Is the problem at the moment? It's not this country, it's the French, isn't it?
Well, I agree with the honourable member, but this is directly because we don't have reciprocal arrangements. We used to, we don't have any more, and this is at the crux of the problem with the bill. We need to have more reciprocal arrangements with our international partners to allow other measures to be put in place. I will make, Madam Deputy Speaker, I will make progress. The agreements that we had previously, such as Dublin III, gave people who are eligible a safe route here, and it was also allowed us to send people to the other safe countries when it was appropriate. It is well known that family reunion leads to better outcomes in terms of the ability of people to integrate. It is also well known that it is only with international cooperation that we can hope to expect other countries to accept the safe return of individuals where appropriate. We therefore believe that new clause 49 is a sensible and proportionate measure to tackle the issues that we face. Madam Deputy Speaker, this brings me on to new clause 51, which does two things. First, it places the Afghan citizen resettlement scheme on a statutory footing to make sure that it is fully implemented. Second, it calls on the government to draw up the scheme in a way that also helps prevent people being exploited by people traffickers and smugglers. The government has accepted that safe and legal routes are important as an alternative to dangerous routes run by criminal gangs, but it either hasn't implemented or designed safe legal routes that do this. This is why we are proposing that the resettlement scheme be designed in a way that allows those who are fleeing persecution in Afghanistan and who have family in the UK to be able to apply to be included in the resettlement scheme. So this would be a specified opportunity for family members to apply within the scheme. The government has already consulted to see that these family members don't end up being exploited by criminal gangs, promising them a route to reunite with their family members. So we see no reason why this should be controversial and why the government won't open the scheme and allow family reunion within it. It's been absolutely shocking to hear firsthand the stories of desperate people who are eligible to come here from Afghanistan being effectively abandoned. I have achieving scholars who have contacted my constituency office who have been left without any support at all and without any prospect of a safe route from the country. Other MPs have told me about people who worked closely with the British who have now also been left vulnerable. Interpreters, women who worked as lawyers, and many others whose lives are under threat from the Taliban. Again, if the government is serious about drawing people away from the people smugglers and offering the safe routes to do so, then they need to get a grip of the situation. I'll give way.
Thank you, Madam Deputy Speaker. And I'm grateful to my honourable friend for making this point. Does he agree with me that at the core of this is the poor quality of our relations with some of our nearest neighbours, and indeed our falling standing in the international community, which I'm afraid is, if I may finish, and I'm afraid that is a result of government policy over Brexit and a number of other matters, Will the honourable gentleman agree with me on that point?
Well, as I previously said, that international cooperation is at the root of dealing with the problems that are purported that this bill will address. Ministers have talked a lot about. I will give way one last time, but I really must make progress.
The honourable gentleman for giving way. Just as a point of clarification, with the previous intervention, the comment was made that Brexit was a government policy. Would he like to just agree with me that the government was fulfilling the mandate of the British people at a referendum?
Yeah.
I think we've already had that debate. I think it was the last Parliament. I think that safe and legal routes, as proposed by the Dublin III Amendment, need to be replaced now that we have left the European Union. And this is something that's absolutely integral to make sure that we do have the measures in place to deal with the problems that we face. Madam Deputy Speaker, ministers have talked a lot about the Afghan resettlement scheme, but where are the results? We've been waiting since August for the scheme to be implemented. It still hasn't. People are dying. They do not have 4 years to wait. And it's now time for action and not words. Madam Deputy Speaker, I also believe that we should be looking after people who put their lives on the line by loyally serving the nation. And it's nothing short of outrageous that visas for foreigners who have served in the UK Armed Forces currently cost £2,389. In 2020, there were 5,110 Commonwealth citizens serving in the armed forces. Each year, around 500 of those choose to leave, and those who choose to stay in the UK are compelled to pay extortionate visa fees. A government consultation has, as we know, proposed scrapping the fees for those who have completed 12 years service in the armed forces. And Labour has campaigned long and hard for this change to happen. And we believe that this proposed qualification period is far too long, and we're calling on the government to right this wrong and change the period of qualification. And I'm grateful to the two largest veterans charities, the Royal British Legion and Help for Heroes, for their campaigning work that they've done on this issue. They are clear that they think that the current situation is gravely unfair. And Madam Deputy Speaker, it's really time that the government started honouring its promise to the armed forces. I'll give way on that point.
Honourable friend for giving way on that point. And I've met many of the Commonwealth soldiers in my own constituency, the Fijians who've worked very closely alongside Welsh regiments, others from other foreign and Commonwealth backgrounds who have come into our armed forces. And indeed, I think it makes up something like 11 or 12% of the army recruitment at the moment. I've heard horrifying stories about how they've been treated in relation to visas and settlement, but also in terms to, as my honourable friend has exposed, in relation to, for example, healthcare costs. It is completely wrong for that to be happening, for them to be treated in this way when they've served our country so bravely.
Yeah.
He's absolutely right. To ask servicemen and women to pay for the privilege to live in a country that they fought for or were prepared to defend is completely unreasonable. Madam Deputy Speaker, the current situation is frankly embarrassing, and we ask the government to do the right thing and waive fees for those veterans seeking citizenship. I'll give way one last time, but I must make progress.
Very generous. Does Labour think there should be any limit on the number of people we invite in each year as migrants? And if so, what should that limit be?
As I've made clear, we are supporting, I'm speaking in relation to the Commonwealth veterans who are fighting for us, defending our country. And on that level, we very much support waiving the fees for them to become British citizens. Madam Speaker, I'll move on. I believe that I'll deal next with Clause 11. Clause 11 is a particularly pernicious part of the bill. As well as creating two tiers of refugees, it also seeks to criminalise some refugees according to how they arrive in the UK. Criminalising people who are seeking our protection is a clear breach of the Refugee Convention and our obligations under international law. And let us consider the implications of this. Under Clause 11, it's possible that an Afghan national facing persecution from the Taliban, or Uyghur Muslims facing persecution in China, or a Syrian national facing persecution in Syria could all be criminalised. They could be criminalised merely for the way in which they arrived in the UK. Yet their claim for asylum or persecution that they faced has not been lessened because of the means of arriving in the UK. Of course it hasn't. And whilst the government are doing little to secure safe and legal routes for persecuted groups, it's simply cruel to criminalise people escaping torture or death. Moreover, no evidence has ever been produced that this will deter these irregular journeys, as the government claims. Madam Deputy Speaker, as the Joint Committee on Human Rights report has pointed out, this bill is littered with measures that are simply incompatible with human rights law and the UK's obligations under international treaties. This is one of the reasons why we believe that Amendments 105 and 98 are necessary. By removing the term "for gain," the government is creating a situation where anyone in the Channel helping people in distress, as is their duty under maritime law, could be criminalised. This is clearly wrong both morally and legally, and therefore we strongly urge the government to accept this amendment. It is equally the case as stated in Amendment 98 that there should be safeguards against endangering life at sea. As the Joint Committee on Human Rights has recommended, it must be made certain that maritime enforcement powers cannot be used in a manner that would endanger lives. Madam Deputy Speaker, this is a bad bill, and we hope that the government will take heed of the amendments that we are supporting. Only through international cooperation, safe and legal routes, and targeted measures against the criminal gangs with our international partners can we improve the current situation.
Johnny Mercer.
Thank you very much, Madam Deputy Speaker, and thank you for granting this debate today. And I won't be too long in my remarks, but I want to make a couple of really clear points. I'm clearly going to speak to the issue of Foreign and Commonwealth service personnel who serve in our armed forces and then have to pay to live in this country afterwards and to use public services. Now, this is an issue that has got wide, broad and deep support over the last few days from people who really don't like to get involved in politics. Okay, whether that's the Royal British Legion, whether that's Help for Heroes, whether that is obviously the veteran community, but beyond that, into our communities up and down this country who recognise the moral reason and the morality behind charging those who serve to live in this country. And you know, I speak to all sorts of people in the veterans community. Last night, I had a conversation with Prince Harry about this. And, you know, he has contributed hugely to the veterans debate. And I wanted his view on what he said. He said to me, it's not only morally right, but would mean so much to those who've given so much. And it's not a political intervention. It is the moral purpose of this. And it's an almost effortless change, as he said, for this government to make. It's for us to finally see through what we've said for these people for so long, because we owe it to them. They're our brothers and sisters. They've served with us over many, many years. And I recognise that there are things going around today about saying how we shouldn't be doing this in primary legislation, lots of reasons. I'll come on to that in a minute. But this has been going on for 20 years for these people. And we have to, at some point, grasp the nettle and make sure that we look after them. The money is meaningless, okay? And I'll address the figures that have been put out by government and others on this particular issue, okay? On Monday, I was told the government couldn't do this because it's going to cost £160 million, okay? That is garbage. And don't take my word for it, okay? Look at the Royal British Legion, who have for many years campaigned on this issue. And I pay tribute to members across this House, because there's people here who've been defence ministers on this side of the House, okay, who have dealt with this, who've tried to deal with this problem and have hit the same reasons as we're hitting at the moment. £160 million. If you speak to the Royal British Legion, who have studied the figures, if you apply for a visa, okay, and you served in the military in this country, all your dependents, you use a special code, okay, and you can only use that code if you've served or you're a dependent. So you can pull off that data between 2016 and 2020. It has never cost more than £1 million a year. Okay, and the majority of that is fees in profit, is a charge on our service personnel to stay here. Let me address this consultation issue around 12 years. Look, I don't want to air dirty linen in public, okay? But that 12-year figure, I was there when that was decided upon. Right? It was done on a visit. It was plucked out of the air. There is no evidence whatsoever to back it up. There is evidence that will tell you in the department that if you serve in the military and you come from a foreign Commonwealth country, you're likely to serve between 6 and 7 years. 12 years is well outside of that. Okay, it's well beyond what our peer nations do. It's well beyond what our allies do, and it is incredibly kind of unkind to these individuals who've worked and served for so long. I've given the moral case for it and I've given the financial case for it. But ultimately, this decision comes down to members on this side of the House, okay? Because the whole country is aligned on this issue, and they have been for a very, very long time. All the political parties will support this amendment, except the Conservatives. And we are the ones who made a promise that we would do something about that, and that is unconscionable. And so I'm afraid today comes, you can, of course, take the calls from the Defence Secretary, you can take the calls from others with these figures that I've demonstrated to you are not true. Okay, or you can think what you're here to do to represent the Fijian family in Plymouth, who left the military after 9 years, fought in Afghanistan, Iraq. They may be a member of the United Kingdom Special Forces Group, a relentless operational tempo. Finally leave, their kids go into school, they save up for a house, but they've got a £10,000 bill that they have to pay to stay in this country that they fought for over so many years. And ask yourself if you can really look that family in the eye and say, no, you have to pay. We have to make a profit out of you for you to stay in this country, despite the fact that you were prepared to commit so much to the privileges and the freedoms we enjoy. I would just say to colleagues, finally, the tide changes very, very quickly in politics. This issue has been around for 20 years now. And the tide changes. I know what it's like when people put the screws on and ask you to vote a certain way. But the tide changes, and all you can do is do what you think is right on that day. And this, the moral case for this, the financial case for this, has never been clearer than it is today. And I'd urge you to consider carefully before you cast your vote today. Thank you.
Stuart MacDonald.
Thank you, Madam Deputy Speaker. Rather than fixing the broken asylum system, on these benches we believe that the provisions in this section of the bill risk breaking it altogether, endangering, criminalising, delaying, warehousing, offshoring and depriving of their rights those who simply seek our protection. The Uyghur, the Syrian, the persecuted Christian that I spoke about at second reading, as well as the Afghans now in danger because of events subsequent to that debate, all face these bleak impacts despite our best efforts at committee. And contrary to the claims that this bill is about safe routes, it actually does not add a single one, while threatening, on the other hand, to restrict vital family reunion rights, pushing more people towards smugglers and dangerous crossings.
On that point, will you give way?
I'll give way to my
I thank my honourable friend for giving way, and I'd like to thank him for his forensic work on this bill in committee. He correctly says that this bill doesn't propose any new safe legal routes. But of course, there is one clause that does, and that's new clause 10, in the name of the honourable gentleman for Bermondsey and Old Southwark, of which I'm a co-sponsor. And that's the idea of having a humanitarian visa for which people could apply for in France and start the process in France of coming to the United Kingdom. Can you confirm that SNP MPs will support new clause 10 and new clause 11?
I'm grateful to my honourable friend for her intervention, and I'm very happy to confirm that the SNP will indeed support that. Indeed, there are a range of clauses from both sides of the House, from backbenchers in particular, that seek to add safe routes, and they all have our support. And for our part, new clause 35 would expand refugee family reunion in a way that this House supported in 2018 through the private members' bill of my honourable friend for Nailin and Yar. Our other amendments try once more to limit some of the harm that the bill will do at every stage in the asylum process. But indeed, let me first welcome amendments from the Joint Committee on Human Rights and others regarding appalling maritime pushback clauses and criminalisation of rescuers, provisions that risk serious harm even before an asylum seeker is able to enter that process. But if they get here, is it not absolutely outrageous that those seeking asylum in the UK will be criminalised under clause 39 with an offence punishable with up to 4 years in prison? So that's why our amendment 116 states clearly and simply that if Afghans, Syrians, Uyghurs, Christian converts or others are at risk of persecution in their countries of nationality, their mere entry or arrival for the purposes of seeking asylum is not a crime. And is it not extraordinary that that very idea has to be debated? Having faced the criminal justice system, clause 11 means our Afghan and his colleagues will now be stuck in one of the government's asylum warehouses. We say don't go down that path, a path that the Irish have just rejected as utterly failed and which brought shocking results at Napier Barracks. Make community dispersal work. And our new clause 36 would ensure dispersal authorities get the funding that they need to undertake their vital role. Deputy Speaker, stuck in that warehouse, clause 15 means that the Syrian and his colleagues will have to wait for months on end before their asylum cases are looked at, because those claims will be deemed inadmissible under a ludicrously broad range of criteria. These will allow the Home Secretary to say another country should take responsibility, even if there is not the remotest chance of that actually happening, even if there is no real reason why it should happen, or even if there are strong reasons such as family ties that say the claim should actually be considered here. The Home Secretary could even insist that a human rights abusing country that pays no more than lip service to the Refugee Convention should take charge, and even where a Syrian or Afghan has absolutely no connection to it whatsoever. So Amendments 132 to 142, drafted with advice from UNHCR, seek to put those safeguards and restrictions in place. Now, we are not saying that it is never appropriate for other countries to be asked to take over responsibility, but we do say that crucial safeguards must exist, and they are absolutely nowhere in this bill. Already we have had 7,000 or so people had their claims put on hold this year through inadmissibility procedures. Just 10 were removed. The remaining 6,990 all either are still waiting or have been moved into the asylum process, but they've been waiting for absolutely no good reason at all, and almost certainly at the cost of tens of millions of pounds to the taxpayer. The whole setup is absolutely ludicrous. But having toughed out the additional delays, it will be the Home Office that finally considers the asylum claims of the Uyghur and his colleagues. But we ask why. Time and again, the Home Office has shown itself as not fit for purpose. And that's why new clause 37 asks us to look to the Canadian model of an independent asylum decision-making body, ensuring that protection claims no longer suffer from political interference and politically motivated targets.
Hear, hear.
But sadly, far from supporting independent decision-making, a whole series of pernicious clauses in this bill would see this Parliament telling decision-makers what inferences to draw about evidence that is provided as part of a claim. We say leave assessments of evidence to the decision-makers that actually see it. We don't get to see it. So that's why Amendments 118 to 120 seek to remove clauses 18, 21 and 25. And by redefining parts of the Refugee Convention in this bill, the government makes it more difficult for our Christian convert and his colleagues to prove their need for international protection. Amendments 144 and 147 seek to fix two of the most dangerous examples of that. The impact of clause 31 is that if a decision maker is 49% sure that a person is a Christian convert and 100% sure that they will be persecuted and tortured to death in their home country if they are a Christian convert, that person will no longer be recognised as a refugee because the balance of probabilities test at the first stage is not met. 49% sure that the person will be tortured to death and they're not recognised as a refugee. Amendment 142 scraps that absolutely horrendous test and reverts to the existing test of a real risk of serious harm. And likewise, Amendment 147 fixes provisions in clause 32 that seek to overturn important and established case law and which would make it harder for people to make claims based on membership of a particular social group. But of course, most outrageously, the Afghan and his colleagues might have their claims considered not here at all, but a so-called offshore centre, replicating one of the most disgraceful episodes in Australian policymaking, an episode that saw human rights abuses rife, health and well-being massacred, exponential costs, utterly inadequate capacity, and a total policy failure that saw it abandoned. We fully support the amendments to take those provisions out of the bill. Our Syrian, Afghan, very briefly.
I've been told to be very brief, Madam Deputy Speaker. I just wanted to ask the honourable member if he was aware of Dr Nick Martin, who was a medical doctor, had been in the British Navy for a number of years, and he worked on Manus Island, one of the offshoring projects in Australia, and he describes himself as right of centre and not a natural refugee supporter until he saw the vile way, well, we are modelling this on the Australian model, the vile way that people were treated. And does my honourable friend agree with me that we should be listening to the voices of the people who've lived through this, rather than the people who tell us it's going to be all roses?
Hear, hear, hear.
Madam Deputy Speaker, the evidence about how disgraceful the Australian system was is absolutely overwhelming. My honourable friend adds helpfully to that. But our Syrian, Afghan and Uyghur, despite all of that, will almost certainly be recognised as refugees. But let's say the persecuted Christian convert is refused because the judge is only 49% certain that he's going to be murdered on removal. Of those who challenge refusals, around 40% have been successful in appeal in recent years. But in this bill, appeal rights are yet again restricted and certain appeal processes are accelerated. So Amendment 121 would delete the government's attempt to reinstate the detained fast-track process, which was previously ruled unlawful, And Amendment 145 removes another expedited appeal process. It is the Home Office that needs to address delays, not our tribunals. And the SNP, again, is fully behind cross-party attempts to place time limits on the use of detention. But even if a persecuted Christian after appeal joins the others in being recognised as a refugee, the misery that this bill will inflict upon them is far from complete. The group will now face all the discriminatory measures heaped on by Clause 11, which empowers the Home Secretary to punish recognised refugees through the insecurity of temporary residence, through no recourse to public funds, through limited family reunion, and any other form of discrimination and punishment that she thinks fit. It is a truly astonishing and outrageous provision. So Amendment 114 specifically exempts Afghan, Syrian, Uyghurs, Christian converts and other refugees from such disgraceful treatment. And we fully support Amendment 8 to remove the clause altogether. And if an Afghan or any of the others happen to be a young person whose age is challenged, the bill risks making life especially difficult for them, thanks to the provisions of Part 4 rammed into the bill at committee stage against the advice of numerous organisations and experts. The clauses will ramp up use of age assessments by altering established guidance on when assessments are required, requiring them even when there is no reason to doubt a child's age. They will allow the Home Office to meddle in an area which should be a matter for child protection and safeguarding teams, and to introduce new, unsupported, inaccurate and unethical scientific methods of assessment. Our amendments 122 to 126 seek to undo the damage of these provisions and leave those with expertise in charge and not an anti-refugee agenda. Madam Deputy Speaker, finally, our new Clause 32 simply requires the bill to be interpreted so far as is possible in line with the Refugee Convention.
Hear, hear.
If the government maintains there is nothing contrary to it in the bill, surely the government will have no problem with that new clause. The reality is, as numerous published legal opinions show, these provisions are a blatant assault on the Refugee Convention, and the most vulnerable in the world will suffer. Our amendments seek to ameliorate some of the most outrageous aspects of this bill, but the truth is the whole thing needs canned.
Hear, hear.
Sir William Cash.
Much indeed, Madam Deputy Speaker. My clause 28, using the notwithstanding formula, would exclude the Human Rights Act, the European Convention on Human Rights, EU and retained law, and the United Nations Refugee Convention from judicial authority and judgment. This is all about tackling illegal immigration, which our 2019 manifesto made clear we intended and must resolve. The amendment is not against genuine persecuted refugees. This is about economic migrants who claim that they are within the legal framework of protected refugees. The illegal traffickers convince them to use our human rights laws to come over to our shores in the certain knowledge that they will be protected by our judicial system. Illegal immigrants have no right to enter our borders, and despite the difficult journey that they have made to the French coast, they have no greater right to come here than any other illegal immigrant. When they come, as the traffickers have promised them, they are almost all allowed to stay under the Home Office guidance and are protected by the judiciary. They then bring their families across, and with the benefits they claim, not to mention education and housing, they enter what they believe to be the land of milk and honey. The returns are negligible because of the human rights legislation as it stands. Of course.
Honourable friend, and I strongly support his amendment. Did he note that when I asked the Minister for an assurance that the legislation unamended would be proof against human rights legislation distorting the intent, he was not able to give me that assurance?
They're not able to, but he didn't want to. 26,000 have entered this year alone, and unless the legal loopholes are effectively stopped, they will continue to come in a tsunami of numbers next year. The government in this bill has provided a partial remedy, but not yet regarding the full legal framework of the Human Rights Act, the European Convention, nor European retained law and the Refugee Convention of 1951, as amended with universal application in 1967 by a protocol. On EU retained law alone, I have found on the government's own website in the National Archives that this amounts to as many as 123 directives and regulations which spell out masses of law relating to asylum and immigration, which originated in EU law and are now on our statute book, although a few have been revoked. The official Home Office policy guidance for asylum screening is still essentially based on the same law, and it makes for dismal reading. It is essential that this is changed. At present, an asylum claim must be registered where an individual fears persecution or serious harm of persecution for any given reason on return to their country. How to evaluate a fear varies with every individual and can in many cases be deliberately exaggerated. To be recognised as a refugee under the UN Refugee Convention, the claimant can assert that they have a well-founded fear of persecution and be not only unable but unwilling to go back to their country of origin or habitual residence. This can be invoked on grounds which includes mere political opinions. Furthermore, they can claim that they are within the judicial sphere of, quote, the humanitarian protection policy, close quote, and the discretion as to whether an asylum claim should be accepted is heavily weighted in favour of asylum, even if when the asylum claimants arrive on our shores, they do not even use the term asylum itself. The paper by the highly distinguished former Professor of Law at Oxford, John Finnis, and Simon Murray explains in graphic terms the law and case law in over 100 pages of detailed analysis. They conclude that the European Court of Human Rights have wrongly circumvented fundamental principles originated in the European Convention and in the 1951 Refugee Convention. As they also argue that properly interpreted, the UK and other signatory states have no obligation to let in refugees arriving at our borders en masse, have no legal or treaty obligation to accept refugees at all, and no obligation to provide asylum for dangerous refugees such as criminals and terrorists. The European Court has, by radical and unwarranted interpretation, used the provisions in Article 3 on torture and inhumane treatment and in Article 8 on the right to a private and family life to extend the ambit of claimants to encourage claimants to engage in unlawful immigration. This is through the formula of so-called living instruments and recent UK judicial rulings which have continuously expanded claimants' rights within the judicial system. Claimants are granted repetitive appeals, which brings the immigration system under intense pressure at monumental expense to the taxpayer with grave political consequences on the doorstep. We need to pull the rug from under the traffickers' feet and save the lives of those exploited by them, and to protect our own manifesto promises. Despite the government's good intentions and aspects of this bill, we must solve the fundamental problems presented by the human rights legislation and the legal framework of the provisions I've mentioned. We cannot continue with unwarranted interpretation and judgments by the judiciary to allow illegal immigration, and I seek robust assurances today from the government and to resolve this by legislation, and I will press my amendments unless I get them. We cannot go on kicking the can down the yellow brick road. The journey has begun, but the question is, where does it end? This yellow brick road is not only in disrepair, as it was in The Wizard of Oz, but is littered with political precipices.
Harriet Harman.
Thank you, Madam Deputy Speaker. I'm speaking in particular to the amendment standing in my name and other honourable members 96 to 100, which arise out of the Joint Committee on Human Rights legislative scrutiny of this bill. Just to remind honourable members that the Joint Committee on Human Rights is half members of the House of Commons, half members of the House of Lords, cross-party obviously, and we undertake legislative scrutiny of all bills for their human rights implications. On this bill, we've taken evidence from many, including the Minister, and we're grateful for his evidence. And we're also advised by our own legal experts. And this is our report, which we published on the 1st of December. We concluded that the proposed new measures to criminalise those who enter the UK without a visa or without leave will breach human rights law and the Refugee Convention. And our Amendment 102 deals with that. We also concluded there should be no immunity from prosecution if criminal offences are committed by border officials, particularly where that leads to loss of life. And our Amendment 100 deals with that. I hope the government will accept both those amendments. Our Amendments 96 to 99 deal with the major issues about pushbacks. The bill provides greater powers for the border force to board, divert and detain vessels. The government acknowledge crossings are perilous, and this debate takes place in the shadow of the 27 people who drowned in the Channel. The Minister was clear in his evidence to the Joint Committee on Human Rights that he does not want the government action to be the cause of yet more lives lost. Of course they don't. Our amendments would circumscribe these new powers in order to ensure that they could not be used against unseaworthy vessels such as dinghies. And that's our Amendment 97. And that they could not be used in a way that would endanger lives at sea. And that's our Amendment 98. And could only be used in a way which complies with international maritime law, which the government say that they want to comply with. Now, the Minister said in his evidence to us that all this is their intention and that they would make clear in operational directions that intention. But if the power is on the face of the bill, then so too should be the protections on the face of the bill. As it is the government's intention, what reason could they possibly have to oppose these amendments? The government has a big majority and can whip to vote down these amendments, but they are brought forward to the House from a cross-party committee of the House, and they are expertly drafted by our legal counsel, and they represent what the government say is their intention. The Minister is new and enthusiastic in his role. He was very forthcoming in his evidence to our committee, and he and I have spoken about this privately, for which I'm grateful. So I offer him a bit of advice for him not to be the Minister who votes these amendments down just because he can, to not be the Minister who makes his backbenchers vote against ensuring that lives are not endangered. That's not the right thing for him to do. And not to be the Minister who gives new powers to the border force, which then cost lives at sea. Our amendments allow for the new powers, but make them compliant with international law and make them safe. The government have no reason to oppose them. So I hope that he will say to his colleagues and his civil servants that he is wanting to reflect on them, because he doesn't want to stand in the way of putting the government's intentions on the face of the bill. The government have no reason to oppose them, but if they do, we'll seek to push Amendment 98 to a division, but I hope that will not be necessary.
David Davis.
Speaking, can I say what a pleasure it is to follow the right honourable lady, and how sad I am that she's not standing next time. Can I also say what a particular pleasure it was to hear my old friend, honourable friend, the Minister, make such a measured and balanced case at the dispatch box. I was really proud of it. That doesn't mean we're going to agree on everything, as he'll hear in a minute, but I think the Minister put a very, very good case. The current asylum system is broken, not just for us, but for most of Europe as well. And we should understand that this is not simply a national issue. It rewards smuggling gangs who prey upon the desperate, punishes those who with genuine needs through bureaucratic impediments, and pushes the most vulnerable into harm's way. And of course, we know thousands have arrived across the Channel and dozens at least have died as a result. We must find a system that destroys the criminal network underpinning this crisis, vigorously pursues enhanced cooperation with the French and other European parties, and distinguishes properly between economic migrants and those fleeing persecution. And I think at the moment we don't do that properly. Now, I believe the Home Secretary is entirely committed to these approaches, but unfortunately, one element, I think it's a very good bill in many ways, but one element of this bill, offshoring, in my view, sacrifice our long-term values to short-term political expediency with fairly little chance of success.
Will my right honourable friend allow it?
Yes, of course.
We agree on many things, but perhaps not on this. Does he agree with me that unless we get rid of the pull factor, we will never solve this problem? You don't need to go offshore. If you look at my new clause 23, you can actually ensure that anybody entering this country illegally from a safe country will be held in secure accommodation. The reason why they keep coming is they know they will vanish in the community and they will never be deported. So will my right honourable friend, who's so good in so many ways, at least look at what we are proposing?
Of course. And I said to the front bench that much of this bill is worthwhile. You're right about the pull factor. And there are many other things we can do. I've been in discussion with the minister, for example, about improving our surveillance. The irony is, at the moment, Frontex in the Mediterranean, using British surveillance operations, does a better job than the Home Office does in the Channel. So there are lots of things we can do. And yes, of course, I would look at all options available, so long as they're humane. But what Clause 28, Schedule 3 of the bill does is grant the Home Office the legal powers to create an offshore processing system. And I'm afraid to say to this side of the House, it's based on something of a mythology. It's based on the Australian government's approach in 2013. And its scope would allow children, modern slavery victims, and torture survivors all to be detained offshore in a place where we have little legal control. Now, the Australian model of offshoring was actually seriously problematic on a humanitarian level, and its supposed deterrent effect of the policy was really down to a very aggressive pushback policy. What the Australians did was push those ships back effectively into the middle of the Pacific or into Indonesian waters in the Pacific. That was the biggest impact. It's really my right honourable friend's point about the attractiveness of these things. Now, the Refugee Council of Australia has documented the gut-wrenching sexual, physical and mental abuse that has pushed vulnerable children towards suicide. A 14-year-old girl held offshore for 5 years, doused herself in petrol and tried to set herself alight. Fortunately, she was stopped. A 10-year-old boy attempted suicide 3 times. A 12-year-old boy held offshore for 5 years, had to be medically transferred to Australia because he tried to starve himself to death and got to the point where he couldn't even stand up. He was so weak. You might think these are isolated cases, but tragically they're not. From May 2013 to October 2015, there were 2,116 documented assaults, sexual abuse, or self-harm attempts. More than half of them applying to children. And I say more than half of them applying to children. Only 1/5 of the asylum seekers were actually children. So it's an astonishing humanitarian record, really, for this policy. Now, if this would happen on our watch, I know there's a lot of politics in this and a lot of doorstep politics in this. If this happened on our watch, just imagine how the public would respond to harm, serious harm, to a child nominally in our care. Do you remember what happened when the Iranian Kurdish child of 4 was shown drowned on a Greek beach? Well, you'd have something like that, but in our own control. And I do not want to see any British government of any persuasion face that. Now, I'll give way to the Honourable Lady.
I thank the right honourable member and for everything that he's doing on this, and he'll be aware of Madeleine Gleeson, the Australian lawyer, academic, and author of the book Offshore, who's an expert on offshoring. And she said that once you commit to something like offshoring, there is no going back. And she actually asked me to let the members who are tempted to vote for it know that even for those in Australia who opposed it, the burden on their consciences to this day is a heavy one. So will you join me in urging those members tempted to vote in favour of offshoring to search their consciences and not do this to themselves or those children?
Let me say to the Honourable Lady, I think everybody in this House wants to do the right thing by our own country and the right thing by vulnerable people too. I do not dismiss anybody from that. What I'm trying to do here is to let people know what will happen before we are fixed with the system and then find ourselves defending something which may turn out to be indefensible. That's the real concern I have about this element of this bill. And the biggest argument, in my view, is on humanitarian issues. But also, as Conservatives on this side, we should think about the cost. Now, by any measure, this will be eye-wateringly expensive. Eye-wateringly expensive. We spend at the moment £1.4 billion annually on asylum costs. That's about £11,000 per asylum seeker here. Australia has spent £4.3 billion on just over 3,000 asylum seekers. That's about £1.38 million per person. And I promise you, as an ex-Public Accounts Committee chairman, I looked at that rather askance and I went through it with a fine-tooth comb. And I tell you, it's right. Now, if you applied that cost to our asylum situation, you're talking about something like 34 or 35 billion pounds, the size of a government department. Now, let's imagine we were twice as effective as that. Just imagine we're twice effective. It's still 17 billion. Yeah, are we really talking about doing something like that? And the reason is, of course, you effectively have to bribe the country that will take the asylum seekers.
So, am I right, honourable friend? I'm grateful, but isn't my right honourable friend overlooking the deterrent effect that this will have?
Well, that of course was the argument. Not so cheering. That of course was the argument with respect to the Australian system. But the real deterrent effect on the Australian system was the pushback. The fact is nobody got to Australia, and that was the main effect. And you have to ask yourself, in the past, we've had an argument within our own party about the question of hostile environment. We remember the hostile environment policy, which we lived with for a long time. It didn't work, but we tried it and it brought our reputation down. So thank you for that. So no, I do not think this. I mean, he's right. The pull effect, the deterrent effect, they're all important, but you've got to do it in a way that you can stand by and be proud of at the end of the policy. And that's why I'm saying to the House now, this is what it will look like come the day. And it's not something I will be proud of at that point in time. And for that reason, I beg to move my amendments.
Sana Begum.
Thank you, Madam Deputy Speaker. I rise to speak in favour of a number of amendments, but for the purposes of time, I will largely keep my comments to new clause 12 and 13 in my own name, and new clause 14 tabled by my honourable friend, the member for Streatham. New clause 12 would provide recourse to public funds to everyone holding a valid UK residence permit. New clause 13 would repeal the sections in the 2014 and 2016 Immigration Acts, which restrict undocumented migrants having access to work and services. And new clause 14 seeks to abolish the immigration health surcharge. I'm really pleased that these clauses have received lots of support from members from across the House. It will perhaps be obvious to colleagues that these clauses are about addressing the unjust suffering that has been caused by the government's hostile environment, a term used to describe all the policies which make life difficult for migrants living in the UK, explicitly and deliberately treating them as less deserving of dignity and humanity than British citizens. The measures that my new clause 13 in particular is seeking to overturn is about the denial of basic human rights. And members will know from their casework in their constituencies that the consequences are brutal and wide-reaching. The hostile environment deters people from reporting crimes to the police or calling out unsafe working conditions or exploitative practices at work. It undermines trade union rights, and it pushes people into poor quality and dangerous accommodation and homelessness. As new clause 14 highlights, it is even about denying access to healthcare. It scares off people from going to the doctor for fear of charges being reported, detained and deported. The no recourse to public fund status, which my new clause 12 is about, abandons some migrants from having a safety net. It leaves children hungry. It pushes family into poverty and unsafe, overcrowded housing. And it means women in particular fleeing abusive partners are not entitled to access mainstream refugees. It is breathtakingly cruel and unjust. Yet, Madam Deputy Speaker, the disproportionate suffering migrants have had inflicted upon them during the pandemic is well known, even if apparently forgotten by this government. But not only is this hostile environment and the environment that it produces a culture of fear that is so often risking the NHS being able to do its job, it does put all of our communities in danger. And although such policies try to incentivize us to be suspicious of one another, they are not actually in the interests of the majority of people. Therefore, it should be to no surprise that the bill before the House today is another horrifying extension of such an approach, undermining human decency, and it must be opposed in every way. Now, the fact that this is all set in the context of the ongoing tragedy of people drowning in the English Channel is chilling. That such people will now potentially face jail sentences if they do survive such precarious journeys, and even more hostile environment is just catastrophically wrong. And I want to emphasize the humanity that runs through amendments that I am supporting today. We have to stop this political immigration game of misinformation and cynicism that has such horrendous human costs. There is no doubt that one of the reasons we are seeing scenes of desperate people trying to cross the channel is the lazy but deadly political anti-migrant agenda that sees that safe routes to the UK are closed off.
Exactly.
Madam Deputy Speaker, one of the biggest myths perpetuated by politicians is that they are too tough, too afraid to talk about migration, when in fact the opposite is true. The more politicians talk about being tough on migrations, the more they just talk about being tough on migration. Indeed, for decades, the rate of lawmaking in this area exceeds that of every other social policy area. When people repeat half-truths, inaccuracies, and attempt to utilize society's fears, prejudices, and anxieties for opportunistic so-called political gain, a climate of acceptance is created for such ideas within society at all levels. And the mainstream media also must reflect on its role with their focus on numbers and the use of words such as flood, influx, and wave. And I'm sorry that the honourable member for Stone also used the word tsunami, which is a disgrace. Yet it is simply not true that Britain takes in more refugees than everywhere else, and research shows that 2/3 of asylum seekers crossing the channel in boats, for example, are finally granted asylum by the government's own measurements.
Exactly.
Yes, we do need solutions to the soaring inequality, suffering, and frightening COVID death toll that this government has presided over, but not suspicion and scapegoats. Wherever we are from, we all need a roof over our heads, food to eat, healthcare, and basic human kindness and solidarity. And surely the true measure of a civilized society is not in its hostility, but in its humanity. I commend these clauses to the House.
Caroline Noakes.
Deputy Speaker, and I would like to draw attention to my entry in the Register of Interest for the support I get from the Refugee, Asylum and Migration Project. That's a cross-party group of MPs, and following on from the comments from the Honourable Lady for Poplar and Limehouse, which absolutely seeks to take the toxicity out of this debate, to find consensus, to be careful in the language we use, to try and make sure that we can find agreement and indeed pragmatic solutions. And certainly when it comes to crossings of the channel in small boats, we need some pragmatic solutions. I absolutely commend my honourable friend, the Minister, for the comments he made about seeking to smash the evil trade in people, for that is what we must do, because they regard human life as being absolutely worthless and are seeking to provide crossings available to the highest bidder and actually with no consideration whatsoever to people's safety. And I thank my honourable friend, the Minister, for the engagement that he's had with me on this subject and trying to listen to some of the very real concerns I have about some of the clauses contained with this bill. Now, it is interesting that when talking about immigration, you often find yourself with strange bedfellows. I think I'll be completely candid about that. And it is not often that my right honourable friend for Halton Prowse and Howden and I find absolute agreement on issues. However, when it comes to offshoring, and you might expect this from the chair of the Women and Equalities Select Committee, I share a great many of his reservations, not only about the moral principle, but the practical impact of this policy. I've sought assurances from my friend the Minister about whether this policy will apply to children. And I hope very much that we will see included in the bill that it will not, that we will not seek to remove young, vulnerable people to any other country, whether they're a member of the Refugee Convention and signatories to the HCR or not. And I also seek assurances from him that we won't be seeking to do it to women, perhaps to pregnant women. And if there are pregnant women making those dangerous crossings, what are we doing to make sure that they are safeguarded and not shipped off to another country? And I think that's of crucial importance. I give way to the Minister.
I'm very grateful to my right honourable friend who speaks with great passion on this issue, and I'm very grateful to her for the constructive way in which she's gone about raising concerns in this area. I just want to really emphasise that we will always act in accordance with our international obligations and be very clear in saying that unaccompanied asylum-seeking children will not be subject to inadmissibility, nor would they be transferred for offshore processing. And of course, it's also important to say that we won't split family units, because that would be contrary to our international obligations.
I hope my honourable friend, the Minister, won't mind me instantly picking up. He was very specific there. He said that unaccompanied asylum-seeking children would not be sent offshore, and he said that we would not split families. I also seek his assurance that we will not send whole families to have their claims decided offshore, and a further assurance around you ask children that once they've been accepted into the asylum process, that they won't then fall out of it again once they turn 18. It's an absolute imperative to me that if somebody's claim is going to be decided here, it should be decided here and not diverted midway through the process because they pass an arbitrary age. Now, look, I have very real concerns, and this is an illustration that I tend to use about creating two tiers of asylum seeker. We saw the horrific scenes in Afghanistan as female judges, female members of parliament sought to flee that country. And we've put in place some schemes not yet up and running, and I think it's important to emphasise that, around the Afghan Citizens Resettlement Scheme. And I just draw the image of one female judge coming to this country under that scheme when it's up and running and being accepted into our country, given indefinite leave to remain, given the right to work very promptly, and a second one who arrives on a small boat. Same circumstances in that she's a female judge who would be at risk if returned to Afghanistan, and we seek to offshore her. Now that causes me very real concern that we will be creating this two-tier system where people with identical claims to safety at identical risk from the Taliban could be treated very, very separately. And I just want to raise some concerns about where we might send people. So I wouldn't seek to presume that I would know which countries the Home Office is discussing this with, but perhaps a country like Albania, mainland Europe, not part of the European Union, where actually there is already a well-established route from there to this country in the back of a van. We could be in a situation where we were paying a third country a significant amount of money for somebody to be accepted into their asylum system. So different from the model outlined by my right honourable friend for Halton Prowse and Howden, one where they were actually being accepted into that asylum system. But what if they're refused? What is there at that point that means that person won't seek to come immediately back to this country, some sort of circular trade where they end up back on our shores, whether in the back of a van, whether in a small boat, and so the cycle goes round and round. I have some experience as immigration minister, and I know full well that at this time of year, there is a very popular journey in the returns flight to Tirana. And I can see that Madam Deputy Speaker wants me to hurry up, so I will. And it just beggars the suspicion that people might see that as an opportunity to head off to a different country and then end up back here because their claim was either accepted or denied in that third country. And finally, on resettlement schemes, we must get the Afghan Citizens Resettlement Scheme up and running and effective. We should also seek to make sure that we fulfil our commitment to vulnerable people that we made when VPRS and the Vulnerable Children's Resettlement Scheme came to their conclusion. We can't talk about safe and legal routes unless we actually have some. And it's an absolute imperative that we do so. Finally, and I know I'm now stretching the patience of Madam Deputy Speaker, to follow on from the comments of the Right Honourable Lady, the member for Camberwell and Peckham, about pushback. I was the immigration minister who rejected that because I thought it was too dangerous to do that in one of the busiest shipping lanes in the country with vulnerable, overladen boats with women, with children in them in choppy seas. I think we should think very, very carefully before going down that route because no minister at all wishes to be responsible for more loss of life in the Channel.
Order. I'm just going to have to put a 3-minute limit on now because otherwise we simply won't get people in. Patrick Grady.
Thank you, Deputy Speaker. This bill is literally inhumane. It dehumanises asylum seekers, it puts lives at risk, and it turns people into criminals for simply attempting to exercise their basic human rights. The UK government is going to let small matters like fundamental human rights, the rule of law and natural justice get in the way of their hostile environment and attempts to exclude practically anyone that's not a tax-dodging billionaire from settling on these shores. We keep hearing the asylum system is broken from that side. Well, how did that happen? Because they've been in power for 10 years and the environment's only got more hostile, so perhaps a different approach is needed. And that's why I want to support the right to work in new clause 45 for my honourable friend from Glasgow North West. The right to work is a human right. It's in the Universal Declaration of Human Rights, and it cannot be taken away. It might be denied, but it cannot be taken away. And lots of us heard that last week from people who had travelled from Glasgow and the Mary Hill Integration Network to speak to us about this. They want to work, they want to contribute, they want to share their skills. Instead of being a cost to the system, let them contribute to the system. Instead of receiving meagre and insulting support payments from taxpayers, let them become taxpayers. But that's not something the government is interested in. I don't know when the last time a government minister has had to sit in a constituency surgery and look at a biometric card that says no right to work, no recourse to public funds. It's one of the most heartbreaking things that you have to do as a member of parliament in this house, and it's a complete insult because it's a human right to be able to work. I also support a new clause 9 from the honourable member from Hackney South and Shoreditch on EU certification, because that is correcting another historic wrong. I have constituents who have an email saying, congratulations, you have your settled status. By the way, this email is not proof of your settled status. So quite how they're supposed to prove it if they don't have that documentation is kind of beyond me. But it's all a part of a Home Office agenda that doesn't want people to make the United Kingdom their home. They want to close borders, they want to shut down routes to citizenship, and they want to send a general message that unless you have lots of money, you're not really welcome here. How can the UK ever be the first safe country of arrival? We're surrounded by water. So it's simply not possible. It means that practically everyone turning up here to claim asylum, whether they're on a ship or whether they're on a small boat or whether they're at an airport, is going to become a criminal because we're surrounded, as I say, by water. But that's an approach that is rejected by people in Glasgow North and across Scotland. And I look forward to the day when we can have an open, generous, accessible pathway for asylum and citizenship for those who want to take it up in an independent Scotland.
Christopher Cho.
Madam Deputy Speaker, it's not just the asylum system that is broken, but it's also the immigration enforcement system. And last year, the Public Accounts Committee reminded us that the Immigration Enforcement Directorate has 5,000 staff, costs £400 million a year to run. But over the last several years, every year there have been fewer enforced removals, fewer voluntary returns. And in the last year, from which figures are available, in 2019, there were only 55 convictions for all immigration offences. And yet we know that there are probably 1.2 million illegal immigrants in this country. So one asks the Minister, what is happening to the published aim of the Immigration Enforcement Directorate, which is, and I quote, to reduce the size of the illegal population and the harm it causes. The reason I put down new clause 18, and I much appreciate the support of 17 colleagues who also signed it, is that it would make it clear that it is a criminal offence to be in the United Kingdom illegally. Most people find it amazing that it's not already a criminal offence. So it's a criminal offence to watch a television without a television licence, but it's not a criminal offence to be in this country without authority. And my amendment would change that and address the issue of all these people who are here unlawfully. And I've noticed, Madam Deputy Speaker, there's hardly any time left. The Sky News suggested that there may be about 87,000 new illegal immigrants coming in each year. Very few of those, relatively speaking, are failed asylum seekers. There's a much bigger problem of clandestines, those arriving without documents, and the very large number, estimated to be 66,000, who stay beyond any visa entitlement. We've got to deal with the wider issue of illegal migrants and enforce it properly.
I'm going to be prioritising people who've got amendments down. Meg Hillier.
Thank you, Madam Deputy Speaker. Before I speak to my new clause 9, I want to associate myself fully with the comments of the Honourable Lady for Romsey and Southampton North, which in normal times might surprise people, but I think she put very eloquently the real challenges and issues of offshoring and pushing back. But I rise to propose new clause 9, which calls on the Home Office to fill the gap between the digital by default proof of status for under the EU settlement scheme and the realities of people's lives. And it's very typical of the Home Office to have set up a system that doesn't actually understand the interactions that people will have to make while proving their status. I do want to put on record my thanks to the Minister for speaking to me about this and for his letter of today. But some facts: I represent, over 10,000 EU citizens in Hackney South and Shoreditch alone, and alongside my honourable friend, the Honourable Member for Hackney North and Stoke Newington, many thousands more. But in my constituency, it's 8.5% of the constituency. 60% of Roma people are unable to access digital proof, and there are other groups that have real problems with digital access. And it's just some of the cases I've had just through my own caseload. An EU citizen living in my constituency who visits France weekly for work has been interrogated by British border force every time she arrived back in the UK. Another case, where a constituent whose parents are in their 70s who struggle to understand the complex process of proving their status digitally. A freelancer who's another case who's had to prove his identity with every new employer, can be every 5 or 6 weeks. The website is sometimes down and many employers just don't want to engage, and he has lost money. And another constituent who works for a charity working with the Roma, which shows this figure of 60% of Roma people finding it difficult to access digital proof. I also want to thank the 3 million who've written to me since I tabled this amendment and explained many of these situations, which I haven't got time to go into, but repeat the concerns of my constituents. But I would say to the Minister, whose job I did just over a decade ago, we're not so far apart on this. I too support methods that take us away from those old immigration and nationality directive folded up letters that many of my constituents still come to surgery with in their wallets, folded so they're falling apart. They are not a great way of proving your status in the UK. People lose passports, but there are gaps in the system, I say to the Minister, Madam Deputy Speaker. And we've seen with the COVID app how we can make a difference linking the app, combining both the digital and the paper. And I wonder if the Minister might want to say something at this point.
Thank the Honourable Lady for giving way. In terms of the app-based solution, we've had it helpfully suggested by the 3 million, and it's something that we are looking at, subject to having held my role before. She'll know the usual sort of security caveats that we would add to that, but it's certainly something we'll be looking at.
Madam Deputy Speaker, I thank the Minister for that, which is a bit of a breakthrough. And I think it is important that the Home Office remembers that people will lose records. They will have places with no Wi-Fi, when they're travelling, they'll be able to access this. So having the opportunity for a time-limited document at least, which gives them an option to have it on paper, would be a very welcome move. On the basis of what the Minister said, and I will watch him like a hawk on this, I won't be moving my amendment to a vote tonight, but I think there are a lot of us, I thank the honourable members who signed my amendment, who have a very strong interest in this. These are EU citizens who've made their life in this country, and we deserve to give them the comfort that they need so that they can go about their ordinary lives easily and effectively.
Richard Graham.
Madam Deputy Speaker, I rise to comment on new clause 52. This is important because in April 2019, I wrote a letter with the former member for Bridgend, Madeleine Moon, on this subject to the then Home Secretary Sajid Javid and then to his successor a few months afterwards. And in this letter, we called for a waiver of fees for Commonwealth servicemen and women, rightly now amended to all non-UK citizens, which is effectively the core of what my honourable friend, the member for Plymouth Moor Views amendment calls for. And it's very good to see him in his place this evening and back in the House, and I welcome that. However, I do think there are some realities that make it very, very difficult for us to vote for this amendment tonight, not least the fact that it doesn't need to be in primary legislation. The amendments can be made outside of legislation through the immigration and nationality fee regulations, and actually when it comes to sums of money, it's very important that it is done that way. But I would like to remind the ministers that in that letter, I highlighted the point that the current situation irks many members of the public, that our nation looks mean-spirited to those who volunteered to join us and potentially put their lives at risk. This letter was signed by 130 MPs, Madam Deputy Speaker, including 3 Secretaries of State in the current government, 10 ministers, including the Veterans Minister, and 1 whip. So this letter, this belief, has considerable amount of moral support around the House. And I suspect the Minister will say, and I understand that they need to respond to the consultation that they held on this earlier this year, and that this is not the place to divide the House or to make rapid decisions, which I totally understand, Madam Deputy Speaker. But I do hope that ministers will confirm this evening that they will look at this very closely with a clear understanding of the support around this House for the moral principle at stake, and that they will come back to the House when they respond to the consultation so that we can have a full debate on it then. And I hope at that stage, Madam Deputy Speaker, we will be able to support changes that they make, which will enable non-UK citizens to carry on serving in our armed forces.
It goes without saying that if colleagues could be less than 3 minutes, we will get more people in. Tim Farron.
Thanks, Madam Deputy Speaker. I would speak in support of new clause 10 and 11 and Amendment 8 in my name. I don't say this lightly, but I think there's a deep wickedness at the heart of this bill, matched only by the stupidity of it because of the reliance on a bogus narrative, which is that we are being, whatever the language you use, swamped by asylum seekers. Let's have some facts, which might help backbenchers on the opposite side. First of all, 2% of the world's population lives in the United Kingdom. 0.65% of the world's refugees are in the United Kingdom. We are not taking our fair share. We are not overwhelmed. We take fewer than half the number of asylum seekers we had 20 years ago. We are 17th in the league table, lower mid-table of countries in Europe when it comes to taking asylum seekers per head of population. Germany takes 3 times more than we do. France takes 2.5 times more than we do. We hear from the Minister that our asylum system is broken. Yes, it is. Not because it's deluged by too many asylum seekers, because evidentially that is not true. It is broken because of incompetence of the part of the Home Office. It is the equivalent. The government's argument is the equivalent of blaming patients for NHS waiting lists. It's unacceptable and it is wrong. The numbers crossing the channel is tragic and it is awful, and it's obvious why it is the case. It is because we have seen a clampdown because of COVID and because of security on people crossing the channel through other unsafe routes, through the Channel Tunnel, through ferries, and indeed, as the narrower routes across the channel have been more heavily policed, what have we seen people doing? We've seen people taking more dangerous routes. So what does the evidence show us? It shows us that when you close off a route, people find a further, more unsafe route, so the government's policy will see more people dead in the channel, and that is clearly what's going to happen. And unless you introduce safe routes, a whole lot of rhetoric about safe routes and no action whatsoever.
I think all this shouting across the chamber isn't doing anybody any favours, okay? Tim Farron.
Sorry, honourable members can shout on the other side, but they are literally voting for something which will see more people dead in the channel. They are. This is a charter for the people traffickers. And the only answer is safe routes. And so we offer them the humanitarian visa as a safe route. We offer them the opportunity to do something that is not just morally right, but will actually solve the problem that we are seeking to solve. The reality is that here we have a room full of comfortable people deciding to create a 2-tier asylum system that will decide that between the deserving and the undeserving asylum seeker, which is not just morally wrong, but internationally against international law, undermining our standing internationally, weakening Britain's position on a whole range of issues across this world, and of course at the same time doing something which is morally shameful, undermining everything that it is to be British.
Alfred.
Madam Deputy Speaker, I rise in support of Amendment 150 in the name of my honourable friend, the member for Stone, to which I'm a signatory. Before turning to that, I welcome the government's amendments 60 to 63 as I pay tribute to the Border Force, Coast Guard, RNLI and search and rescue organisations operating in Dover, Deal and across East Kent who day after day, month after month, year after year, put their lives on the line to save those at peril on the sea. And it is a truth and an uncomfortable one, and one on which the Right Honourable Member for Westmoreland and Lonsdale is wrong. It is an uncomfortable truth, but a truth all the same, that every person put in peril by the people smugglers is already safe on land in France and many other countries before France. When we remember the 27 people who died recently, as well as the many other lives lost, we must be united in this place to do whatever it takes to stop more lives being lost in the English Channel. That is the second uncomfortable truth. For whatever those on the opposite benches may wish to say, there are routes that are safe and legal to come to this country. And this is a bill that shows compassion to those most in need of assistance and prioritises those people over people who choose unsafe and illegal routes of entry. The clauses 29 to 37 make it clear that refuge will always be available to people persecuted by reason of their religious, political, other beliefs, their race, their ethnicity, their sexuality. And it seems to me to be absolutely right to prioritise protection to those most in need of it. And that is the third uncomfortable truth, that it is possible to have help for those people in greatest need and have strong borders. It is possible to have help for those who need it and also make sure our country has strong and secure protection. It's absolutely vital that that's what's supported in this bill. And finally, I'd like to turn to the Refugee Convention. It is now 80 years old and it's out of date, with some 80 million people displaced across the globe. We need a new global compact, a COP26 for the migrant crisis, to make sure that we finally work together globally and put an end to the migrant crisis and the small boats crossings routes that's losing lives in the English Channel.
I'm sorry, I'm going to put a 2-minute limit on. I know that's not going to be that popular, but I'm not going to get everybody in anyway. And I'm sure our next speaker, who will be on 3, because it will be after him, will try to stick to 2. Paul Blomfield.
Madam Deputy Speaker, and I rise to speak on new clause 44 on safe and legal routes, tabled in my name, and also new clauses 15 to 17 on statutory limit on immigration detention, which I've tabled with the Honourable Member for North East Bedfordshire, and I pay tribute to his work on that issue. On new clause 44, the issue here goes to the heart of the supposed objectives of the bill, which is predicated on stopping irregular arrivals of asylum seekers by encouraging those fleeing war and persecution to access safe and legal routes. But the Afghan Citizens Resettlement Scheme, announced in August as urgent, is still not operational. The Syrian scheme has closed, the Gateway scheme is not operational, and the UK resettlement scheme, opened in February with a commitment to resettle 5,000 people in year 1, has taken just 770 people. It is a cruel deceit to say that the measures in this bill are encouraging the use of safe and legal routes if we have no such meaningful routes. Now, there's much to be concerned about with the bill: differentiation of refugees in contravention of international law, offshoring of processing claims away from protection, pushing back rubber dinghies and risking lives. Importantly, the measures for which the government's own impact assessment says the evidence base is limited, and their own impact assessment says these measures, quote, could encourage cohorts to attempt riskier means of entering the UK, but it's all justified in the name of encouraging safe and legal routes. So the government has to face up to its responsibility and deliver those routes. On new clauses 15 to 17, we're seeking to place a statutory limit on immigration detention and respond to a missed opportunity in this bill. I was vice chair of a cross-party inquiry over 8 months in 2014. Parliamentarians from both sides, all main parties, more government members than there were opposition members, a retired law lord and former chief inspector of prisons, and of course the Honourable Member for North East Bedfordshire. Our recommendations, which included the limit on detention contained in new clauses 15 to 17, were endorsed by this House in September 2014. So it's disappointing that we're still debating them 7 years on. It's not a particularly controversial proposal. We are unusual in this country in having no limit. During our inquiry, we spoke to a young man who had been trafficked from Cameroon-Nigeria border. He'd been beaten, raped and tortured, and he'd made an irregular route to this country on a false passport. He had been detained for 3 years in contravention of the stated aims of the Home Office, that those who've been trafficked shouldn't be detained, those who've been tortured shouldn't be detained, and that detention should be for the shortest possible period. Time and again, we were told that detention was worse than prison, because in prison you know when you're going to get out. But that sense of hopelessness and despair leads to hugely deteriorating mental health.
Order. I'm sorry. Sir Edward Lee.
The Pope was recently in Greece, and he criticised European governments for their lack of humanity to migrants. I agree with the Pope, and it's his job to stand up for the poor and the dispossessed of the world. But leaving aside the fact that if Greece accepted 100 a day, 1,000 would come tomorrow, and if they accepted 1,000 the next day, 2,000 would come the day after that, because there are countries in the world which are in such an appalling mess, like Syria and Iraq and Libya and Somalia, that there is no limit to how many people would want to come here. Also, the people crossing the Channel are not the world's poorest. They are paying £6,000 or £7,000 to get here. They are not the world's poorest people. They are economic migrants. And if we are weak as a government, we are actually being inhumane. We are putting people's lives at risk because more and more people will come to our shores and risk the channel. So to be kind, it may be a cliche, but we have to be tough and we have to get rid of the pull factor. There is no point in going on blaming the French. Of course, we would like them to take them back, but they probably won't. You have to get rid of the pull factor, and that's why I have put forward new clause 23. The only way we're going to stop this is if we put these economic migrants who enter this country illegally in secure accommodation. They know that they can vanish in the community. There is a minuscule chance of them being deported, and here they have better chances and better job prospects than in France and elsewhere. So the government has to get firm and tough on this. And by the way, according to the law of the sea, it would be perfectly legal for them to escort with border force vessels economic migrants back to the shores of France. So I say to the government, act now, get tough, or people will die.
Ferry.
Madam Deputy Speaker, I have to say there's a lot of myths and misunderstandings in that last contribution. But I want to speak to Amendments 113 and 13 in my name, and also to endorse new clauses 10, 11 and 28, for which I'm a co-sponsor. Amendment 113 prohibits the UK from acting in breach of the UK's international obligations. And in particular, the notion of pushback and offshoring are the most extreme manifestations of the hostile environment and the scapegoating and dehumanisation of those fleeing war and persecution. Amendment 13 is on an entirely different issue, which hasn't been touched upon in the debate at all, nor indeed much in terms of the committee process. And it relates to the electronic travel authorisations, and in particular what's going to happen in terms of movement on the island of Ireland. These will be required for all non-Irish visitors who wish to enter the United Kingdom, including via the land border. While the government insists there'll be no routine immigration checks on the land border on the island of Ireland, these requirements will nevertheless create new bureaucracy and legal uncertainty for thousands of EU citizens and indeed other non-British and non-Irish residents south of the border that cross the border often on a daily basis, whether for family visitation, to work, to shop, for healthcare, education or for leisure. Indeed, there are some circumstances where the straightest route between 2 points actually crosses into Northern Ireland, sometimes several occasions. The government may say that they are committed to no new checks. However, people will be placed in legal uncertainty. If there's any interaction in particular with the UK state, they may well have major consequences that flow from that, and the potential repercussions could be as severe as people going into prison. So this is not practical on the island of Ireland, and I urge the government to reconsider what they're doing in terms of electronic travel authorisations. Thank you.
Thank you, Madam Deputy Speaker. The UK has a long-standing reputation as a beacon of human rights, but we need to recognise in this House that we have enormous discretion under international law and indeed under domestic law about how we exercise the responsibilities that we have. And many of the controversies around this bill are very much about the operations rather than the legislation themselves. Having sat as a member of the Joint Committee on Human Rights, as we took evidence on a number of these issues, it is clearly that there are matters of opinion about whether, for example, pushbacks, which are freely used by the European Union Frontex Border Agency in the Mediterranean, are for or against international law. In respect of scientific methods, I share the concerns that have been expressed. About the methods currently available to science, and I agree we would not wish to see those being used at present. But I agree that it should be open to the Home Office, should there be effective scientific methods developed, that they should be used for the purposes of dealing with age assessments. And I very much welcome the engagement which both the Bill Minister and others have had on these issues. I'd like to conclude, Madam Deputy Speaker, with 2 points. Firstly, to agree very strongly with the member for Dover on the point about needing a new COP26 of the issue of global migration. The world is changing. The challenges faced by asylum seekers with the numbers on the move mean we need to update the way in which we respond in partnership with our allies. And finally, I'd like to comment in respect of some of those international obligations which are often heavily criticised. The UK is very rarely referred to the European Court of Human Rights for any breach of our laws. We are rarely criticised, and indeed the findings of that court are not binding on the United Kingdom. I think we need to recognise that as a champion of human rights, we should be proud of the UK's record in this respect, and that we should renew our dedication to being a beacon of human rights for the future.
Claire Anderson.
Thank you, Madam Deputy Speaker. The asylum system certainly is broken, and this is not the bill to fix it. Firstly, on the Afghan resettlement scheme, where is it? How can we trust the government to deliver any of these programmes or anything to fix our asylum scheme if we cannot even come up after many months and we all receiving in this House, Madam Deputy Speaker, desperate emails from people in Afghanistan who are under threat? Secondly, I agree with Amendment 52 to waive the visa fees for Commonwealth veterans, for those who we asked to put their life on the line as members of our country, and yet we do not pay their pensions, we do not allow them to, and their families, to have the visas to say that they are citizens of this country. What more can we ask? But I really want to focus on family reunion. I have stood in the camps in Calais, and I have seen the people smugglers wandering around very, very maliciously around these camps. So I've seen those people smugglers that so much is made of, but it's not going to be through the measures of this bill that sorts them out. And one area that's really missing, Madam Deputy Speaker, is that of family reunion. One of those 27 men, women and children who tragically died in the Channel was Harem Pirot. He was fleeing for his life from Iraq to reach his brother Anwar, a Sheffield graduate living here in Cambridge. His brother had to go to Calais to identify his brother's body. In fact, we could cut so many of those smuggling routes if we were to allow family reunion. Yet there's nothing in this bill about family reunion. It was promised in after the EU withdrawal bill. As I sat here, I talked about it in my maiden speech. It was promised in the immigration bill. It was promised in the new plan for immigration that that there would be safe and legal routes for refugees, for people fleeing from their lives, who we can offer safe harbour for. There needs to be family reunion put back into this bill for it to work in the way it's intended. Thank you.
I'm going to call the Minister now, but I'm sure he's aware that there may be people who might like to intervene. Minister.
Thank you, Madam Deputy Speaker. And I want to start by thanking honourable members for their contributions to this debate and for the way in which most of those contributions have been expressed. These are difficult matters that we are dealing with, where members of this House have very strongly and deeply held convictions. As I have said, it is absolutely vital that we do everything in our power to break the business model of evil criminal gangs and reform the broken asylum system. I'm conscious of the time constraints, but I will address a number of amendments which have sparked a lot of today's debate. Let me start by addressing Amendment 150 from the member for Stone on the removal to safe third countries, on which the Right Honourable Member for Wokingham also raised earlier, and I know the Right Honourable Member for South Holland and the Deepings has also been following too. My right honourable friends are absolutely right in the sentiments they have expressed in tabling this amendment. I would like to thank my honourable friends for their full support on the policy intention, including on third country processing of asylum applications. There is a recognition that certain existing laws may prevent this government from achieving our aim to remove those with no legal basis to remain in the country. The legal barriers associated with the removal of failed asylum seekers and foreign national offenders are well known. That is why there is work underway across the government to look at the further legal barriers to removal. I would therefore like to reassure my honourable friends and colleagues more widely that there are no insurmountable domestic legal barriers to transferring eligible individuals overseas under an asylum processing arrangement. Schedule 3 of the Asylum and Immigration, Treatment of Claimants, etc. Act 2004 allows the Secretary of State to remove an individual with a pending asylum claim from the UK to a safe third state if a relevant certificate is issued. The Nationality and Borders Bill amends Section 77 of the Nationality, Immigration and Asylum Act 2002 to make it easier to remove someone to a safe third country without having to issue a certificate. Obviously, this bill complies fully with our international obligations, but the Home Secretary fully agrees with the sentiment that has been expressed through this amendment and how the challenges which frustrate the will of the British people in terms of our ability to remove people with no right to be in the UK. I can therefore confirm that the government has imminent plans to consult on substantial reform of the Human Rights Act, which will be announced imminently in Parliament. The Home Secretary also recognises my right honourable friend's concerns about aspects of ECHR and other international agreements. I can therefore confirm that we are committed to reviewing and resolving these issues with the urgency that the situation warrants. I will give way.
I'm listening very carefully to my honourable friend. He says that the government is committed to resolving these difficulties. Can he confirm that by resolving these difficulties, he means that the government will be legislating so to do?
Well, I'm very grateful to my right honourable friend, and I would refer him back to the point that I've already made in saying that we are intending to consult on substantial reform of the Human Rights Act, and we'll set out our plans imminently in that regard. Work is underway to develop a new phase of measures to ensure that the clauses in the bill are not undermined or that legal processes cannot be instrumentalised to circumvent the will of the British people. As we have said, the government has imminent plans to consult on reform to the Human Rights Act, which are under consideration as we speak. Likewise, work is underway in relation to resolving the question of retained EU law. I will give way.
It sounds like he's announcing something a bit more radical than perhaps we had anticipated in relation to the Human Rights Act. Can he confirm that the government is still committed to remaining a signatory, a full signatory to the European Convention on Human Rights?
I'm very grateful to the honourable lady, and the point that I would make is that the government will set out its intentions in due course. And I think it is right not to preempt. I think it's important to make sure that this House is kept updated as to that work, and we will be very clear in our intentions.
This is extremely encouraging news. The government is going to, at last, I have to say, consider the Blair legacy of the Human Rights Act, but to substantially reform it will require legislation. That much is implicit, is it not?
I'm very grateful again to my right honourable friend. As I say, ministers will come forward to this House with further details in due course. Work is underway in relation to resolving the question of retained EU law, led by Lord Frost, with input from the Attorney General and the Ministry of Justice. It is for these reasons that I would ask my honourable friends to withdraw their amendment. Next, I turn to new clauses 18 and 19, raised by my honourable friends for Christchurch and Kettering on illegal immigration offences. I hope that he and my honourable friend for Kettering and my other honourable friends who are supporting this amendment will recognise that this government, as part of our groundbreaking new plan for immigration, has sought robust changes to the law around illegal entry and similar offences through the very bill we are discussing today. This bill, which my honourable friends seek to amend, already addresses and indeed exceeds the changes proposed by new clause 18. I turn to new clauses 24 and 52, raised by the honourable members for Enfield Southgate, Halifax, Plymouth Moorview, Chingford and Woodford Green, Tonbridge and Malling, Bournemouth East and Barnsley Central. As these two amendments are both regarding settlement fees for non-UK members of our armed forces, I would like to debate these together. It is a fact that the government and our nation highly values the service of all members of the armed forces, including Commonwealth nationals and Gurkhas from Nepal. I will give way very happily.
Very grateful to the Minister, and I'm pleased to hear how valued our members of the service community are. This is a very good opportunity for the government to give way on the amendment tabled by myself and the honourable gallant member. Can the Minister give that assurances that the government will support new clause 52?
Well, thank you to him for making his case so eloquently in the way that this House is so used to. The House will be aware of the measures the Home Secretary and the Defence Secretary announced in the summer for Gurkhas from Nepal. They all have a long and distinguished history of service to the UK, both here and overseas. We also remain extremely grateful for the contribution made by former British Hong Kong service personnel. This is why the Ministry of Defence, together with the Home Office, ran a public consultation between the 26th of May and the 7th of July 2021 regarding a policy proposal to waive settlement fees for non-UK service personnel in Her Majesty's Armed Forces. While there is a response to that consultation coming out on this matter shortly, I recognise the strength of the honourable gentleman's feeling on this issue and those of the Royal British Legion. To that end, I'd like to thank him and colleagues for raising these matters. And I'd also like to invite both honourable members to meet with ministers along with the Legion next week to make sure that the concerns and realities of non-UK service personnel dealing with the immigration system are fully understood. I'm under no illusions about how strongly my honourable friend, the member for Plymouth Moor View, is in particular on this issue, along with colleagues across the House. I will give way to him.
Can I just make the point to the Minister that many ministers before him, many defence secretaries, many prime ministers before this one have said we feel and we value and we are adamant we are proud of our armed forces. But if you're a Fijian family in Plymouth, you're still splitting up your family because they haven't sorted out visa fees. And tonight is an opportunity to go beyond meetings and those words and actually waive visa fees, which everybody knows, irrespective of party, everybody knows is the right thing to do. And it is going to test the character of this government, whether or not they're going to do it.
Well, I'm very grateful to him, and I note the conviction with which he speaks about these matters. And I would reiterate the offer that we have made to meet next week to discuss these matters, and he will appreciate that the consultation has been ongoing and that we would expect to hear more on that in short order. I'd also like to pick up on the amendments tabled by the Joint Committee on Human Rights. And obviously the Right Honourable Lady, the member for Camberwell and Peckham, presented those to the House. And of course, I would also just like to say how sorry I was to hear that she will be standing down from the House at the next general election. But it is fair to say that these are important matters that the committee has raised. And I would respond in saying that we always act in accordance with our international obligations in relation to matters at sea, in terms of SOLAS and search and rescue operations. That has consistently been the position and will continue to be the position in the work that we do. I want to conclude by again thanking honourable members for their amendments and the lively debate we have had today. Following the tragic events in the Channel over the last few weeks, I know that all members take this debate with the seriousness and concern it deserves. But the only way we will solve these long-term problems is by delivering a long-term solution, and ultimately that is exactly what this bill delivers.
The question is that new clause 20 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 20 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. New clause 50 has been selected for separate decision. I call Bambos Charalambos to move new clause 50 formally.
Formally.
The question is that new clause 50 be added to the bill. As many as are of that opinion say aye. Aye. The contrary, no. No. Division, clear the lobby. Hang on. Question is that new. Yeah. Okay. The question is that new clause 50 be added to the bill. As many as are of that opinion say aye. The contrary no. No. Tell us for the ayes, Taiwo Owatemi and Mary Clinton. Tell us for the noes, Scott Mann and Craig McKinley. Lock the doors. Order. Order.
The ayes to the right, 235. The noes to the left, 314.
Thank you. The ayes to the right, 235. The noes to the left, 314. So the noes have it, the noes have it. Unlock. Thank you. Order, order. Under the order of the House of today, I must now put the questions necessary to bring to a conclusion proceedings on the new clauses and amendments in this group. New clause 52 has been selected for separate decision. I call Johnny Mercer to move new clause 52 formally. The question is that new clause 52 be added to the bill. As many as are of that opinion say aye. Aye. The contrary, no. No. Division, clear the lobby. Order. Order. The question is that new clause 52 be added to the bill. As many as are of that opinion say aye. Contrary, no. Tellers for the ayes, Tywell, Awatemi, and Mary Glindon. Tellers for the noes, Craig Whitaker and Scott Mann. Order.
The ayes to the right, 251. The noes to the left, 296.
The ayes to the right, 251. The noes to the left, 296. So the noes have it. The noes have it. Unlocked. Thank you. We now come to Government Amendments 19 to 53. I call the Minister to move Government Amendments 19 to 53 formally. The question is that Amendments 19 to 53 be made. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. Amendment 116 has been selected for separate decision. I call Stuart C. MacDonald to move Amendment 116 formally.
Move formally.
The question is that Amendment 116 be made to the bill. As many as of that opinion say aye. Aye. Of the contrary, no. No. Division, clear the lobby. Order. The question is that Amendment 116 be made to the bill. As many as are of that opinion say aye. Aye. Contrary, no. No. Tellers for the ayes, Alan Brown and Richard Thompson. Tellers for the noes, Scott Mann and Craig Whitaker. Order.
The ayes to the right, 233. The noes to the left, 318.
Everyone's chattering. The ayes to the right, 233. The noes to the left, 318. So the noes have it. The noes have it. Unlock. Thank you. We now come to government amendments 54 to 63 and government amendments 91 to 96. I call the Minister to move government amendments 54 to 63 and government amendments 91 to 96 formally.
Formally.
The question is that amendments 54 to 63 and 91 to 96 be made. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. Amendment 98 has been selected for separate decision. I call Harriet Harman to move Amendment 98 formally.
Move formally.
The question is that Amendment 98 be made to the bill. As many as are of that opinion say aye. Aye. The contrary, no. No. Division, clear the lobby. The question is that Amendment 98 be made to the bill. As many as are of that opinion say aye. Aye. Contrary, no. No. Tellers for the ayes, Mary Glindon and Taiwo Owatemi. Tellers for the noes, Craig Whitaker and Scott Mann. Lock the doors. Order. Order.
The ayes to the right, 235. The noes to the left, 313.
Thank you. The ayes to the right, 235. The noes to the left, 313. So the noes have it, the noes have it. Unlock. Further consideration what day?
Tomorrow.
Tomorrow. Thank you. We now come to motion number 4 on road traffic. Minister to move.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it, the ayes have it. We now come to motion number 5 on business of the House, 8th December. Minister to move.
I beg to move.
The question is, as on the order paper, as many as are of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it, the ayes have it. Petition, Sir Mike Penny.
Thank you very much indeed, Madam Deputy Speaker. And it's a pleasure to present the petition on behalf of 1,131 constituents in my constituency. The petition is self-explanatory, Madam Deputy Speaker, and so on their behalf, I shall read it out. The petition of the residents of the constituency of Hemel Hempstead declares that Bennett's End Road is a very busy and long road. Further, that over the last few years, there have been numerous incidents, I think there's a typo on here, it should be accidents, on the road as a result of local residents crossing for various reasons. Further, especially dangerous for local children trying to access local schools in the area. A further solution needs to be found, and that is possible to avoid these accidents going forward before a serious accident occurs. The petitioners therefore request the House of Commons urge the government to make Bennett's End Road safer by allocating funding to Hertfordshire County Council to install a pelican or puffin crossing in Bennett's End Road for the safety of my constituents and their children, and the petitioners remain, etc.
Petition, Bennett's End Road.
It's in the bag. I beg to move that this House do now adjourn.
Question is that this House do now adjourn. Dr. Andrew Morrison.
Thank you very much, Madam Deputy Speaker. Adjournment debates are great opportunities to raise issues raised with oneself by constituents, and it gives me much pleasure this evening to do precisely that. And I'm grateful to the Minister, particularly after his extremely busy day. I'm really sorry that I've kept him a little longer, but I'm delighted that he should be there to be the Minister responding to this debate this evening nevertheless. He will be aware of correspondence I have had on a specific constituency case with our Right Honourable friend, the Policing Minister. This debate draws from it and the experience related to me by my constituent and by others caught up in similar nightmares that are not of their making. I hope the debate is timely, given the imminent, very welcome consultation on upgrading the victim strategy by means of a victims bill. Many, particularly on this side of the House, take a very stern view of crime and criminality. Many of us have called for stiffer sentencing, particularly in relation to crime of a sexual nature. Because of the internet and the opportunities for indecent imaging it presents, those crimes are sadly rising, and they're rising exponentially. I am focusing very largely on the consequences of them this evening. Specifically, I'm buttonholing my good friend, the Minister, on the collateral. The families left behind to cope with the devastation that follows the arrest and conviction of a loved one for those crimes that attract the greatest public opprobrium. On that front, Deuteronomy chapter 24, verse 16 offers some chilly reassurance. The fathers shall not be put to death for the children, neither shall the children be put to death for the fathers. Every man shall be put to death for his own sins. Less dramatically, the sins of the fathers should not be pinned on the sons, daughters, spouses, or anyone else other than the perpetrator. Delighted to give way to the right of the honourable gentleman.
Thank the honourable gentleman for allowing me to intervene. And always I'm always attracted to the scripture text, and I thank the right honourable gentleman for doing that. Does the right honourable member not agree that those families who come to me with their windows broken and their messages spray painted on their homes, as often happens in Northern Ireland, due to a family member's actions is not appropriate, and the support should be offered to ensure that they do not end up having to pay, as the right honourable gentleman says, for the sins of the father, as can often be the case.
The honourable gentleman is absolutely right, and he speaks from a great deal of experience, and I think Deuteronomy is bang on the money. These are innocents and need to be dealt with as innocents by the statutory agencies, and that is the burden of what I have to say this evening. During the course of my research, I have been told about the 5 o'clock knock that hits you like a train, the stunning effect of the unheralded appearance of police on the doorstep, the trauma of seeing a loved one taken away, the brusque way in which family members are too often managed by the police as they sack the family home, searching for evidence, carrying off not just the suspect's possessions, but those of his or her partner as well. The knock after which nothing is ever the same again. Over 850 individuals are arrested each month for online offences involving indecency, and that's a 25 times increase in a decade. Each one of those carries in its wake a devastated family, a wall of misery, and the destruction of settled, ordinary lives. For most of these people, the worst brush with the authorities they have had up to that point has been the issuing of a speeding ticket. That makes them particularly susceptible to vicarious shaming and social isolation. So it's hardly surprising that nearly 70% of family members experiencing the knock in such circumstances have severe post-traumatic stress disorder. Unsurprising, given that they are often told to speak to no one for fear of bullying and vigilante activity. Unsurprising, since as part of the process, their mobile phones and computers are removed. Unsurprising, as the go-to resource of many traumatized people in the modern age, the internet is for them no longer a trusted entry point for help and support, but a dark, deeply hostile place. And the ascent of social media has meant there's nowhere to hide. Vigilantes, those self-appointed guardians of public safety, use a confected moral high ground to prey upon innocents who they deem guilty by their association with those convicted of stigmatizing offences. About the time I was first elected, I remember a group of so-called vigilantes confusing the terms paediatrician and paedophile, and seeing one of their neighbours described as the former, took it upon themselves to attack the home of the hapless specialist in child health. These bovinely stupid people are the antithesis of the upstanding public guardians they purport to be, encouraged in their misconception, I'm sorry to say, by elements of the tabloid press. They are despicable, they are the mob. And it's the mob, or fear of the mob, that drives the innocent bystanders of stigmatizing crime from their homes. And when these innocents are at their most vulnerable, most in need of the agencies of the state, there comes no help, no comfort, no support. Commenting on the knock, one of our more thoughtful police officers said, "We are acutely aware of the devastation we are leaving behind. But where is the attempt to mitigate that devastation?" Indeed, some within our statutory agencies and authorities behave as if the families of suspects are guilty too. That's just not good enough. So what's to be done? Well, the 2018 Victims Strategy and its Victims Code is a good start. In the code, there's a decent stab at a definition of victim. It defines victim as a person who has suffered harm, including physical, mental, or emotional harm, or economic loss, which was directly caused by a criminal offence. But in common usage, that definition probably doesn't include family members of people whose crimes have destroyed their lives. Indeed, the then Prime Minister appeared to confirm this in the foreword to the Victim Strategy, in which she said, "We must make it easier for people who have suffered a crime to cope, recover, and move on with rebuilding their lives." The simple addition of the word "from" or the phrase "as a result of" before a crime would have been helpful in embracing the desperate people that are the subject of this evening's debate. On the other hand, some would say that the definition of victim should indeed be ambiguous, since surely we can all tell a victim when we see one, can't we? A bit like an elephant. Well, I don't think we can. And unless the families of offenders are included explicitly within the definition of victim, nothing will change. There will be no recognition or help for them, and the agencies will continue too often to give them the cold shoulder. Other jurisdictions seem to have been more thoughtful. They offer a potential way forward that our Victims Bill consultation might gainfully reflect upon. The United States has a category of secondary victim with access, for example, to the Department of Justice Crime Victims Fund. Now, I'm not for one moment suggesting that to the Minister, but it gives an indication of how these victims are regarded by the US. Canada has 4 categories of victim: direct, indirect, secondary, and tertiary. but all have the dignity of being recognised by the Canadian system as victims, as does the US system using its definition. Why is all this so important? Well, firstly, the Victims Code sets the mood music. Inclusion of the people I'm talking about will establish them as victims of crime and unpick the notion that they have, by some curious osmosis, contributed to it. More tangibly, the Victims Code offers things to those identified as victims: needs assessments, appropriate signposting, being treated respectfully, sympathetically, and in a dignified and sensitive way. Of course, I will.
Very pleased the members got this debate and hope you got my email earlier. Over the summer, I visited the excellent project Children Heard and Seen, which is campaigning for prisoners' families. And I met a woman who, her and her children were basically driven from their home because the husband had been arrested and imprisoned for an offence similar to the one that he's talking about. Driven from their home, had to change their names, and she had to stop her postgraduate studies because her computer had been taken away. Just the repercussions went on and on and on. One of the things that I've been calling for is a statutory mechanism so that children caught up in this situation are recognised, identified by the system, and they get the help that they need straight away. Does he agree with me?
With the honourable lady, I'm very, very pleased that she has raised her constituency case, because her constituents are not alone, with 850 arrests being made every month, which is just staggering. So that's one for each of our constituency, and some, and a bit, every single month. So we all have constituents in this awful situation, and the situation she has just described is exactly the same as has been described to me. They are under the radar, and I hope in some small way this debate this evening will make their plight much clearer, and perhaps at this critical juncture where we are considering the Victims' Bill and the consultation leading up to it, they might be included, and that will be my principal ask of the Minister this evening. And indeed, in September, the Prime Minister brought some good news on this front. He said, "We are committed to legislation for victims in the Queen's speech and will be consulting on a Victims' Bill later this year." Given that we're fast running out of year, can the Minister outline the timetable for the consultation? Will he include in it an improved, more embracing definition of victim, perhaps one that is more nuanced, as other countries have done? Will he task officials with drafting improved guidance to statutory agencies, including but not confined to the police, on the handling of families of those arrested on suspicion of serious, particularly stigmatising crime? Will he look at improving support to the few lifeline charities that operate in this space, including the Lucy Faithfull Foundation Stop It Now and Act Fast? Will he ensure that the consultation includes wording that explicitly recognises the pain and suffering experienced by the massive number of wholly innocent family members of those accused and convicted of stigmatising crime? At a time when their lives are falling apart and they are facing, often alone, financial, domestic, occupational and social ruin, they deserve to be treated as victims with respect, kindness and dignity. We can do so much better, Madam Deputy Speaker. The Victims' Bill gives us an opportunity to do so.
Mr. Tom Purslow.
Thank you, Madam Deputy Speaker, and I would like to start by thanking my right honourable friend, the member for South West Wiltshire, for securing this important debate this evening and for doing the cause that he is seeking to advance real justice in terms of the way that he has presented his case and the arguments that he has marshalled here in the chamber tonight. The case that he has highlighted demonstrates the sometimes overlooked impact that one person's criminal behaviour can have on their family and friends. And I have to say that it is difficult, I think, not to be troubled by the circumstances that he has described and the impact that that has on families. And in the same way that the Honourable Lady set out the case of her constituents as well. Many families, not just those that my right honourable friend has alluded to, feel that they're being unfairly punished in the eyes of others for someone else's actions. The circumstances he describes are horrendous and unthinkable. He put it that it is a wall of misery. And I think that that is rather an apt description. As my right honourable friend set out, the consequences of these crimes can be devastating and are felt long after the knock on the door that he describes. And I think the empathy that I feel, and that I'm sure all members of this House feel, to all of those who've been affected in this way in our country is very difficult to put into words. And I think the circumstances where that knock on the door comes are also very, very difficult to comprehend. Not least because of the betrayal of trust that those family members must feel about what has happened, and just the magnitude and the enormity of the trauma and the circumstances that they are presented with is unthinkable. In April of this year, we updated the Victims Code, providing victims with a clear set of entitlements and setting out the levels of service that a victim of crime can expect from the criminal justice system. For the purposes of the code, a victim is someone who has suffered harm, including physical, mental, or emotional harm, which was directly caused by a criminal offence. A person who has suffered harm as a direct result of witnessing a crime is also a victim for the purposes of the code and is able to access services that support victims. While I have great sympathy for families in the circumstances my right honourable friend has described, I recognise that this will not automatically apply to families of offenders. However, support is available for those who have been directly harmed. There are, of course, certain circumstances in which a family member is a direct victim or witness to crime perpetrated by their loved ones, and it is right that we offer them support to cope and, as far as possible, recover from these crimes. For example, our National Homicide Service works tirelessly to support those bereaved by domestic homicide. We know that being impacted by crime can have a lasting impact, especially for children and young people, which is why in July of this year, we worked with the Homicide Service to launch dedicated casework support for children and young people impacted by these crimes. The crimes my right honourable friend speaks of are some of the most abhorrent and are often perpetrated in the home and by those we should feel safe in the company of. And where families face the sort of damaging attention on social media following an arrest or conviction that my right honourable friend has described, this should be treated with the utmost seriousness. Therefore, we are taking steps in the Online Safety Bill to place new duties on companies to keep their users safe online. And I think I would also go on to say that I expect, this government expects, and I think this House expects, and we've seen this reflected in the debates that we have witnessed in recent weeks, that the tech companies must take responsibility for these matters and take robust action when inappropriate content is hosted on their sites. I think that that is a reasonable expectation and one that time and time again this House has echoed. And so I, for one, certainly welcome the Online Safety Bill coming in due course. We're determined to improve support for victims of crime so that they can recover and confidently seek justice through the criminal justice system. We continue to invest significant funding in victim and witness support services, given the increase in demand and the impact of the pandemic. This year, we will be spending £300 million across government, with the Ministry of Justice providing just over £150 million. This funding will go towards a range of support services, including the National Witness Service, rape support centres and local organisations commissioned by police and crime commissioners. And I can confirm that we will be consulting imminently on a victims' law so that we can make tangible improvements for victims across the criminal justice system. I look forward to meeting my right honourable friend, the member for South West Wiltshire, to discuss the contents of the consultation as soon as possible after publication. As I said earlier in this debate, I have a huge amount of empathy for innocent families who, through no fault of their own, end up in these circumstances. And I think as members of this House, we can all think of, when we debate these matters, families in our own constituencies who've been caught up in the sort of trauma that we are discussing this evening. And I have to say, I'm truly shocked to hear about the levels of PTSD linked to these cases. But inevitably, it isn't surprising that there is that level of PTSD. While these families may not fall within the definition of the Victims Code, this does not exclude them from accessing the support they need to recover from the harm caused. Her Majesty's Prison and Probation Service funds the National Prisoners Families Helpline, which provides free and confidential support for those with a family member at all stages of their contact with the criminal justice system. Their highly trained and skilled staff provide practical information, along with emotional support for those who simply need reassurance or guidance. They are also able to point families or their children to sources of additional support should they need it. There are several charities that also provide support for families affected by the actions of a family member, including PACT, NEPACS, the Lucy Faithful Foundation, and Children Heard and Seen. The government is committed to ensuring everyone that requires mental health support, including offenders' family members, have access to timely mental health treatment based on clinical need. As part of the government's commitment to Build Back Better, we published our Mental Health Recovery Action Plan in March 2021, backed by an additional 500 million for this financial year to ensure we have the right support in place. The plan aims to respond to the impact of the pandemic on the mental health of the public, specifically targeting groups which have been most affected, including those with severe mental illness, young people, and frontline staff. While in some cases further contact between a family and prisoner might not be appropriate, I think it is right that we reflect that in the majority of instances, there are significant benefits to both the offender and their family of maintaining the family relationship to help tackling reoffending when the prisoner is released from prison. The impact of imprisonment on a family member can be significant. For example, for a child of an incarcerated parent, there can be social stigma, loneliness and isolation, along with feelings of resentment about being abandoned. So while offenders are in custody, we have an opportunity to support them to appreciate the impact that their offending behaviour has, not only on themselves, but their family and especially on their children. We believe that regular quality engagement between a prisoner and their children is essential to mitigate the potential harms the child of an incarcerated parent might experience. While the focus of the MOJ's work is ostensibly upon supporting the offender and helping their rehabilitation, there are other initiatives across government which can support those family members who are having to simply carry on. The Supporting Families programme continues to drive early help and the better coordination of services for families with multiple and complex needs, including those involved with or at risk of crime and antisocial behaviour. The government is committed to ensure that the programme delivers, which is why the Chancellor recently announced an expansion of the Supporting Families programme, taking total planned investment across the next 3 years to 695 million. This will enable local authorities and their partners to provide help earlier and secure better outcomes for up to 300,000 families across all aspects of their lives. As well as supporting the recovery of those who have been affected by crime, the programme encourages early intervention to prevent families from entering the criminal justice system in the first place. To conclude, I hope that I've demonstrated the importance that we place on supporting children and families of offenders, and that in the time available, I've been able to provide clear examples of how we are working to properly support those leaving prison and their families. But I would just say that I recognise that my right honourable friend has raised a number of very valid points. And I think that there are areas there that government as a whole should, of course, reflect upon, and obviously reflect on whether the package of measures and the help that is in place remains appropriate. We must always keep these matters under constant review. I'm grateful for the way in which he has brought this adjournment debate this evening and for the important matters that he has raised. I look forward to meeting with him, and I'm very grateful for his contribution tonight.
The question is that this House do now adjourn. As many as are of that opinion say aye. The ayes have it. Order, order.